court officer. This got what tax? This one is appeal. Yeah, we are 2024. Next week. No. See, yes. Put on your mic.
2022 writ appeal matter, my lordship. The single judge has directed the bank to consider the one-time settlement offer once again, and the bank has challenged the single judge order. I am for the respondent, my lordship.
Bank has challenged.
Bank has challenged the single judge order.
For the borrower.
I am for the borrower, my lordship. First, the bank has offered me one-time settlement.
Correct.
And I have complied all the conditions. ಈಗ ಅವರು ಅದನ್ನ ಒನ್ ಟೈಮ್ ಸೆಟಲ್ಮೆಂಟ್ ಅದನ್ನ ವಾಪಸ್ ತಗೊಂಡ್ರು. ಸಿಂಗಲ್ ಜಡ್ಜ್ ಡೈರೆಕ್ಷನ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಬ್ಯಾಂಕಿಗೆ. ಸೊ ಆ ಬ್ಯಾಂಕ್ ಚಾಲೆಂಜ್ ಮಾಡಿದೆ ಅದನ್ನ.
But it is covered by the judgment of Justice Nagaratna ಅಲ್ವಾ? In OTS matters, even if there is any fault, writ court shall not entertain ಅಂತಾನೆ hold.
Here the
anyway ನೋಡ. Yes, sorry.
One matter, day after tomorrow.
ಏನು ಅರ್ಜೆಂಟ್?
Demolition ಇದೆ.
Demolition.
Demolition.
ನಾಳೆ ಡೆಮಾಲಿಷನ್ ಆದ್ರೂ ನಡೀತಾನೋ?
ಅಂದ್ರೆ ಕಂಪ್ಲೈ ಮಾಡಕ್ಕೆ ಟೈಮ್
ನಾಳೆ ಹಾಕ್ರಿ, ನಾಳೆ ಕಳಿಸಿ, ನಾಳೆ ತರಿಸಿ. As ಹಾಕ್ಬೇಕು, ಕಂಪ್ಲೈನ್ಸ್ ಇರ್ಲಿ ಬಿಡ್ಲಿ. ಡೆಮಾಲಿಷನ್, ಬಿಲ್ಡಿಂಗ್ ಡೆಮಾಲಿಷನ್ ಆದ್ಮೇಲೆ ವೇರ್ ಇಸ್ ದಿ ಕ್ವೆಶ್ಚನ್ ಆಫ್ ಕಂಪ್ಲೈನ್ಸ್? Yes.
My lords, appellants are the elected directors of cooperative society called as Totgar's Cooperative Society. My lord, the election was challenged by two persons by filing election dispute.
Urgency ಹೇಳ್ಬೇಕು. Merits ಮೇಲೆ argue ಮಾಡಬಾರ್ದು. Urgency argue
My lord, election is ordered to be set aside. Our application seeking stay of the order of the DRCS has been rejected by the KAT.
Next.
Tomorrow, my lord.
Next week.
My lord, since the election is set aside, ma'am.
Nothing will happen. Many elections have taken place in this country. Every election has created problem to us.
Your lordship, on the last date, your lordship had directed the mother to allow the father, whom I am representing, to allow for visiting rights. The mother is not allowing. The case was supposed to be posted on 27/8. It was not posted. It was not posted.
The other one date hackle next week.
My lords, one matter, my lords. Appointment of minor's guardian as a mother, my lords.
Minor's guardian. Mother is appointed.
Not appointed, my lords. Seeking appointment.
Good. Next week.
On date, could madam.
Some date it will come. Please. Yes, madam.
Sir, actually ಗೋಕಾಕ್ದಲ್ಲಿ ನಂದು ಎಕ್ಸ್ಪರ್ಟಿ ಆಗಿತ್ರಿ ಸರ್ 2023 ನಲ್ಲಿ.
ಅಲ್ಲಿ ಆನ್ ಮಾಡ್ಕೊಳ್ಳಿಕ್ಕೆ ಹೇಳಿ.
ಸರ್ 2023 ನಲ್ಲಿ ಎಕ್ಸ್ಪರ್ಟಿ ಆಗಿತ್ತು. ಸೊ ಅದನ್ನ ನಾನು 2024 ನಲ್ಲಿ ನಾನು ಫೈಲ್ ಮಾಡಿದ್ದೆ ರೀ, ಚಾಲೆಂಜ್ ಮಾಡಿ ಹೈಕೋರ್ಟ್ಗೆ. ಬಟ್ ನಮ್ ಲಾಯರ್ ಯಾವುದೇ ರೀತಿ ನಂಗೆ ಸ್ಪಂದಿಸ್ತಾ ಇಲ್ಲ ರೀ, ರೆಸ್ಪಾಂಡ್ ಮಾಡ್ತಾ ಇಲ್ಲ. ಅವರಿಗೆ ನೋಟಿಸ್ ಸಹ ಕಳಿಸಿದ್ದಾರೆ, ಅದನ್ನ ರಿಜೆಕ್ಟ್ ಮಾಡಿದ್ದಾರೆ ಸರ್. ನನಗೆ ಪ್ಲೀಸ್ ಬೇರೆ ಲಾಯರ್ನ ಅಪಾಯಿಂಟ್ ಮಾಡ್ಕೊಳಕ್ಕೆ ನಂಗೆ ಪರ್ಮಿಷನ್ ಕೊಡ್ಬೇಕ್ರಿ. ಮತ್ತೆ ಪ್ಲೀಸ್ ಮ್ಯಾಟರ್ನ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ನನಗೆ ಅಲೋ ಮಾಡ್ಲಿಕ್ಕೆ ನಾನು
ವೀಕ್ ಆಫ್ಟರ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ತುಂಬಾ ಆಗಿದೆ.
ಅಟ್ ಲೀಸ್ಟ್ ನನಗೆ ಒಂದು ಅಪ್ಲಿಕೇಶನ್ ನಾನು ಇದು ಮಾಡ್ತೀನಿ ಸರ್.
Yes.
Lord, item number 39.
My lord.
13.
Yes,
39, my lord.
amicable settlement.
Settlement ಆಗಿದೆಯಾ?
ಆಗ್ಬೇಕಾಗಿದೆ ಸರ್, ನೋಡಿ ಸರ್ ಪ್ಲೀಸ್. ನೀವು ತಮ್ಮ ಹತ್ರ ಬಂದೈತಿ ಹಿಂದಕ್ಕೆ, ಅದು ಇನ್ನೂ ಪಾರ್ಟಿ ಕರ್ಕೊಂಡ್ ಬರ್ತೀನಿ.
ನೀವ್ಯಾರು?
ನಾವು ಲ್ಯಾಂಡ್ ಓನರ್.
ಲ್ಯಾಂಡ್ ಓನರ್. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಯಾವ್ದೋ ಒಂದು ಹಾಕಿ ಒಂದು ಡೇಟ್ ತೊಗೊಳ್ಳಿ, ಅವ್ರಿಗೆ ಡೇಟ್ ಕೊಡಿ. ಪಾರ್ಟಿ ಇನ್ ಪರ್ಸನ್ ಅವ್ರಿಗೆ ಗೊತ್ತಾಗಲ್ಲ.
39, my lord.
Serial number 40, my lord. Serial number 40, my lord. The connected matters are posted on 24th, my lord.
24th?
Please, my lord.
Call on 24th.
Please.
My lords, next. Serial number 32, my lords. I am for the appellant, my lords.
32.
Please, my lords. Senior has been admitted in the hospital, my lords.
Admitted to hospital?
Please, my lords.
ಯಾವ hospital? Who is your senior? Which hospital?
Ramchandra Mali, my lords. Ramchandra Mali. He has been
in fact admitted to hospital. Yesterday also he did not come. Why? What happened?
Dengue, my lords.
Oh, call this after.
My lord, already they have taken adjournment.
The virus and bacteria do not obey our orders.
Short date may kindly be. Since
men are also not obeying.
Yes.
Let alone the biotics.
Short date may
Item number.
Call after 2 weeks.
Please.
Item number 39, my lord.
29.
39, my lord. 39. My lord, I was supposed to be physically present in the court, my lord. There was a small error. The ticket that was booked for September 10th came to be booked for October 10th, my lord.
Then again you have to come that day. We'll post this matter to that day only.
No, my lord, that is a holiday, no, my lord, court holiday at that point of time. We'll have it on 23rd, my lord, 23rd,
23rd, Maduda?
Monday.
All right, take a
I'll be there,
chance.
my lord. I'll be there, my lord.
Don't ask us for return ticket.
No, my lord.
Ticket is your concern.
Yes,
Yes.
my lord. Thank you, my lord. Thank
Number
you.
36, my lord. 36, maybe referred back to mediation since it is not yet
36.
concluded.
Sivana,
Yes, my lord.
both the sides consensually submit that matter be referred to mediation for amicable settlement. First, there are elements of possibility of such settlement. First, therefore, referred.
Please.
My lordship, serial number 25, my lord.
Huh?
25,
25.
yes, my lord.
Another.
The parties have obtained NOC from us, my lordship.
They have taken NOC from you.
Yes, my lordship.
Huh.
And the file also had been taken, my lordship.
They have taken the file also.
Yes,
All right. You want time?
yes. I'll file the memo for this one, my lordship.
Memo. But how you should not have returned the file without permission of the court.
My lordship.
Anyway, call this off matter after 2 weeks at the request of counsel appearing for. Yes. Udamma. Kutko, chalko.
Bengaluru bench alva first.
ಮಧ್ಯಾಹ್ನ 2:30 night ಗಂಟೆ.
ಚೇಂಜ್ ಆಗಿದೆ.
ಏನಪ್ಪ ಇದು?
ಏನ್ ಜೋಶಿ ಸರ್?
I am for respondent. ಅದು last time.
ಮತ್ತೆ ಅವ್ರು ಬೇಕಲ್ಲ ಅಪೀಲ್ ಹೆಂಗ್ ಡಿಸೈಡ್ ಮಾಡೋದು?
ಕ್ವಾಂಟಮ್ ಇದೆ ಅಷ್ಟೇ.
ಕ್ವಾಂಟಮ್ ಇದೆ. ಲಾಸ್ಟ್ ಟೈಮ್ ಲೋಕ್ ಅದಾಲತ್ ಹೋಯ್ತು. ನಾವು ಪ್ರಪೋಸಲ್ ಕಳಿಸಿದ್ರೆ ಯಾಕೋ ರೆಸ್ಪಾಂಡ್ ಮಾಡ್ಲಿಲ್ಲ ಬ್ಯಾಂಕ್.
ಕಟಗರಿ ಬರ್ತಾರಲ್ಲ. ಮುಕ್ಡಿಸ್ದೆ. ಪಾಸ್ ಔಟ್ ಮಾಡಿ. ಏನಂತ ಕೇಳಿ ಹೇಳಿ ಎಷ್ಟು ಅಮೌಂಟ್ ಏನ್ ಡಿಫರೆನ್ಸ್ ಇದೆ?
ಸ್ಮಾಲ್ ನ್ಯಾರೋ ಕಂಪಸ್ ನಾಗಿದೆ ಮ್ಯಾಟರ್.
ಪ್ಲೀಸ್. ಯಾವ್ದು?
ಪಾಸ್ ಔಟ್ ಮಾಡೋಣ.
ಎನ್ಹಾನ್ಸ್ಮೆಂಟ್ ಅದ ಅದರಲ್ಲಿ. ಎನ್ಹಾನ್ಸ್ಮೆಂಟ್ ಮಾಡಬಹುದು.
ಅದೇ ಯಾವ ಇದ್ರಲ್ಲಿ ಅಂತ ಅವ್ರು ಹೇಳಿಲ್ಲಲ್ಲ. ಏನ್ ಗ್ರೌಂಡ್ಸ್ ಅಲ್ಲಿ ಹೇಳಿದಾರ?
ಅವರು ಡಿಸಬಿಲಿಟೀಸ್ ಆಸ್ಕಿಂಗ್ ಮೋರ್ 38% 20% ತಗೊಂಡಿದ್ದಾರೆ ಆಲ್ರೆಡಿ. ಅದಕ್ಕೆ
ಒಂದೆರಡು ನಿಮಿಷ ಬರ್ಲಿ ಅವ್ರು.
ಕರ್ಕೊಂಬನ್ನಿ.
ಅದೇ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಇಟ್ ಮೇ ಬಿ
ಒಂದ್ಸತಿ ಲಿಸ್ಟ್ ಆಗಿದೆಯಲ್ಲ 5 ನಿಮಿಷದಲ್ಲಿ ನೀವು ಹೇಳಿದ್ರೆ ಬರ್ಕೊಂಡ್ಬಿಡ್ತೀವಿ.
There will be a widow family ಇರ್ತದೆ, ಹಂಗೆಲ್ಲ ಟೈಮ್ ಕೇಳಬಾರ್ದು ಅಂತ MEC ಮ್ಯಾಟರ್ ಅಲ್ಲಿ. Yes.
Claimants appeal for enhancement, and it is case of death matters, bachelor death matters. Tribunal has taken monthly income of the deceased 6,000 instead of 8,000. 2015 matters.
Chart value ಏನಿದೆ?
Chart prakar 8,000 DDBs. That is only.
Being a bachelor, 50% has to be deducted. Reassess ಮಾಡಿ.
Pranay Sethi.
Yes.
ಬೇರೆ ಎಲ್ಲ ಕರೆಕ್ಟ್ ಇದೆ.
ಅಲ್ಲ
ಅವರು 50% ಮಾಡ್ಲಿಲ್ವಾ ಟ್ರೈಬ್ಯುನಲ್?
ಇಲ್ಲ, one third ಮಾಡ್ಯಾರ.
50% ಅನ್ಮ್ಯಾರಿಡ್ ಅನ್ನು.
Unmarried.
ಮಲ್ಟಿಪ್ಲೈಯರ್ ಇಸ್ ಕರೆಕ್ಟ್?
ಮಲ್ಟಿಪ್ಲೈಯರ್ ಕರೆಕ್ಟ್ ಐತೆ ಸರ್.
18 correct.
ಫ್ಯೂಚರ್ ಪ್ರಾಸ್ಪೆಕ್ಟಸ್ ಆಡ್ 40%.
ಕರೆಕ್ಟ್ ಆಗಿದೆ.
40% ಫ್ಯೂಚರ್ ಪ್ರಾಸ್ಪೆಕ್ಟಸ್ ಆಡ್
ಮಾಡಿದಾರಲ್ಲ?
ಅವ್ರು ಮಾಡಿದಾರೆ.
ಮಾಡಿದ್ದಾರೆ. Page number 20 matters.
Yes. Disposed.
Please.
ಅದು ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಮೆಮೋ ಆಫ್ ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಕೊಡಿ.
Please.
Refer to local adalat. Refer to local adalat.
Refer to local adalat.
I'll submit in counter. Second set of copy of submit.
The joint request matter is referred to the local adalat. Then counsel for the appellant submits that he has filed a second set of the appeal memo.
First matter, my lord, my senior name is to be deleted, my lord, to show the name of SK Kaikmat. First matter, my lord.
First matter, registry is directed to reflect the name of Sri SK Kaikmat representing the respondent number 2 by deleting the name of Sri Nagaraj Sri Kolluri.
Please.
Cause list. Local adalat joint request. Please.
Yes, Mr. Kamte.
The sugar factory, my lord.
matter, my lord. But I think my learned friend, my lord, had to take instruction with regard to that, my lord. Lord, I made a submission, my lord, that is, my lord, the 13 members are there, my lord. Each will get, the management, my lord, lord has agreed for, my lord.
Agreed for?
My lord, in between, my lord, 1 or my lord, 1.5.
How?
Last time. Because
That
the
will be
lordship seen, my
a
lord.
frugal,
Yes.
a frugal value. You know the rupee value, it has slided down. Years have passed now. Suppose if we put the clock back, the amount of agony that your client would be put to, just measure it. So go for some, therefore, always we have said.
I understand. Lord, your lordship seen, my lord, that the other partner also, Lord, where, my lord, we have paid, my lord, the compensation plus, my lord, the retirement, my lord, benefits, and all these things were there, my lord, they have
To
accepted.
improve your offer to us, don't worry about them. We can make the order. If they agree very well, otherwise we'll make some order. Improve your offer.
Please.
Is your client behind?
No.
Yes, have whisper from.
On behalf of, my lord,
Have whisper about. ಕೊಡಿ.
Lord, ಇಲ್ಲ. Lord, as I said.
ಕಾಲೇಜ್ನಲ್ಲಿ ಚೀಟಿ ಕೆಲಸ ಮಾಡ್ತಿದ್ವಿ ನಾವು. ಇಲ್ಲಿ ಮಾಡೋ
ಇಲ್ಲ, open ಆಗಿ ನಾನು ಹೇಳ್ಬೋದು. Lord, as I said, Lord, nothing is there, Lord, actually. As I said earlier, Lord.
ಬಿಡಿ ಅರ್ಲಿಯರ್ ಮೊನ್ನೆ ಹೋದ ವಾರದ್ದೆಲ್ಲ so much water has flowed under the bridges now since last week. Tell something new today.
Please, Lord,
to entertain the judges.
I'm grateful, Lord.
Caliber 1.5 or caliber 2 because of the age. To some less service, length of service. Short length of service.
ಅವ್ರಿಗೆ ಹೇಳಿ ನಿಮ್ ಕ್ಲೈಂಟ್ಗೆ ಪೂರ ಕಳ್ಕೊಳ್ಳೋಕ್ಕಾರೆ ಅರ್ಧ ಉಳಿಸ್ಕೊಂಡಂಥವನೇ ಪಂಡಿತ ಅಂತ ಹೇಳ್ತದೆ ಸುಭಾಷಿತ. ವಿನಾಶಕಾಲೇ ಸಮುತ್ಪನ್ನೆ ಅರ್ಧಂ ತ್ಯಜಿತ ಪಂಡಿತ. ತಲಿ ಪೂರ ಕಳ್ಕೊಳ್ಳೋ ಬದ್ಲಿ ಅರ್ಧ ಯಾರು ಉಳಿಸ್ಕೊತಾನ ಅವರೇ ಜಾಣ. ಇದು ನಿಮ್ ಕ್ಲೈಂಟಿಗೆ.
Please. Last from 2 decades, my lord, they are fighting in the litigation.
2 decades you have done. We know you did not disclose the receipt of money in your claim petition. You simply dropped the pleadings in the post box of the court and wanted an order. At least some constitutional motto
short service
ಅಲ್ವಾ? ಸ್ವಲ್ಪ ಸತ್ಯವಾಗಿ ನಡ್ಕೋಬೇಕು, ಹೇಳ್ಬೇಕು. ನಾವು ದುಡ್ಡು ಇಸ್ಕೊಂಡಿವಿ,
ಪ್ಲೀಸ್,
ಆದ್ರೆ ನಾವು ಇಸ್ಕೊಂಡು ನಾವು ಫೈಟ್ ಮಾಡ್ತೇವಿ. ದುಡ್ಡು ಇಸ್ಕೊಂಡಿವಿ, ಜೋಬಿಗೆ ಇಟ್ಕೋತೀವಿ, ಅದನ್ನ ಹೇಳಲ್ಲ ನಿಮ್ಗೆ ಅಂತ ಹೇಳಿದ್ರೆ ನಾವು ಹೆಂಗೆ ಜಸ್ಟಿಸ್ ಕೊಡೋದು?
In the form of compensation, they have not given that, your lordship. In the form of 15 days for per year.
ಕೋರ್ಟದ ಎಂಬ್ಲೆಮ್ ಏನಿದೆ ನೋಡಿ,
ಪ್ಲೀಸ್.
ಏನಿದೆ?
ಸತ್ಯಮೇವ ಜಯತೆ.
ಅಲ್ವಾ? ಏನ್ ಹಂಗಂದ್ರೆ?
Truth will always prevail. Truth will always prevail.
Always prevail. Truth ಅಂದ್ರೆ ಏನು? ನಿಜ ನುಡಿಯೋದು.
ಪ್ಲೀಸ್
ಅಲ್ವಾ?
ಪ್ಲೀಸ್.
ಸತ್ಯಂ ವದ ಧರ್ಮಂ ಚರ ಹೆಂಗಿದೆ ನಮ್ದು ಉಪನಿಷತ್ತಲ್ಲ. ಹಂಗಾಗಿ ಇದನ್ನೆಲ್ಲ ಹಾಕೊಂಡು ಇದೇನು ಚಂದಕ್ಕೆ ಹಾಕೊಂಡಾರ, ಗೋಡೆ ಚಂದ ಕಾಣ್ಲಿ ಅನ್ಕೊಂಡು. ದೇ ಶುಡ್ ಬಿ ಟ್ರೂತ್ಫುಲ್. ಅವರು ಸತ್ಯವಂತರಾಗಿರ್ಬೇಕು. ಇಲ್ಲಿ ನಿಮಗೆ ಜಸ್ಟಿಸ್ ಬೇಕು ಅಂದ್ರೆ ಸತ್ಯವಂತಾಗಿ ನಡ್ಕೋಬೇಕು ಅನ್ನೋದಕ್ಕೆ ಅದನ್ನ ಹಾಕಿದ್ದು ಅಲ್ವಾ? ಸತ್ಯಂ ಏವ ಜಯತೆ. ಸತ್ಯ ಒಂದೇ ಗೆಲ್ತದೆ, ನಾನೃತಂ, ಸುಳ್ಳಲ್ಲ. That is, we have taken it from Upanishad.
But they have taken through post, your lordship.
But answer your question. Why did you not disclose? Why they did not disclose that they have received the check from the management? All they were appointed in 80, 81, 82. Please have seen it, except 183. Why they did not disclose to the court? Swami, ಇಷ್ಟು ದುಡ್ಡು ಕೊಟ್ಟಾರವರು, ಆದ್ರೆ ಇದು ಸರಿ ಇಲ್ಲ, ನಮಗೆ ತೆಗೆದು ಹಾಕಿದ್ದು ಆ ದುಡ್ಡನ್ನು ನಾವು ಬದುಕಬೇಕು ಅನ್ನೋದಕ್ಕೆ ಇಟ್ಕೊಂಡಿದ್ದೇವೆ. ಹಂಗಾಗಿ ನಾವು ಲಿಟಿಗೇಟ್ ಮಾಡ್ತಾ ಇದ್ದೀವಿ. ಒಂದು ಪ್ಯಾರಾಗ್ರಾಫ್ ಇಲ್ಲ, ಒಂದು ಸೆಂಟೆನ್ಸ್ ಇಲ್ಲ ದುಡ್ಡು ಇಸ್ಕೊಂಡ ಬಗ್ಗೆ. ಅಂದ್ರೆ ಬರಂಗ್ ಬರ್ಲಿ, ಒಳ್ಕೊಳ್ಳಿ ಎತ್ಲಾಗೆ ಅಂತ ಎನಿವೆ keep this in your mind. That's the weakest point, the actually seal of your party.
Please. Yes. Lord, I have permission to Lord, give it to me, Lord. Lord, I have made it two slab, my Lord. One is, Lord, who is having long service and short
service.
So subject to what?
ಯಾವ ಇಯರ್ ನಲ್ಲಿ ಅವ್ರನ್ನ ನೀವು ಡಿಸ್ಚಾರ್ಜ್ ರಿಟ್ರೆಂಚ್ಮೆಂಟ್ ಏನೋ ಮಾಡಿದ್ರಲ್ಲ ಯಾವಾಗ?
2002 ದಲ್ಲಿ Lord. They are discharged from service, Lord, in 2002. And at that time, Lord, they received, Lord, all the Lord.
No improvement. Perhaps in your calendar, days have not moved at all.
Lord, I'm sorry, Lord.
Sorry, my brother has written something which is worthwhile. Consider.
Again,
but much more money will be spent on litigation if something happens here.
Subject to they approving, they accepting this.
ಏನು 13 ಜನ ಇದ್ದಾರೆ. Otherwise, the case, the amount which you will incur for fighting the legal battle, apart from the uncertainty, apparent uncertainties.
Lord, I think Lord may seek Lord Passover, Lord, so that we can do it. Lord, I understand.
No Passover. ಕೊಡಿ ಅದು ಕೇಳೋದು ಕೊಡಿ.
We have done the short service and long. On that basis,
ರಿಮೈನಿಂಗ್ ಸರ್ವಿಸ್ ಫಾರ್ ರಿಟೈರ್ಮೆಂಟ್ ಅದನ್ನ ಕಣ್ಮುಂದೆ ಇಟ್ಕೊಂಡು ಮಾಡ್ತಾ ಇರೋದು.
For remaining service. For remaining services. Some of them have retired, Your Lordship, and some of them no more, Your Lordship.
ಅವ್ರಿಗೆ ಇದೆ, ರಿಟೈರ್ಡ್ ಆದವರಿಗೆ ಹೆಚ್ಚು ಅಗತ್ಯ ಇದೆ. ನೋಡಿ, ಸುಮ್ಮನೆ ವರ್ಷಗಟ್ಟಲೆ ಕೇಸ್ ನಡೆಸ್ಕೋತ ಹೋಗೋದು ಆಯ್ತಾ, ಅದರಿಂದ ಅಷ್ಟು ಉಪಯೋಗ ಮುಟ್ಟಲ್ಲ.
Sincere submission, Your Lordship. My Lord, since from 2 decades, they have lost 3 to 4 lakhs in litigation itself, Your Lordship.
You have argued that. You have quoted it as mantra several times.
Please, Lord, please.
But that may not help you, except that your client will be happy that our lawyer is arguing very well. We understand all that. But now we are proposing this. Otherwise, leave it to us. We will decide this way or that way. We cannot go on bargaining as if we are doing it in Subhas Market. Subhas Road, Rubas. Ask them. Otherwise, they may not get that also. We do not know. We do not know. We do not know.
Leave to Your Lordship, Your Lordship.
No, don't leave it. Are you giving money to us? The government is paying to us. So we do not take.
But since they have suffered from 2 decades, Your Lordship, in please.
You have said that. You have argued the matter very well. ಚೆನ್ನಾಗಿ ಆರ್ಗ್ಯೂ ಮಾಡಿದ್ರಿ. ಎಲ್ಲ ಕರೆಕ್ಟ್. ಬರೀ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮೇಲೆ ಜೀವನ ನಡ್ಸಕ್ ಆಗ್ತದ? ಬೆಳತಂಕ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದ್ರು 1 kg ಹೀರಿಕಾಯಿ ಸೌತೆಕಾಯಿ ತರಕ್ಕಾಗಲ್ಲ. ಒಂದೇನೋ ಒಂದು ಪ್ರಪೋಸಲ್ ಬಂದಾರೆ ನೋಡಿ ನಿಮ್ಮಲ್ಲಿ. ಮತ್ತು ಅಪೆಕ್ಸ್ ಕೋರ್ಟ್ ಸೈಡ್ ಯು ಹ್ಯಾವ್ ಸೀನ್ ದಟ್ ಜಜ್ಮೆಂಟ್. ಏನ್ ಹೇಳಿ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಈಗಾಗಲೇ ಅಮೌಂಟ್ ಅಕ್ಸೆಪ್ಟ್ ಮಾಡಿದ್ರು ಅಂದ್ರೆ ರೆಸ್ಟ್ ಆಫ್ ದ ಥಿಂಗ್ಸ್ ವಿಲ್ ಫೇಲ್ ಇನ್ ಟು ಇನ್ಸಿಗ್ನಿಫಿಕೆನ್ಸ್.
In one
ಹೇಳ್ತೀರಿ ನೀವು ಮೆರಿಟ್ಸ್ ಮೇಲೆ. ಯು ಆರ್ ನಾಟ್ ಓನ್ಲಿ ದೇರ್ ಅಡ್ವೊಕೇಟ್, ಯು ಆರ್ ಎ ಕೌನ್ಸಿಲ್ ಆಲ್ಸೋ.
Please.
ದೇರ್ ಕೌನ್ಸಿಲ್ ಆಲ್ಸೋ. ಅವ್ರಿಗೆ ನೀವು ಅಡ್ವೈಸ್ ಮಾಡಬೇಕು ಹಿಂಗಿದೆ ಅಂತ. ಇಫ್ ದೇ ಅಗ್ರಿ, ವೆಲ್ ಅಂಡ್ ಗುಡ್. ಇಫ್ ದೇ ಡು ನಾಟ್ ಅಗ್ರಿ, ಮೋಸ್ಟ್ ವೆಲ್ಕಮ್. ವಿಲ್ ರೈಟ್ ಒನ್ ಮೋರ್ ಜಡ್ಜ್ಮೆಂಟ್. ಒಂದು ಹೆಸರು ಮಾಡಿ ಚಲೋ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿರಿ ಅಂತ ಹೇಳಿ ಬರೆಯೋಣ ಜಡ್ಜ್ಮೆಂಟ್. ಬಟ್ ಜಸ್ಟಿಸ್ ಆಗತ್ತೆ ಇಲ್ಲೋ ಗೊತ್ತಿಲ್ಲ. ಒಳ್ಳೆ ಜಡ್ಜ್ಮೆಂಟ್ ಬರೀಬಹುದು. ಯಾರೇ ಲಾ ಸ್ಟೂಡೆಂಟ್ ಹೋದ್ರಿ ಎಷ್ಟು ಚೆನ್ನಾಗಿ ಬರ್ದ ಜಡ್ಜ್ ಇವ್ನು ರೀತಿ ಬರಿಬೋದು. ಜಸ್ಟಿಸ್ ಆಗಲ್ಲ. ಕೇಳಿ ಏನನ್ಸೈ ಮಿಕ್ಸಳಿ ಬೇಗ ಬೇಗ. Heard, reserved.
Please. I am relying on Supreme Court judgment. One judgment of Supreme Court, my lord. Please.
Okay. ಅವ್ರಿಗೆ ಹೇಳಿ ಒಂದ್ ರೂಪಿನೂ ಸಿಗ್ಲಕ್ಕಿಲ್ಲ. ಅವ್ರಿಗೆ ಹೇಳಿ ಒಂದ್ಸರಿ ಜಡ್ಜ್ಮೆಂಟಿಗೆ ಹೋದ್ಮೇಲೆ ನಾವು ಕಾಂಪ್ರಮೈಸ್ ಎಲ್ಲ ಇಲ್ಲ.
First judgment, my lord, in which my lord
What is the proposition? What is the proposition?
Please, estoppel is concerned, my lord. Page number 1, your lordship.
We are not on the estoppel.
Please, my lord.
We are not on that estoppel.
But even mere acceptance of the compensation, what they have issued, my lord.
That his clients are accepting the compensation.
Not compensation, it is a 15-year, 15.
Any amount given by the employer would not stop them from raising the industrial dispute. In support of that, he relied upon addition of
three judges.
Apex Court in Bhau Ram versus Vaijanath Singh. AR 1961 SC.
Please.
That's what. All right. Yes, sir. Yes.
ಅದು ರಿಟಪೀಲ್ದಲ್ಲಿ ಮಿಲಾಟ್ಸ್ ಹ್ಯಾವ್ ಟು ಡೂ ಸಮ್ ಕಂಪ್ಲೈಯನ್ಸ್.
ಹಾಗೆ ಆರ್ಗ್ಯುಮೆಂಟ್. Compliance.
27th, Milords, the contempt was listed. On that day, Milords, I made a submission that the writ appeal.
Yes, argue the matter on merits.
Please. Because I couldn't comply because I couldn't get the file. It was already sent to the court. That was what I wanted to submit. But in the writ appeal.
Ground in.
Milords, the case of the Milords, the petitioner, that is the complainant herein, is that. Is that. He has, my lords, purchased the property. The property, my lords, is in fact acquired for the extension of, my lords, Randebannur municipality by the then Bombay government. My lords, this runs back to, my lords, some hundreds of years back, even prior to independence. To extend, my lords, the town of municipality, my lords, certain lands were acquired, and, my lords, the municipality is the owner of the property, wherein, my lords, it was decided that the property, whoever are interested, my lords, who come forward to take these lands on lease basis will be, my lords, the lease will be they will be allotted these properties on the basis of, my lords, on hereditary rights. They will be leaseholders, but it will be inherited by their family members. On that basis, my lords, it was leased to them.
It's a perpetual lease.
Perpetual lease.
Correct?
Please.
Although perpetual leases are discouraged, there is no prohibition as such.
There is no prohibition as such. The perpetual lease, my lords, was not to the complainant. It was, my lords, to one Bijapur. There in the lease, in that Kabiliyat Patra, they termed it as Kabiliyat Patra, my lords, there was no provision for, my lords, the leaseholder to sell or to transfer their rights to the third parties. It can only be inherited, my lords, through their legal heirs. This is how, my lords, it was styled.
Only by succession.
By succession.
Cannot be by inter vivos transfer.
Illa, that.
Where is the prohibition?
my lords, the lease, sorry, my lords, that this appeal is not paginated.
It's all right. We'll look into all that.
Please.
Don't worry about all
Please,
those
please.
frills. Do not worry about frills.
Please.
Concentrate on frock.
Lords,
Don't
the
worry about frills.
Kabuliyat Patra, my lords, is one.
Does it prohibit alienation of property?
It doesn't, my lords, it says that the lease, my lords, is ಮೇಲ್ಕಂಡ ಷರತ್ತುಗಳಿಂದ ಉಭಯ ಪಕ್ಷರು ಅವರ ಸ್ಥಾನಪನ್ನರು ಅವರ ವಾರಸುದಾರರು ಅವರ ಮೃತ್ಯು ಪತ್ರ ನಡೆಸುವವರ ಬದ್ಧರಿದ್ದಾರೆ.
Therefore, bequest is permitted.
Bequest is permitted.
If bequest is permitted, why not transfer inter vivos? See, section 5 of the transfer of property. Read section 5 of the transfer of property act. There is one famous book by William on wills. An English author wrote a book on law of wills, like Jarman wrote. They say, where one has power to bequeath, one will have power to alienate the property during the, except in Mohammedan law. Where in Mohammedan law, you can alienate the property fully, but by bequest, you cannot make more than 1/3 or 2/3. Mullah says that. Power to alienate may be by will, may be by instrument.
Please.
Kutkali, do you want to spoil your case?
No.
Kutkali, sit down. Oh, you have a problem? Okay. Then all right.
Kindly permit.
See, please be on jurisprudential points. Property, someone says, is nothing but ownership over bundle of rights. One of the rights, someone says, again, is right to alienate the property. Unless alienation is interdicted by law or an instrument having force of law, you cannot interdict. You have seen section 109, 10, 11, or 10, 11, 110, 111, 112 of the Indian Succession Act. 9, 10, 11 of the Transfer of Property Act. They repeal the restriction on alienation, barring exceptions. Read section 5 now.
It's 5 minutes where the transfer is defined.
Includes lease also is a property.
It's a mode of transfer.
No, it's a property. See, traditionally under Indian legal system, except Roman, etc., we have sale, exchange, gift, where full ownership of the property is transferred. Then we have mortgage, we have lease, then we have some anomalous transactions which Mullah Transfer of Property Act discusses. All right, keep them aside. These three will apply to leasehold rights also. I can sell my leasehold rights unless interdicted by the instrument.
Please.
Then you have no case.
No, what I'm lords wanting to submit is that lords the
Your first ground is there is no provision in the instrument under which they have got the leasehold rights to transfer it.
They have sold the property.
That's what.
What
Transfer
we say is
sale also.
lease of what they could have, my lords, transferred is only their right, their leasehold right.
Leasehold is sold.
Yes.
And
This is what, my lords, my
buyer becomes the lessee.
please, this is because the contention. Because
sale of leasehold rights would make the buyer lessee.
Please, their contention before the learned single judge was that they have become the owners of the property. That, my lords, we had.
That learned judge has clarified. It's a case of nemo dat quod non habet. A person cannot transfer a better title than the one which he has.
So he continues, my lords,
That
to be
is clarified by the learned single judge.
continues to be, my lords,
He continues to be the lessee achandraarkavagi. Surya Chandraru iruvavarage he will
continues to be
continue to be lessee, regardless of how he describes himself.
Lords, as I, Lords, comments my submissions. For extension of this Rajabannur town, my lords, hundreds of my lords plots were created in this fashion, and my lords, hundreds of my lords, in fact, 1,200 my lords are the plots, my lords, that have been allotted, big dimension plots at that time, prior to independence. Since my lords, initially my lords, the original allot is my lords continued, and most of them my lords have now sold the properties in this fashion. Sold in the they have transferred their leasehold rights, my lords, to different third parties. And my lords, because there was this problem created, they were staying there. The subsequent lessees was continued staying there, but my lords, their title to the property was not there, and they were claiming that they are the owners of the property because sale deeds were, my lords, executed.
You initiate proceedings for rescinding of
Lords,
lease
I'll,
on that ground.
please, my lords, I'll come to that, my lords. Certain, my lords, resolutions were passed by the municipality, my lords, they were set aside. Then, my lords, in 2020, my lords, the government, my lords, had passed an order to, my lords, settle all these, my lords, problems to, my lords, once for all. That is, my lords, at Annexure A. Saying, my lords, that taking all these, my lords, the earlier position into consideration, my lords, the government says, pass an order, lords, on 11/12/2020, saying that the whoever are in no possession of the property, in the sense, my lords, the allottees, to claim ownership of the property, they have to, my lords, pay 25%, not the entire, but
They are not
25%.
agreeable. What is the power of the government to compel the lessee to become the owner?
Lords,
What is the government's power? Where is that power? That the government judge has said in his own way. There may be scope for improvement even in heaven. That's another thing. But there is sense in the judgment. What is the power of the government? Under which section?
My lords,
which act? Just tell us.
That, my lords, is
Then government is not a Mughal government.
no. What is that? There were two conditions, my lords, in that order.
Not answering the point.
My lords, as far as the
What
power,
is the
my lords,
source
I
of
will.
power to the government? A government cannot do anything which the law does not provide for. The subjects can do all that which is not prohibited by law. 49 Calcutta.
Lords, as far as, my lords, the source of power, my lords, to pass this.
You are only
order.
wasting the time. Any other point you have?
My lords, one submission.
Next.
Since,
The senior panel counsel vociferously argues that the rescinding of the lease deed does not provide for alienation of the same to others. First off, this aspect having not been duly adverted to by the learned single judge, there is a lacuna. Number two, the government, by its order dated 2020,
Lords, 11/12/2020.
11/12/2020, had directed the municipal body to collect the amount and grant ownership over the subject property. And that order having not been put in challenge is enforceable. First, when we asked as to under which power such a order could be passed by the government, the council is not in a position to satisfactorily answer. Next point.
My lords, in this order, my lords, there were two conditions left. That to be eligible for this, my lords, to become the owner, to be eligible, he has to be.
Who wants to be? He does not want to become owner.
No, my
It is
lords.
like forcing a man to become two by marrying.
No, my
He
lords,
says, I don't
please.
want to marry. I want to be like this only.
Now, my lords,
That's what.
now, my lords.
My brother is saying, the government's order at the most can be construed as providing invoking for doctrine of election. If he wants, he can take advantage of that. But you cannot compel.
This is the observation of the learned single judge.
Option, my lords,
He is given an optional.
If he wants, he will choose. You can't compel a person.
Now, my lords, since municipality continues to be the owner of the property, lords, we imagine a situation, my lords, where any of the, my lords, the lessee, my lords, raises huge amount of loan. Then, my lords, he becomes a defaulter. The bank, now, my lords, the bank has to sell the property to recover the loan. The lessee not being the owner of the property.
Not selling the property, selling the leasehold.
No, but my lords, now the petition.
It's security. See, again, doctrine of that maxim, nemo dat quod non habet applies. If he mortgages the property, bank should be cautious what he mortgages is his interest in the property.
Now, my lords, he had approached the bank. That is why, my lord, the writ petition at the first instance was filed. He approached the bank. The bank, since in the RTC extracts, my lords, the owner is shown, the municipality is shown as the owner of the property. The bank said you obtain an NOC from the municipality. Now, my lords, if you provide an NOC, I'm not just, my lords, looking at the complainant, but there are 1,200, my lords, lessees. My lords, if my lords, provide them the NOC, they will obtain loan pledging this property, and thereafter, my
Not
lords,
this property, pledging their interest in the property.
Now the direction, the London single is direction number 6, directed the municipality to give the NOC.
NOC.
That note, para 6. 6, direction number 6.
ಓನರ್ ಅಂತ ಕೊಡು ಅಂತ ಹೇಳಿದಾರ, ಆಸ್ ಎ ಲೆಸ್ಸಿ ಅಂತ ಕೊಡು ಅಂತ ಹೇಳಿದಾರ. ಆಸ್ ಎ ಲೆಸ್ಸಿ ಅಂತ ಕೊಡಿ. What objection you have got?
Lords, one, my lords, this government order was not challenged by the petitioner.
Condition repugnant to the interest created in the property is void ಅಂತ ಹೇಳ್ತದೆ ಒಂದು section. That is at the time of that condition should be contemporaneous with the conveyance. ಹಂಗ್ ಹೊರಡು ಮಾಡ್ಯಾನ ಜಸ್ಟಿಸ್ ರಾಜಮನ್ನಾರ್ ಆಫ್ ಮಡ್ರಾಸ್ ಹೈಕೋರ್ಟ್.
No, my lords, the similar problem was also, my lords, is faced by the Badgi municipality. The Badgi also, my lords, a similar scheme at that time, my lords, before independence was there. This government order, a similar government order was also passed. There, my lords, because as on today, my lords, the reality is this, that the original lessees have all transferred their rights, and my lords have all third parties are, my lords, squatting on the property as lessees. But because of the two conditions, that they have to be resident, they have to be the original allottees, and that they have to be there as residents and not use the property for commercial purpose. That was two conditions. Now the Badgi laws are forwarded to the government to remove these two conditions and retain the one condition, that is to pay the 25% of the guidance value of the property. Not we are not asking for the market value, my lords, or my lords, the.
You are not saying the legitimacy of that government order.
That, my lords, was not challenged in the first instance.
Not necessary. If an order is ab initio void, why I should challenge?
As far as, my lords, the now the no objection, my lords, that which is sought by the now complainant. If we provide the no objection, our, my lords, apprehension is that he pledges this property. I'm not only talking about the complaint, my lords, but there are some
With respect to
mortgages this property, my lords, and obtains huge amounts of loan, and then becomes a defaulter. We being, my lords, the owners of the property, will you put in prejudice, my lords, because
put a word in the event there is a default, we will not be responsible. You are not a co-obligant.
You are not, but
you will.
But by giving the no objection,
no objection, not even consent. It is no objection. Otherwise, he cannot.
That will be, my lords, for no objection to.
You can also say. So only to that extent, correct. Yes. That's what others. He becomes the lessee. That's all. You make it clear in your NOC, saying he is only the lessee in eternity, and our NOC is only to the extent of he availing the right, the loan by securing repayment. The bank can secure repayment by getting the mortgage of that. But you mention it. Once the lease comes to an end, whichever way, whether lease is determined or lease is terminated, both ways, or it gets determined by efflux of time. So efflux of time barala adralli, permanent lease. Hanಗಾಗಿ breach of conditions ಬೇಕಾಗುತ್ತೆ. It can be a case of only termination of lease, not determination of lease at all. ಆ condition ಹಾಕೊಳ್ಳಿ.
Then, my lords, the order passed by the learned single judge, as far as, my lords, directing us to give NOC, my lords, to the petitioner, that, my lords, has to be clarified, is what my humble submission is. One submission, my lords.
What right is it?
That's what. This intra-court
What-
appeal,
Lordship, Lordship. Order number 678, please kindly see.
we'll say that. Okay.
That is the only humble request.
This intra-court appeal calls in question a learned single judge's order dated 3/4/2024, whereby the private respondent's WP number 105498 of 2022 LB res having been favored, a learned single judge of this court has observed in the operative portion thereof as under. Next paragraph. The appeal is dismissed on the following grounds. Number one, the learned single judge has rightly held the lease is perpetual in nature, and leasehold rights can be subject matter of alienation in the absence of interdiction in the lease deed itself. First, admittedly, the lease deed provides for alienation of property, bequeathing of property by the will. First, if a property can be transferred by way of bequest, it can also be transferred inter vivas as provided under section 5 of the Transfer of Property Act. First, the second contention that the private respondents are only the lessees and they have been dealing with the property as if they are owners thereof when they are not, and therefore no relief could have been granted to them, again is mistaken. Is mistaken. First off, the leasehold rights also constitute property and they can be subject matter of alienation unless some special law provides to the contrary. First off, a lessee is entitled to alienate his property, his interest in the property, and the person who buys it, and the alienee becomes the person standing in the shoes of the alienor. Nothing beyond that. By virtue of nemo det quod non habet. First, next paragraph. The third contention that the learned single judge is not right in asking the local body to give no objection, also does not much impress us. First, the lessee is entitled to enjoy the property to the fullest extent of his interest therein, and the lessor has to accommodate such a possibility as of requirement. First, that view broadly accords with the Mullah's Transfer of Property Act 1882, section 107, another 7 or 8, not 107 in the 112. First, however, panel counsel is right in telling us that no objection to be given to the respondents should not be construed as enlarging the interest of the respondents in the subject property, nor his client becoming a co-obligant or incurring any liability under the arrangement that may be entered into by and between the respondents and the others. First, even their nemo det quod non habet applies. It is open to the respondent body to carefully script the NOC. First, with the above observations, writ appeal is disposed of. What was the time given to you to comply?
Timeline, my lords, was not what was not mentioned in the
Within what time you are giving, otherwise one more month, one more year. We know how the corporations work.
4 weeks accommodation, my lords, because
the NOC shall be issued to the lessees by the respondent local body within an outer limit of 8 weeks. 8 weeks. Other direction to be complied with accordingly.
Contempt my lords may be dropped.
The contempt proceedings are liable to be dropped in view of that order now made with liberty to the complainant to institute appropriate proceedings if our order and also the order of the learned single judge as modified by us is not adhered to.
One more submission, lords, if I permit. There is some, my lords, my correction in the name of the complainant in the writ appeal. That, my lords, I will, may be permitted to correct it. Adu, because it will reflect in the order, my lords, that's why.
Regardless of the office objections, we have taken up the matter on merits.
The name of the respondent, my lords, was wrongly mentioned.
One padi at least 100.
That's, my lords. I'll, today. Please. Name of the, my lords, name of the respondent, my lords, is wrongly mentioned, a typographical error there. That I may be permitted to correct it. But that will reflect in the order.
Correct. Padi. Next.
Complaints. Affidavit has been filed, my lord. Key number 2.
Yes, Manchini.
Please, my lord. He served the copy of the complaint. Amount have to have been deposited by the respondent. Now he has deposited the amount.
Deposit madidra? Full of yes, court heli tastu madidya?
Yes.
Agade. Recording. This complaint alleges violation of interim order, nadu?
Interim
order dated 31/8/2023, followed by another order dated 28/3/2024, made in pending MFA number 100743 of 2015, filed by the complainant herein. First, after service of notice, the answering respondent, Daro.
One also appeared last time.
Key number 2 to 6.
Yaar dur tumbiddaro?
2 to 6.
Key number 2 to 6.
2 to 6.
7 is dead, my lord. I have.
Respondents, answering respondent numbers 2 to 6 have filed an affidavit of compliance this day, sworn to by one Mr. Basavaraj Chantaya Dhupad, who happens to be accused number 5 for himself and for others, to the effect that in terms of the order whose violation is complained of, the payment has been made. Deposited another. This amount has been deposited in the court. Correct? Court deposit? Court deposit. The said affidavit is accompanied by a photostat copy of the check, the banker's check, and memo for depositing the amount filed in the MFA. First, a perusal of the same shows there is due compliance of the order, subject order. First, next one, in view of the above, the contempt proceedings are liable to be and accordingly dropped. First, if there is any other residue of grievance, redressal may be had elsewhere in accordance with law. First, for that, all contentions are kept open.
I am permitted to amend the
amendment. Next.
My lords, we are before my lords against a dismissal order of a modification application filed by us before the learned single judge of an order of July 2023.
Modification of order of the learned single judge. After requisition was disposed of, you had sought for modification?
No, we had sought for modification of an interim order.
Modification of the
Interim
appeal
order.
is still pending. Petition is still
Writ
pending.
petition is still pending. Now, what happened, my lords, in March 2022, the contesting respondent, who is respondent number 6 in this writ appeal, filed complaints against us. Us, when I say us, the appellant here is only one, which is Brahmanand Sagar Jaggery Industries. It's a firm, it's a jaggery manufacturing and jaggery powder manufacturing industry. It's a firm. Now, in 2019, the directors of the firm incorporated a company called Askins Biofuels Private Limited. Itself has just research in
Company.
May I make
company.
one-
They incorporated a company called Askins Biofuels Private Limited. Now this,
My lords, may I make one preliminary objection, my lords? Because the matter today is coming up on orders. My lords,
On Madikodi.
my lords, the complied copy of the writ petition, writ appeal has not been served on me. My lords, when I tried
copy
to
is served,
verify
Madam.
with the records of the court, my lords, when the copy that has been served on me had two appellants, appellant number 1 and appellant number 2. My lords, the court copy, my lords, says it is only appellant number 1. The entire pleadings, my lords, pertains to two appellants. That is 1 and 2, one Askins and one Brahmananda. Now, my lords, this dispute has been going on, my lords, before the learned single.
Preliminary.
My lords,
Preliminary objection.
preliminary objection is the complied copy has not been served on me at all, my lords. And my,
How with them, na?
my lord, this is prior to compliance. And
may
there
I
are about 20
clarify?
officers.
Any change is there in the
No,
compliance?
I'm not sure, my lords, because the,
Yes, is there no change?
one appellant, I'll just,
there are about,
One appellant.
because the entire
may
pleadings
I
will
just-
change. The
may-
entire pleadings pertain to appellant 1 and 2. But I'm not shying away, my lords. I have also got a convenience
It is-
compilation because on the last occasion, your lordships had directed them to give a convenience compilation. I'm carrying it. I'm not shying away.
Yes.
grateful. So the directors of the company, directors of the firm incorporated a company called Askins Biofuels Private Limited in 2019 for erecting and manufacturing ethanol and supplying to the government ethanol under the ethanol blended with petrol program. Now, there were two notifications issued by the government in terms of which they set it up also, and they took certain interest
Let us
subventions
see
from
the
the
order,
government.
interim order.
My lords, the
My lords,
entire, the entire order is not uploaded, my lords. Only the operative portion has been uploaded.
That order is not yet released.
No, my lord.
No, my lords, not yet released, my lords.
Long ideno order.
Illa, my lords, it's just one para, my lords, which is, my lords will find it at page number 1 to 3. Gautam, can I submit, please?
Submit. I'm just answering. Please go ahead. But only submit correct things.
Gautam is angry because you have brought him from Delhi to Bengaluru.
I'm only
No,
requesting.
the Supreme Court matter in this connected case itself is listed today, my lords.
We are not denying it.
So-
And there is an order
No,
that.
I'll take my lords through all of that, my
No,
lords.
if it is, suppose if that matter is decided in the Supreme Court.
It is doubtful whether it will come up.
You said it is posted today.
It is posted today at serial number 48.
Just call it afternoon. Let us see.
Man,
Suppose if something happens.
no, no, it will not come. My lords, may just, that is in a earlier writ petition. I will just take my lords, it's a convenience
No,
complaint.
I'm asking you. I'm asking you, please
Yes.
answer.
Yes, ma'am.
Suppose if the Supreme Court passes some order,
Yes, ma'am.
will not it cast shadow or light on
No,
this?
both of us have agreed to take a date there for today.
There.
Because
I'm
this
happy
matter-
for once he has said by
because-
consent. He didn't want to use that word, but once he has said something.
No, why we should, when matter is pending before the apex court, all these things can be urged there only.
What has happened, my lords, there's a division bench order in our favor which says that the standalone distillery, Askins Biofuels Company, is a standalone distillery and the sugarcane control will not apply.
No,
Anta
one
31,
second. Whether the grievance you are raising now before us, can it be treated by the apex court in the pending matter or not is our question.
can it be?
Can it be treated by the apex court?
Can it be treated?
Can it be decided by the apex court if it is raised before it?
No, because this is the matter now before my lords is only on an interim prayer. Now what, just 2 minutes, my lords, because there is a lot of complexity involved in this because of their complaints and what has happened. My lords, they complained in March 22 and they filed a writ petition saying we are in violation of sugarcane control and that both this firm and the company put together are a sugar factory and that the limitation under 6A of the sugarcane control that 2 sugar factories should not be within a radius of 15 kilometers applies to them, Anta. So what the learned single judge at that time did was he remitted the matter back to the Cane Commissioner and he said, you decide. Let them also appear before you, let us also appear. Cane Commissioner passed an order without giving us an opportunity. Till date, there have been about 5 orders passed, no opportunity given at all, ever. Now, dehorse that. We have always come in appeal. Now, one such case, 102-856, we came in appeal, which was decided on 6/1/23. That went against us by the learned single judge. He said, yes, both of you put together are a sugar factory. Now, against that, we filed an appeal, 1000075. That got decided in our favor, but not for Brahmanand Sagar, because para 16 of that order, what learned division bench does is that it says, it issues a declaration that the standalone distillery is a standalone distillery, and that the sugarcane control order will not apply to the standalone distillery. Anta, they give a declaration. In para 17, however, they say that insofar as the firm is concerned, we have not gotten into the grievances and the complaints raised by them. That is for the cane commissioner to decide in case there are violations. Anta. After that, what the cane commissioner did was, he issued us a show cause notice, which is the first writ petition that we filed, 104-198, against which now we are seeking modification. Now, in that case, my lords,
What was the order made?
order made, my lords, was, my lords will find the interim order at 4 to 7 of this convenience compilation. Page number 5, my lords, it will starts under the heading order down there. Convenience compilation. I just handed over the convenience. Page number 4 to 5. I've just enclosed relevant documents which my lords may. It will be convenient for my lords to go through.
Page number
4, Annex B. 4. Now, this was the order passed in that writ petition 104-198.
No, interim order which now you are putting it.
That is
challenge. This
Four-
is the order.
No, this is not the order.
That order.
Page number 2, my lords.
Page 2.
Just previous page.
That's not the complete.
It's an operative portion.
Operative portion of the order.
It's an operative portion. Complete order has not yet been issued. We do not find any good ground or cogent reason to interfere.
Where is that interim order?
Interim order is on the next page. My lords will see page number 4. Relevant at page number 5 starts at the bottom under the heading order. Then on the next page.
So Jaggery unit you can run.
They permitted us to manufacture only jaggery. We gave an undertaking, also filed an affidavit to that effect. Now, this order was dated
Yes. Something, whether it's this order, I feel some vague memory. Somewhere I have read this order. Did it come before me at any time?
My lords, there was a pollution control matter where my lord sitting with the chief at one instance where they were also again wanting to implement. So my lords,
I felt
my
the
lord?
script is scanned by me at one time.
My lords have elephantine memory.
No, no,
They had sought an omnibus order saying that all authority should not precipitate.
Yes.
That time-
We came before the chief under for a prohibition also, writ of prohibition.
My lords was also part
My
of it.
lords dismissed.
This order you wanted to have modified.
Why? Because now
Then what was the modification you wanted?
No, there is.
Where is your application?
My application, my lords will find at page number 720 to 728 of the writ appeal. I'm sorry, I have not put it in the convenience compilation. My lords, there is just one relevant fact before that.
We'll come to that. We
Great.
have come after reading the
Great.
papers. Not given our time.
720.
My lords may also see at 722, my lords, where his application begins.
My lords,
It
let
is-
Gautam not interrupt,
It
my
is by
lords.
two, no, I'm on a fundamental thing. It is by two parties. Here he is saying only appellant one, number one, my lords. Who's maintaining the application also, I don't know, my lords. And it's two connected matters.
I'll clarify all of this. I'll
Please.
clarify all of this.
Where is, page number?
720. 720 is what we had filed. Relevant, my lords, may come to 722.
722.
722.
What is that? In long drawn battle commence so and so, so and so. Where is the prayer column?
Prayer, my lords will find that prayer andre hence the memo for modification, that's all, 726.
What is to be modified? In what way?
That needs some clarification. My lords, this
So
was
in your application, it should be reflected, na?
para number 9, just above that, hence this, if my lords would just take a look at 725, petitioner in so and so. Now that writ petition, my lords,
New rival sugar factory, no?
our sugar factory, they are a sugar factory.
New sugar factory alla.
I am one standalone distillery and a jaggery unit.
But you use the cane for that.
I am proposing to, I have not yet, even one drop of ethanol, I have not been permitted to to manufacture.
Okay.
My lords, there were 2 writ petitions filed.
So in that writ petition, this condition is put.
So 35/2023 they issued. No. My lords may take page number 20 to 40.
Please come to 726.
Yes, my lord, I am on 726.
Now we read it. Convince us what is meant by that.
The last-
Advocacy is convincing the judges to get an order in our favor.
Yes.
Unless we are convinced, we will not give order at all.
Absolutely, ma'am.
Therefore, convince us what is meant by this, what you wanted to do with this.
If my lords would take page number 47, my lords would see that condition and what that order was.
No, that,
10/1/2024.
that is produced, na?
Yeah, that is produced here in this convenience compilation, page number 47. Because my lords would have to sorry, I'm not using the word properly. My lords would have to just appreciate that there were 2 orders passed by the Cane Commissioner. Just 2 minutes, my lords, give me, and it will become more clearer, my lord. It's a bit murky right now. My lords, in the first writ petition, the Cane Commissioner holds me, the firm, to be a power crusher under the Karnataka license.
ಅದೆಲ್ಲ ಆಯ್ತು. ಏನಂತ ಬದಲಾಗಬೇಕು
ಅದಾದ್ಮೇಲೆ they went to the Supreme Court. My lords,
You please sit. You are not answering the
If I
court's
may
point.
just.
I'm sorry.
What is the modification he wants?
My lords, the modification is this, my lords. There are.
ಈಗ 5%
I'll
crushing
just
allow
come.
ಮಾಡಿದ್ದಾರೆ.
Yes, ma'am.
Correct?
There are,
Once
no, allow madilla, my lords. It is,
ಅಲ್ಲಿ order
no, this is a conditional interim order.
Correct.
Subject to the earlier interim order of 26/7 being modified.
ಏನಂತ modify
Now, my lords,
ಆಗ್ಬೇಕು?
there were 2 writ petitions pending before the learned single judge.
One by
one entity called Brahmananda.
that is appellant here.
Appellant here, who is only appellant 1 here. The second writ petition, my lords, was by 2 entities, one by Askins and one more by Brahmananda. So again,
It's a
same
joint petition.
joint petition, my lords. The entire dispute, if I may sum up in 2 lines, is this: my lords, I'm an existing sugar factory. Adjoining my compound, 15 kilometers radius under 6A, my lord. Adjoining my compound, there is another entity. Now, my lord, it is my contention that this Askins Biofuels and Brahmananda are one and the same. It is only a sham juristic difference that they have created, because it is the same partners, it is the same land holding, same finances, all that is on the merits. I will not go into that. Now, my lords, what is pending before the learned single judges? In the first round, they said that Brahmananda is a power crusher. After that, the second impugned order was passed, which is pending in the second writ petition, where they say that Brahmananda and Askins are actually one unit and they fall foul of this 15-kilometer radius. Now, my lords, in the first writ petition, my lords, with my lord's permission, I
He
will.
said, your friend said, there is a standalone unit.
My lords,
also.
that was in the first round. One nimsha. I won't take more than 3 minutes. In the first round, my lords, the Cane Commissioner said, even if it is a standalone distillery, you would fall within the ambit of the sugarcane control order because you are crushing. That, my lords, went before the learned single judge. The single judge said, no, even if it is, since the activity of crushing is happening, you fall within the ambit. That was taken before the division bench. The division bench reversed the order of the learned single judge and said that it is a standalone distillery which traces its powers to a financial modification assistance scheme, and therefore Who is he? That is Askins Biofuels, whom he is not made a party here. That I challenged before the Supreme Court, which is pending. There the Supreme Court is considering whether a standalone distillery manufacturing, this is very important, my lord, a standalone distillery manufacturing ethanol from sugarcane juice, it has nothing to do with crushing, is falling within the ambit of the definition of factory, sugar factory or not. After that, the subsequent events, my lords, their matter is pending before Supreme Court. After that, the subsequent events are these two writ petitions. The first writ petition, whether he is a, one nimsha, Anirudh, whether he is a power,
Will not send you without hearing.
whether,
They will not give you order, but definitely we will be heard in the matter.
whether he is a power crusher or not. My lords, with my lord's permission, I will use the names of the judges because there have been multiple interim orders. The first interim
Ex-judge, why judging it?
Illa, my lords, because, very well, my lord. On 26/7/2023, the first interim order came to be passed. My lords, that is in WP 104198, which is
by appellant herein alone.
Filed by appellant herein. There they said, my lords, this is very crucial. When the matter had come up for admission, they gave a memo and an affidavit stating that we are restricting it to jaggery. Now, my lords, even then the High Court, single judge at that point was cognizant of the fact that the matter is pending in the Supreme Court. They said, okay, on your memo and on your affidavit, you can manufacture jaggery. Please go ahead and manufacture jaggery. Strictly, I cannot have any problem to that. Thereafter, my lords, the second impugned order came to be passed, holding that both Brahmananda, who is
Another writ petition.
Another
Where
writ petition.
He also happens to be one petitioner.
Yes, he happens to be one petitioner there, saying that these two units are actually an integrated unit. There is no activity of jaggery manufacturing. It is crushing of sugarcane juice solely for the production of ethanol. This matter, my lords, when it came up, there were various interim orders. Now that we are concerned with an interim order, my lords, that was passed by Justice Hegde. I'll just use the, by Justice Hegde on 10/1/24. Now, what Justice Hegde said is, you can subject to 5% sugarcane crushed in that area. Appellant number 2, that is Brahmananda, can supply that juice to appellant number 1, Askins, subject to you getting a modification of the order of 26/7/2023 passed by Justice Yarur. Now,
In his petition.
in his petition. Now, that modification application, he moved on 16/1/24, which he showed my lordships at page 720. When that modification, now my lords, kindly note the timeline. The initial order was passed on 26/7/23. Justice Hegde's order came to be passed on 10/1/24. Modification application has been passed on, modification application filed on 16/1/24. My lords, Justice Yarur, the file came up. We were pressing for final arguments on that. Repeatedly, we have been saying, because my lord, what is also important is the order, first writ petition which they filed a direct 32 before the Supreme Court. The Supreme Court said you cannot maintain a direct 32.
It came here next.
No, but there the Supreme Court specifically said expedite hearing, let that hearing go on. There they are shying away from a hearing. They don't want that order heard on merits. Only on interim they are trying to play around.
Where is that order?
My lords, may kindly see that order, my lords, is at page 376 of his petition, 376.
Compilation del ಹಾಕಿಲ್ಲ ಅದನ್ನ?
ಇಲ್ಲ ಹಾಕಿಲ್ಲ my lords, 376, kindly see. My lords, we have repeatedly been, my lords, and the matter has been heard at least, my lords, on 20 times before the learned single judge. We are saying let the matter be disposed of finally. I don't know why they're shying away from a hearing, and today they're only on modifications. It's a waste of judicial time, my lords. We are taking the courts for a ride. Collectively, I put myself also to blame. This, my lords, is subject matter of the writ petition pending today before the learned single judge.
No, only final hearing of the main matter ಅಂತ ಹೇಳಿದೆ.
Yes, that is pending. Now, my lords, their own.
That judgment or order of the apex court.
Yes, my lord.
Where have they said only main matter should be heard?
No, my lord. Liberty is reserved to, and the same shall be considered expeditiously on its merits.
Avail its remedies in accordance with law. Maybe this also.
My lord, I can't say they can't.
Where is the indication?
My lords,
main matter should be taken up, not any other ಅಂತ ಎಲ್ಲಿದೆ? Because 86 Supreme Court. No, not necessarily. This is an order of the matter article 32 ದಲ್ಲಿ ಹೋಗಿದ್ದು interim order of the judge ಅಲ್ಲ.
No, main
Cane commissioner's
Cane
order.
commissioner's
Same order which is
30
pending.
30th. No, my lords, what happened in one order, he says, I'm crushing Brahmananda. In the subsequent order, he says, don't even have a unit, you don't even manufacture jaggery antane. I have been in existence from 2 decades. Now, our submission throughout on the first preliminary threshold was 2 contradictory orders by the same Cane commissioner cannot be sustained. Just on that ground. Second is, my lords, Brahmananda wants to crush sugarcane and supply to Askins for manufacture of ethanol. There is no prohibition. Under the sugarcane control in 2007, they deleted the words good, gur and jaggery from the ambit of the sugarcane control. There is a clarification by the Cane commissioner in 2011 itself that the sugarcane control does not apply to jaggery unit. In my own, I wrote to him and he clarified to me, after which I took IEM and set up that jaggery unit. Now in 2019, when I'm wanting to manufacture ethanol, I set up the whole industry. Just as I was about to manufacture, they started complaining.
ಇನ್ನು ಏನು ಗೊತ್ತಾಗಿಲ್ಲ ಅಂದ್ರೆ ಏನು modification ಬೇಕಿತ್ತು?
Grateful. ಅದಕ್ಕೆ just 5 minutes, I would just request my lords, 5 minutes. 27 page number, if my lords stay, of my compilation. I'm sorry, there is
7 of your
convenience compilation that I just handed over. Now, this is the order which starts at page number 22 of the learned single judge in the subsequent case.
22.
Page number 22 is the start. The relevant part commences from 27.
Your friends can go for coffee round, at least it appears this matter will take some time.
No,
You
it
need not
will, my
be
lords.
sitting. If
There,
you want
there
to
have,
sit,
there
no
have been
problem.
32 writ petitions, my lord. My lord, page number, writ petition number
To
1041.
match with article 32 or what?
No, my lords, you know,
only
under,
two
because,
filed by me.
my lords, there are direct sitting directors in their companies are ministers in the government. Using the Cane commissioners, using the Cane commissioner's office
because these
and
orders
the
were
police.
passed even prior to 22.
I'll demonstrate. I'll demonstrate.
But he can run the industry. Where is the
No, he
Prior
can
to
run- no, but he
22,
cannot, no,
these
he is
orders were passed when he
undue-
had nothing to do with this.
undue-
My lords, frivolous statements like this should not be made, my lord.
Why, if he says your client is a minister?
No, that is a
Why
matter
are
of
you
fact.
offended?
I can't deny that.
The
But
fact.
my lords, he's saying he's interfering. This is the
Yes.
problem.
Why you think that are we against the minister? We are not.
My lords, when
We
we
are
are
in
in
favor
the
of
court
all
of law,
those
my
good
lords, we should
ministers.
argue on fact.
Page number
This is what
100,
we were
101 of
taught.
this compilation, I put his letter.
ಇರಿ
Anyways.
ಏನ್ ನಿಮ್ ಇಬ್ರು ಕ್ಲೈಂಟ್ಸ್ ಇದಾರೆ ಹಿಂದ್ಗಡೆ ಅಥವಾ ಅಲ್ಲೇ ನೋಡ್ತಾ ಇದಾರೋ ಇಬ್ರು? Yes.
Writ petition number 104198 filed to quash order dated so and so, passed by Commissioner for Cane Development and
This is
also.
by
This is
final
by.
order.
No, this is an interim order, my lords.
The interim order whose modification you had sought for? No. This is another
This
interim order.
order gives me relief. It says 95, even if cane is allotted to them, they are entitled for 95. So I made a submission that 5% is more than enough, it goes over my head. And that is not their right at all, even if they are a sugar factory. So based on that, the learned judge gave this order in both the writ petitions. But because the earlier learned judge had said only jaggery, now I want a modification saying that juice also is permitted.
Not only jaggery, but juice also.
Jaggery
In
ಮಾಡ
other
first
words,
juice
that
ಮಾಡ್ಲೇಬೇಕಲ್ಲ ನಾನು.
for the purpose of 5%, you need not confine to jaggery. And it can include
Jaggery unit, I also took separate industrial entrepreneur memoranda under one kind of license to manufacture juice and syrup. And for everybody under the sun before my license.
that standalone unit. In that jaggery question arises.
Standalone unit ಅಲ್ಲಿ crushing ಇಲ್ಲ. There is no mechanism.
ಹಾಗಾಗಿ only jaggery ಪ್ರಶ್ನೆ ಅಷ್ಟೇ.
Jaggery unit is next door. Standalone unit is next door. Their sugar factory is adjacent. Right abutting my wall.
Okay.
So that is why they are, and they have never shown any loss. They have not commenced production yet. Now all of this, may I submit? Permit me to submit.
Anyway, he is saying.
April 20.
You can tell we have grown enormously.
April 20.
You have made Karnataka Punjab of India.
April 22 only, Cane Commissioner passes the first order. In that, during that time, I had not even produced ethanol.
But modification in
Grateful. I'll take my lords to the relevant part, my lords. rather than the whole order, because it's about 27
ಇನ್ನು ನಮ್
pages.
ಕೇಸ ತಿಳಿದಿಲ್ಲ ನಿಮ್ದು.
Sorry.
ಇಲ್ಲಿ ಇದ್ದವ್ರಿಗೆ ಯಾರು ತಿಳಿದ್ರೆ I don't know.
I'm very
They are
sorry.
really, they
I'm
are
very
like
sorry.
experts.
It says a lot about me. I'm very sorry. I'm not able to.
What is that modification? ಬರ್ದ್ ಕೊಡಿ. ಏನಂತ ಬೇಕಾಗಿತ್ತು ನಿಮ್ಗೆ
My lords,
modification?
ಇವಾಗ-
ಬರ್ದ್ ಕೊಡಿ, ಬರ್ದ್ ಕೊಡಿ.
No, no.
Write down and give us.
Brahmanand Sagar has to be permitted to manufacture juice, because in that earlier order which my lord saw, 26/7/23 ಅಲ್ಲಿ, the learned single judge permitted them only to manufacture jaggery. And we gave an undertaking to that effect. Now, because after that order, Kane Commissioner passes one more order, combining both the units again, despite the existence of the division bench order. Because division bench says standalone sugarcane does not apply. So the Kane Commissioner thereafter could not.
ನಾವು ಇನ್ನೊಂದು ಕೇಳ್ತಾ ಇದ್ದೇನೆ.
Yes, my lords.
Suppose if we request the learned single judge
Yes, my
to
lords.
take up the main matter itself now.
Yes, my lords.
Do you have objection?
I have absolutely no objection.
ಹಾಕ್ಬಿಡ್ತೇವೆ.
But in the interim, surfacey notice has been issued.
ಮೇನ್ ಬಂತು.
In the interim, when that, because my lords, this matter, as my lords will note,
We will tell.
there are about 15, no, what happens? What happens, my lords? It is not going to get over within 1 and 2. I'm very sorry.
Lord, may I
I'm
make
very
this-
sorry.
I am very sorry to hear you. Communication ಅಂದ್ರೆ ಏನು? Two monologues do not make communication.
Yes, my lords. Yes,
ಡೈಲಾಗ್ ಬೇಕಾಗ್ತದೆ.
Yes.
ನೀವ್ ಹೇಳೋದು ನಮಗ್ ತಿಳಿಬೇಕು, ನಾವ್ ಹೇಳೋದು ನಿಮಗ್ ತಿಳಿಬೇಕು.
yes.
ನೀವು ಅಜೂಮ್ ಮಾಡ್ಕೊಂಡು ಹೊಂಟ್ರಿ, ನಮ್ಗೆ ತಿಳಿದಿದೆ,
ಇಲ್ಲ,
ನಮ್ಗೆ
sorry.
ಏನೂ ತಿಳಿದಿಲ್ಲ, ನಾವು ನಿಮ್ಗೆ ಕೇಳ್ತಾ ಇದ್ದೇವೆ ಈಗ. ಕರೆಕ್ಟ್ ಆಗಿ ಉತ್ತರ ಕೊಡಿ.
Yes,
ಟೈಮ್ ವೇಸ್ಟ್ ಮಾಡಬೇಡಿ. ಬಹಳ ಜನ ಕಾಯ್ತಿರ್ತಾರೆ ಕೋರ್ಟ್ ನಲ್ಲಿ, ಹಂಗೆಲ್ಲ ಮಾಡಬಾರ್ದು.
sorry.
Now we will request the learned single judge to hear and dispose of this matter within 15 days, number one. For 15 days, no coercive action under Surface Act would be taken ಅಂತ ಒಂದು ಅಬ್ಸರ್ವೇಷನ್ ಮಾಡ್ತೀವಿ. How you will be affected?
How I'll be affected is, there is already 60 crore loan on my head.
We are saying that.
Allah, there is no they have not, they will, even now I will request my lords to ask them to show my lords the prohibition in law. My lords, just in an earlier case was saying there has
Why
to
are
be
you shying
prohibition.
away from arguing
I'm not,
the
I will
main
argue. I was, in fact, my lords, 10-1 order.
Also, you have to challenge it separately and get the remedy there.
No,
ಈ
my,
15 ದಿವಸದಲ್ಲಿ 60 ಇದ್ದಿದ್ದು 70 ಆಗತ್ತನೋ? 60 ಕೋಟಿ 70 ಕೋಟಿ ಆಗ್ತದಾ?
illa my lords, it will only increase.
15 ದಿವಸದಲ್ಲಿ ನಾವು ವಿಲ್ ರಿಕ್ವೆಸ್ಟ್ ಅವರ್ ಲರ್ನೆಡ್ ಬ್ರದರ್, ಪ್ಲೀಸ್ ಹಿಂಗಿದೆ ಇದು, ಬೇಗನೆ ಸ್ವಲ್ಪ
I'll be
ಎಕ್ಸ್ಪ್ಲೈನ್
grateful.
ಮಾಡ್ಬೋದಾ?
I'll be grateful.
ಅಂತ ನಾವು ಕೇಳ್ತೀವಿ.
Yes, page number 46 of the convenience compilation.
ಮತ್ತೆ ಯಾಕೆ ಟ್ರಬಲ್ ಕೊಡ್ತೀರಿ ನಮ್ಗೆ?
Just, sorry.
ಮತ್ತೆ ಹಂಗೆ ನೀವು ಹಂಗ್ ನಡ್ಸು-
No, sorry,
argument
because,
ಮಾಡ್ಕೊಳ್ಬೇಕಾ ಏನು?
because that order is already given to me.
This
Interim
is, my
order,
lord,
page number
this
46.
ಫೈನಲ್ ಆರ್ಡರ್ ಮಾಡಕ್ ಹೇಳ್ತೇವೆ ನಾವು.
Yes, my lords, let them do it, but page number 46, in the,
ಯಾಕೆ ನಾವು ನೋಡಲ್ಲಪ್ಪ. If you agree for final order, final hearing, why you want us to trouble the judges? We have a better job to do. We will request, you have agreed that you are going to argue the main matter.
my lords, 10-1 order, when, before arguing that, I requested the learned judge that permit me to argue.
Now
the
we will
matter.
request.
No,
the
my
learned
lords,
single judge.
I take strong objection
should
to
I
this
be-
on, my
my
lords,
lords-
my lords, only 1 second, my lords, something
my
factually
only-
wrong is being
my-
said.
One second, he also has got some grievance. What we say is, instead of treating this matter in a piecemeal way, we will request the learned single judge, start kindly expedite the disposal of the main matter.
One day submission.
May I
my lord.
make
I won't
these
say, I
agreements?
won't say anything beyond only 1 sentence, my lord. On 8/2/24, my lords, the matter was set down for final hearing. Despite that, they are going on arguing an interim. My lord, very well, I leave it at that, actually.
He's agreeing.
Very well, I leave it.
Even then we agreed with the learned judge.
Still you will
that we
argue
want,
here.
no, because my unit is shut, there is no prohibition, and 10-1
Since
order,
how long it has been shut?
March 22 in the once.
ಇರಿ, ಒಂದು 2 weeks ನಲ್ಲಿ ಏನಾಗ್ತದೆ? 22 to March 2022 ದಿಂದ
It may-
shut ಆಗಿದೆ. ಅಂದ್ರೆ ಎಷ್ಟಾಗ್ತಿಗದು? 2 ವರ್ಷ ಪ್ಲಸ್ 6 months ಆಯ್ತು ನಿಯರ್ಲಿ.
My only.
ನಾವ್ ಏನ್ ಅನ್ಲಿಕ್ಕತ್ತೀವಿ, 2 ವರ್ಷ 6 months ಅಷ್ಟ್ ಬೇಡಪ್ಪ, ಒಂದು 2 weeks ನಲ್ಲಿ 3 weeks ನಲ್ಲಿ ಡಿಸ್ಪೋಸ್ ಆಫ್ ಮಾಡಿಬಿಡ್ರಿ ಅಂತ ರಿಕ್ವೆಸ್ಟ್ ಮಾಡ್ತೀವಿ ಲರ್ನೆಡ್ ಸಿಂಗಲ್ ಜಡ್ಜ್ ಅನ್ನ.
The roster may change again, my lords.
ಅವ್ರ ಮುಂದ್ ಮಾಡಿ, ಅವ್ರ ಮುಂದ್ ಮಾಡಿ, ಚೇಂಜ್ ಆದ್ರೆ ಎಲ್ಲರೂ ಪ್ರೆಸಿಡೆಂಟ್ಸ್ ವಾರಂಟ್
No, absolutely
ಇಟ್ಕೊಂಡೆ
no.
ನಾವು ಬಂದಂತವ್ರು.
Allah, I just, what I remember, I recall, my lords, Justice Krishna Iyer's one judgment embarked on headquarters ಅಲ್ಲಿ, where they collected money without the authority of law, excise authorities. He said that the dharma of the situation warrants that when you don't have any power, that you have to refund that to the people from whom you have taken that. Dharma of the situation. In my case, my lords, there is no law which prohibits Brahmanand from supplying juice. Sugarcane control does not apply.
You are only time wasting.
No, I'm sorry.
Barkali. I mean, we decline indulgence in the matters in view of the full bench, the 7 judgment decision in Tammanna versus Renuka. Full stop. The parties on our suggestion broadly agreed that the main matter itself may be heard and decided by the learned single judge, and accordingly a request be made. Full stop. We are in agreement with that. Next paragraph. In view of the above, this writ appeal is disposed of, earnestly requesting the learned single judge to take up the main matter, the main pending matter itself for consideration.
My lords,
We find some justification for making this request in view of the following observation of the apex court in WP number 650 of 2023, filed by the appellant himself, which itself, full stop, nodi, page 376 nalli idideyalla.
my lords, just one request, my lords. My lords, just one request. My
You
lord said
said,
that no precipitative action. I'm sorry, my lords.
You did not agree, you wanted to argue. We are not going to give that concession.
No, no, my lords, my lords, my lords, just one more. My lords, there are two writs which have to be connected and heard together because.
It's already connected.
Both the
Because-
writs connected writ petition also.
It's already connected, my lords.
My lords, that, no, no, because I came in writ appeal.
Connected?
Yes,
We connected.
it's already connected.
But ಹಾಕಿಲ್ಲ
MD,
ಅಂದ್ರೆ because
WP number ಕೊಡಿ, number ಕೊಡಿ.
104198 and
ಬರ್ಕೊಡಿ, ಬರ್ಕೊಡಿ.
106747
ಅವ್ರು
of
ಎರಡನ್ನೂ
20.
ಬರ್ಕೊಡಿ.
My lords, no precipitative action, please, my lords.
ಬರ್ಕೊಡಿ. We request the banks and other lenders of the appellant herein to explore the possibility of keeping the coercive proceedings in suspended animation till after the writ petition, pending writ petitions are heard and disposed of. What else is there? Yes. Anyway, now you have requested your banker not to take precipitatory action. The bankers will hopefully abide by that. Yes. It is made clear that the appellant and the respondent shall not seek any adjournment before the learned single judge.
Great. My lords, may I request for hand delivery?
Hinge, final order. ಅಷ್ಟೊಂದು ಅವಸರ ಯಾಕೆ ನಿಮಗೆ?
Because I'll move the learned single judge.
ನಮ್ಮ ರೂಲ್ಸ್ ಅಲ್ಲಿ ಕೊಡಕ್ ಬರಲ್ಲ. Yes.
Obliged.
But it will be webhosted today. We will webhost it today only.
Grateful.
Lordship. Proxy counsel, Lordship, kindly have it taped tomorrow, Lordship.
Tomorrow?
Yes, Lordship. The counsel for the appellant is out of station today itself. Cell number 8.
Default. ಒಂದೆರಡು ಬುಕ್ಸ್ ಕೊಡಿ ಲೈಬ್ರರಿಗೆ. ಒಂದೆರಡು ಒಳ್ಳೆ ಪುಸ್ತಕ ಕೊಡಿ.
Yes. Yes, Lordship.
ಏನಂದ್ರೆ ವಕೀಲರ ವಗೈರೆಗಳು ಬೈ ಅವರ C.H. ಹನುಮಂತರಾಯ, senior advocate. Good book. It's a good book. He has written his life story and he has given so many hints to youngsters. Okay. You are a youngster or not youngster? Because we claim that we are still youngsters only.
Except in the caution, delay of 3 days in preparing the item to recall the order dated by 10/25 is confirmed. Appellant,
Presenting.
donating, presenting the above
ವಕೀಲರ ವಗೈರೆಗಳು.
written by learned
C.H. ಹನುಮಂತರಾಯ.
C.H. Hanumantaraya, advocate, Bangalore, to the advocates library within a period of 2 weeks. Appeal is restored. Office objection, you are required to comply?
Yes, Your Lordship.
2 weeks time is granted. ಅದು ಕಂಟ್ರೋಲ್ ಆಯ್ತಲ್ಲ, arbitrated so and so is recalled by accepting the cause shown. 2 weeks time is granted to comply office.
Please.
ಒಳ್ಳೊಳ್ಳೆ ಆಟೋಬಯೋಗ್ರಫೀಸ್ ಎಲ್ಲ ಓದ್ಬೇಕು. Roses in December by M.C. Chagla. My Own Boswell by Hidayatullah. My life, law and other things by Settlewatt. A very good book.
Neither roses nor thorns.
neither roses nor thorns, Khanna. And Honeybees of Solomon by Katie Thomas. Okay. There is another book, An Autobiography of a Yogi by Paramahamsa Yogananda. It's one of the best books. That is another. It's Living with Himalayan Masters by Swami Rama. ಅಂತ ಒಳ್ಳೆ ಬುಕ್ಸ್ ಓದ್ಬೇಕು. ಅವಾಗ ಲ್ಯಾಂಗ್ವೇಜ್ ಇಂಪ್ರೂವ್ ಆಗ್ತದೆ, ಥಾಟ್ ಇಂಪ್ರೂವ್ ಆಗ್ತದೆ, ನಮ್ಮಲ್ಲಿ ಸಾತ್ವಿಕತೆ ಬರ್ತದೆ, ಅವಾಗ ಹೆಚ್ಚು ಇಫೆಕ್ಟಿವ್ ಆಗಿ ಕೆಲಸ ಮಾಡ್ಲಿಕ್ಕೆ ಆಗ್ತದೆ, ಟೆನ್ಷನ್ಸ್ ಇರಲ್ಲ. ಅವನ್ನೆಲ್ಲ ಓದ್ಕೋಬೇಕು. ಎಷ್ಟೋ ಹಿಂಟ್ಸ್ ಗೊತ್ತಾಗ್ತದೆ. ಆಲ್ ಫ್ರಮ್ ಮೆಮರಿ ಬೈ ಯುವರ್ ಬಿ ವಿ ಆಚಾರ್ಯ. ಅಂಡ್ ಬಿಫೋರ್ ದ ಮೆಮರಿ ಫೇಡ್ಸ್ ಬೈ ನರಿಮನ್. ಎಷ್ಟು ಚೆನ್ನಾಗಿದಾವೆ ಬುಕ್ಸ್ ಎಲ್ಲ ಅವು. ಅವನ್ನೆಲ್ಲ ಓದ್ಬೇಕು, ನೋಟ್ಸ್ ಮಾಡ್ಕೋಬೇಕು. ಅವ್ರು ಹೆಂಗೆ ಆರ್ಗ್ಯೂ ಮಾಡಿದ್ರು, ಯಾಕೆ ಬೆಳೆದ್ರು, ಏನೇನು ಡಿಫಿಕಲ್ಟಿ. ನಮ್ಮ ಶಿವರಾಜ್ ಪಾಟೀಲ್ರದ್ದು, ಆನರೇಬಲ್ ಜಸ್ಟಿಸ್ ಶಿವರಾಜ್ ಪಾಟೀಲ್ರದ್ದು ಒಂದು ನಡೆದು ಬಂದ ದಾರಿ ಅನ್ಕೊಂಡು ನಾನು ಓದ್ಬೇಕದು. ನಂಗೆ ಓದೋದಾಗಿಲ್ಲ, ನಾನು ಓದ್ತೆ, ಹಂಗೆ ಕೋಟ್ ಮಾಡ್ಲಿಲ್ಲ. ನಾ ಕೋಟ್ ಮಾಡಿದೆಲ್ಲ ಪುಸ್ತಕ ನಾವು ಓದಿನಿ, ನೀವು ಓದಿ, ಒಳ್ಳೇದಾಗ್ತದೆ. ದೇ ಆರ್ ವೆರಿ ಗುಡ್ ಬುಕ್ಸ್. ನಮ್ಮ ಗುರುನ್ ತಂದೆಯವರು ಸಹಿತ, ನಮ್ಮ ಗಚ್ಚಿನ ಮಠ ಅವರು ಒಳ್ಳೆ ಪುಸ್ತಕ ಬರೆದ್ರು. ವೆರಿ ಬೆಡ್ ಟೈಮ್ ರೀಡಿಂಗ್ ಈಸ್ ವೆರಿ ಎಂಟರ್ಟೈನಿಂಗ್ ಇದೆ ಅದು. ನೀನಾರ ಓದಿಯಾ? ಇಲ್ಲ. ಅದಕ್ಕೆ ಅಲ್ಲಿ ಭೈರಪ್ಪನವರ ವಂಶವೃಕ್ಷದಲ್ಲಿ ಮಿಸ್ಟರ್ ರಾವ್ ಅವರ ಹೆಸರು, ಐ ಫಾರ್ಗಾಟ್ ಹಿಸ್ ನೇಮ್, ಎಲ್ಲ ಬುಕ್ಸ್ ಬರೆದಿರ್ತಾನೆ. ಆವಾಗ ಅವರು ಕೇಳ್ತಾರೆ, ನಿನ್ನ ಮಗು ಏನ್ ಮಾಡ್ತದೆ ಅಂತ. ಮಗು ಸ್ಕೂಲಿಗೆ ಹೋಗ್ತದೆ, ಹಿಂಗ. ಅದು ನೀಂತ ಪುಸ್ತಕ ಬರ್ದಿ ಅಂತ ಗೊತ್ತಿದೆ ಅನ್ನೋದಕ್ಕೆ ಇಲ್ಲ. ಓಕೆ.
I'm the appellant in this case, Your Lordship. There is one more appeal is there out of arising out of common judgment, Your Lordship. It may be connected to this appeal, Your Lordship.
This is for claimant's appeal.
Yes, Your Lordship. I am for the claimant, Your Lordship.
Another appeal filed by whom?
It is also parents of the deceased rider of the bike. It is the parents of the pillion rider of the.
Common judgment was passed in 2 MVCs. But this is it has the claim petition was dismissed,
Your Lordship.
One submission, Lords. I appear for only respond number 1 and 2 in this case. 3 is a driver. I appear for NWKSRTC and this 1 and 2.
And delay may be condoned, Your Lordship, and it may be listed for admission and
Admission. There is a delay, may be condoned.
Please. And maybe records may be called for, Your Lordship. Please.
Please, Your Lordship. This case, I pay for the appellant, Your Lordship. In this case, now I am ready on the merits of the case, Your Lordship. In fact, the application is filed in the year 2020, Your Lordship. Applicants for withdrawal of the amount. Instead of that, not they, I will argue the matter on merits, Your Lordship. Quantum, Your Lordship. Quantum, claimant's appeal, quantum, Your Lordship. In fact, he said no, he's in.
I am appearing for the respondent insurance company.
No, I will argue the matter in 102-507, Your Lordship. MEC, Your Lordship, 6 of 2018, Your Lordship. Now, both are them not the injury cases, Your Lordship. Not mainly, not I am sought for the enhancement on the ground of not the income considered by the tribunal is on the lower side, Your Lordship. Now, tribunal is considered 12,000, Your Lordship.
Chart value ಏನು? Chart value. Chart.
In synopsis, not a statement.
How much amount you want to consider?
No, in fact, not the.
Legal service authority, how much?
No, in fact, in the present case, not the claimants are working as a drivers in the not the Kuwait, Your Lordship. Kuwait, Your Lordship. They have produced the salary certificate, Your Lordship. Kuwait, Your Lordship. Exhibit P6, not the salary certificate, and the not the ID card issued by the not the company, Your Lordship. Not the as per the not the salary certificate.
There are bank statement for receiver amount.
Bank said
can't examine somebody from Kuwait, no?
Nothing
Bank
examined.
statement.
In fact, not the employee was examined, Your Lordship, but the tribunal has not considered on the ground that the employer has not produced the document to show that she is working in the said company, Your Lordship.
ಅವ ಬಂದು ಹಂಗೆ ಹೇಳ್ಬಿಟ್ರೆ ಹೌದು ನನ್ನಲ್ಲಿ ಇದ್ದಾನೆ, ಅವನಿಗೆ 25 ಲಕ್ಷ ರೂಪಾಯಿ ಸ್ಯಾಲರಿ ಕೊಡ್ತೇನೆ ಅಂತ ಹೇಳ್ತಾನ. ಅದು ವೆರಿಫೈ ಮಾಡ್ಲಿಕ್ಕೆ ಸಮ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಬೇಕಾ?
Please, ma'am. Employment documents. In fact, not the exhibit P11 is the not the passport to show that he was went to the not the Kuwait, Your Lordship.
He went for sightseeing and he was detained there.
Another document, exhibit P8 is the not the document, not the DL issued by the not the state of Kuwait, Your Lordship. They have issued the not the
ಎಂಪ್ಲಾಯ್ಡ್ ಇದ್ದ ಅಮೌಂಟ್ ಅನ್ನ ಬ್ಯಾಂಕಿಗೆ ಹಾಕ್ತಾರೆ. ಎಷ್ಟು ಡಿರಾಮ್ ಹಾಕಿದ್ರು, ಹೌ ಮೆನಿ ಡಿರಾಮ್ಸ್ ಪುಟ್ ಇನ್ ಟು ದ ಬ್ಯಾಂಕ್ ಅದು ಬೇಕಲ್ಲ
He
ನಮಗೆ.
has not produced the bank statement, your lordship.
ಹೌದು.
ಇಲ್ಲ ಬ್ಯಾಂಕ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಹಾಜರ್ ಮಾಡಿಲ್ಲ. As per the chat, your lordship, not the 2016, your lordship. Not my respectful submission is not, there is no doubt. My respectful submission, not there is no dispute regarding the not the his avocation, your lordship. He was not the professional by driver, your lordship. Not the 2016, your lordship. 21/9/2015, your lordship. Sorry, 21/9/2015, your lordship. I am not the my respectful submission, not the. Even assuming that not the his passport shows that not he was residing in the Kuwait, your lordships. My respectful submission, not the his only income and in view of them not he has suffered not the 95% to them not the whole body, your lordships. In view of them not the erudde priyam not he is entitled for them not the 50% of them not the future prospectus, your lordships. And kottilla. No, 95% of the whole body amputation is there. It has to be considered 100% by considering 95% of the whole body, your lordship. 95% ಮಾಡಿದ consider ಮಾಡಿ.
Amputation ಯಾವುದು?
Not the amputation, not the
ಡ್ರೈವಿಂಗ್ ಮಾಡಕ ಬರದಂತ amputation ಏನ್ರ
ಹೌದು
ಆಗಿದೆಯಾ?
I show the ಹೌದು. I show the photographs, your lordship.
ಫೋಟೋ ಕಾಪಿ ಅಲ್ಲ ಹೇಳ್ರಿ, ಫೋಟೋದಲ್ಲಿ ಏನ್ ಗೊತ್ತಾಗ್ತದೆ?
ಅಲ್ಲ ಪುಟ್ಟ ಕಾಲ ಕಟ್ಟ ಇದಾಗಿತ್ತು, ಅವ್ರು ಕಾರ್ ನೋಡ್ಬಿಟ್ರೆ ಗೊತ್ತಾಗುತ್ತೆ.
Yes, my lord. 40%, 40%.
Income and not future prospect.
Future prospects.
Prospects.
Income 12,000 ತಗೊಂಡಿದ್ದಾರೆ.
That we are making it as a 15,000 because driver either in Kuwait or in India doesn't make
ಏನು
any
ಮಾಡ್ಲಿಕ್ಕೆ
difference.
ಬರೋದಿಲ್ಲ ಮುಂದೆ, ಆಲ್ಮೋಸ್ಟ್
15,000.
ಇನ್ವ್ಯಾಲಿಡ್.
And future prospect 50%.
Well, 40%, man. 40%.
Why 40%?
Because it is private, not a government. 40 to.
that difference ನಹರ್ ಕೇಸ್ ನಲ್ಲಿ ಆ ಡಿಫರೆನ್ಸ್ ಇಲ್ಲ ಅಂತ ಹೋಲ್ಡ್ ಮಾಡಿದ್ದಾರೆ.
ಅಲ್ಲ ಅದರಲ್ಲಿ ಬರೆದಿದ್ದಾರೆ ಮೇಡಮ್. ವಾಟ್ ದ ಲಾದಲ್ಲಿ ಏನು 40% ಅಂತ ಮಾಡಿ.
My respectful submission is lordship. At least it may be income may be considered 25,000, lordship, because lord he was. Lord, my respectful submission, your lordships.
Nahar case said, Supreme Court said, there should not be difference in this merely because employment is private. What is that Nahar case ittala yadu? Do you have that judgment? I remember the name of judge that case where the court have discretion to grant anything between 40 to 50 where employment is private anta hold ಮಾಡಿದ್ರು.
These are only two grounds that he missed.
Only two. My respectful submission, not the it may be considered 25,000 monthly income, your lords, because he was residing at Kuwait, your lords, along with the family, your lords.
How many times he was in Kuwait?
According
Only
to
once he was in Kuwait.
No evidence at all.
Evidence illa, but not the nobody will go for them abroad for not the earning of 10,000 or 15. At least not the 25 income may be considered 25,000, lords. Lordship, he was residing in along with my family at Kuwait, lords. There is no dispute regarding the lord.
More expenditure.
ಅಲ್ಲಿ expenditure ಏನು? ಅಲ್ಲಿ the consumer box ಏನೇನಿದೆ, what how much money is required for living there, ಎಲ್ಲ aspects ಅಂತ ತಗೊಂಡು ಅದೆಲ್ಲ ಏನು?
My respect, according to the salary certificate, not the when Kuwait not the exchange rate of the Kuwait dinar is not the 224 rupees Indian rupees. It comes to not
ನೀವು ಬ್ಯಾಂಕ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಯಾಕೆ ಕೊಡ್ಲಿಲ್ಲ?
ಅಲ್ಲ ಕೊಡ್ಲಿಲ್ಲ ಮೇಡಮ್, ಬಟ್ at least ಬರೀ ಬೋನಾ ಪೇಡೆ at least 25,000
ನೌಕರಿನ ಬಿಟ್ಟು ಬಂದಿದ್ದ ಮೇಲಾಡ್ he has come ಇದು ಮುಂದೆ ಹೋಗೋದು ಇದ್ದಿದ್ದಿಲ್ಲ.
Bangalore and in Dharwad 25% drivers will not get.
It may be considered 25,000 is small or the ends of in the ends of justice, your lordship, it may be considered.
ಏನಿಲ್ಲ
Next
ನಾವು
time
ಕೊಟ್ಟೆ ಕೊಡು.
next time is
Same lord. Second name is also not is the
both driver.
Please, your lord.
ಅಲ್ಲ ಅದರಲ್ಲಿ ಡಿಸಬಿಲಿಟಿ ಕಮ್ಮಿ ಇದೆ ಮೇಡಮ್.
ಅಲ್ಲಿ ಎಷ್ಟಿದೆ ಫೋಟೋ ಕೊಡಿ?
44% ಇದೆ.
44%
ಹೇಳಿದ್ದಾರೆ, 14% ತಗೊಂಡಿದ್ದಾರೆ.
ಅವ್ರ ಫೋಟೋಗ್ರಫಿ ಇಲ್ಲ, ಅವ್ರ ಫೋಟೋಗ್ರಫಿ
Amputation ಇದೆಯಾ?
ಇಲ್ಲ amputation ಇಲ್ಲ, ಬರೀ ಇಂಜುರಿ.
ಅದ್ರಲ್ಲಿ ಬರಲ್ಲ. But the doctor said 44%, your lordship.
ಇದ್ರಲ್ಲಿ ತುಂಬಾ ನಮ್ಗೆ ಗೊತ್ತಾಗ್ತದೆ, ತುಂಬಾ ಅನ್ಯಾಯ ಆಗಿದೆ ಇವನಿಗೆ ಅಂತ ಗೊತ್ತಾಗ್ತದೆ.
I spoke in the ends of justice, not the
ಅಲ್ಲಿ
income. may be considered.
44% 1/3 ತಗೊಂಡಿದ್ದಾರೆ.
ನಾವು ಮಾಡೋ
14%
ಆರ್ಡರ್ ಹೆಂಗಿರ್ಬೇಕು,
ತಗೊಂಡಿದ್ದಾರೆ.
ನಾವು ಮಾಡೋ ಆರ್ಡರ್ ಹೆಂಗಿರ್ಬೇಕು ಅಂದ್ರೆ, ನಾಳೆ ಅದನ್ನ ಯಾರ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ನಲ್ಲಿ ಚಾಲೆಂಜ್ ಆಯ್ತು ಅಂದ್ರೆ ದೇರ್ ಇಸ್ ಸಮ್ ಸೆನ್ಸ್ ಅಂತ ಅನ್ಸ್ಬೇಕು ಅವ್ರಿಗೆ. ನಂತರ ಅಕಾಡೆಮಿಕ್ಸ್ ಯಾರಾದ್ರೂ ಓದಿದ್ರೆ ಅಡ್ಡಿಲ್ಲ, ಇಟ್ಸ್ ಎ ಗುಡ್ ಆರ್ಡರ್ ಅಂತ ಏನಿದ್ರೆ ಚೆನ್ನಾಗಿ ಬರೆಯಕ್ ಬರ್ತಿತ್ತು. ಬಟ್ ಎನಿವೇ ವಿ ಆರ್ ಹ್ಯಾಪಿ ಅನ್ನಂಗಿರ್ಬೇಕು, ಸ್ಯಾಟಿಸ್ಫೈಡ್.
As per exhibit P8,
ಸ್ಟೇ ಆತು ಅಂದ್ರೆ ಅದು ಸಿಗಲ್ಲ.
by considering evocation, your lordships, the exhibit P8 is the DL issued by the Kuwait state, your lordships.
ನೀವ್ ಎಷ್ಟು ಸರಿ ಕುವೈತ್ ಅಂದ್ರೆ ಕುವೈತ್ ತಾನೇ ರೂಪಗೊಂಡು ನಿಮ್ ಮುಂದೆ ದರ್ಶನ ಕೊಡ್ಬೇಕು, ಅಷ್ಟಾಗಿ ಆಯ್ತು.
P6 is not corroborated with any other statement, hence that's
ಕೂತ್ಕೊಳ್ಳಿ. Please be seated.
Please.
To assess the income of the injured. There is no dispute that the injured has suffered amputation of 95% to the whole body, that is right leg above the knee was amputated. As the tribunal has rightly assessed the disability of 95% to the whole body. Taking into account this nature of outpatient, we notionally assess the income of the injured at 15,000 per month for the purpose of compensation. To stop. The injured was aged about
27 years.
27 na?
27 years.
Working 27 years and working as a driver with, as per his oral testimony and other documentary evidence on record. Hence, he would be entitled 50% of the assessed
ಅಲ್ಲ
income
40% ತಾವೇ ಎಲ್ಲದರಲ್ಲಿ ತಗೊಂಡಿದ್ದೀರಿ ಮೇಡಮ್.
under the date of loss of future prospects of the injured, as the case is of amputation and disability is more than 95%. On these two heads, compensation is modified. Reasons ಹೇಳ್ತಾ ಇದ್ದೀನಿ ಅಷ್ಟೇ, ಆಮೇಲೆ change ಮಾಡಲ್ಲ. In next MUC 11 of 16, the
Calculation ಕೊಡಿ.
injured was a driver, taking note of the oral testimony and other documentary evidence on record. We mostly assess his income as rupees 15,000 per month. His disability is rightly assessed by the tribunal, considered by the tribunal at tribunal.
45%
44.
ಅಲ್ಲ 14% ಮೇಡಮ್. 44% to the particular
95%
limb.
Next case.
14 ತಗೊಂಡಿದ್ದಾರೆ.
Next case ಅಲ್ಲಿ 44, the doctor assessed 14% has been considered.
Tribunal is considered
14%.
Dr. PW.
PW 5, your lordships.
5 already 4.
ಹೌದು.
As assessed the disability 44%. Tribunal considering the same.
To the particular part.
The disability at
14%.
14%. Taking note of applying 1/3 as a general principle, we assess the disability at 15% for the purpose of compensation. You had a disability only, less income of this. Where is the numbers? Just to type my code. In awarding the compensation to the injured, it would be difficult for the courts or the tribunal to assess the compensation based on mathematical precisions. Taking note of the evidence available on the court, where of the considered view that the tribunal has committed error in assessing the income as well as the disability in MUC number so and so. MUC second is 11. We accordingly modify the compensation. Change ಮಾಡಿ add ಮಾಡ್ತೀನಿ. Type ಮಾಡಿ.
ಮೆಮೊ ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಇಸ್ಕೋಬೇಕು ಅವ್ರ ಹತ್ರ.
ಕಳಿಸ್ಕೊಡಿ ಸರ್, ಇದೊಂದು 2 ಆಯ್ತಲ್ಲ, ಇದು 2 3 ಕಳಿಸ್ಬೇಕು.
ಗೊತ್ತಾನ ಇಲ್ಲ ಇತ್ತು.
So the matter milots which were referred to mediation on the last occasion.
Mediation ಕಳಿಸಕ
ಕಳಿಸಿದ್ರು
ಆಗಿಲ್ಲ.
ಇಲ್ಲ ಅಲ್ಲಿ milots what has happened milots, what they offered milots was only 15 lakhs milots to compensation. This is a case milots where the father of the husband of the appellant milots was married in the year 1959 once, and there afterwards milots he did not milots keep in touch with the in good faith milots with his first wife. There afterwards milots he married this lady, and there afterwards milots he had married a lady.
ನಿಮ್ ಕ್ಲೈಂಟ್ ವಯಸ್ಸು ಎಷ್ಟು?
Lords, now she is old, my lords. She is a senior citizen now.
Yes.
Lords, she is
59.
53 years, my lords, as on 2017. Now, my lords, 2000, around 63 years. Retired.
ಇವ್ರಿಗೆ ಎಷ್ಟು?
ಅಲ್ಲ, ಅವ್ರು ತೀರ್ಕೊಂಡ್ರು ಅವರು.
ಅವ್ರು ಇಲ್ಲಿಲ್ಲ.
After marrying the third lady, he died.
Okay.
So from second lady, my lords, he had got 2 children. From third lady, he has got 1 children. Suit for partition, my lords, which was filed by the children of the second lady, my lords, was dismissed. My lords, allu dismissed. Amal 2 RSs are pending. So comprehensively, my lords, all these issues have to be resolved in order to create a win-win situation for both of them.
ಅದೇ ಹೋಗಿ ವಾಪಸ್ ಬಂದದೆ.
Lords, very short point is involved in this case. Lords, the appellant herein, she claims that she married the respondent number 1 during 1984. When, my lords, admittedly, the first marriage was subsisting. The decree of divorce took place, my lords, in the year 1990, my lords.
Some justice, Mr. Nilopan.
There is one property, my lords, in Dharwad, which is measuring about 8 guntas or so, my lords. Otherly, but all, my lords, if legitimately, my lords, if the share has to take place, then, my lords, I am entitled for 3 shares because wife and 2 children, and third wife and 1 child. So they are entitled for 2 shares.
Wife and 2 children.
Wife and 2 children.
ನಿಮ್ ಕ್ಲೈಂಟ್ಗೆ ಇಬ್ಬರು ಮಕ್ಕಳಿದ್ದಾರೆ.
ಇಬ್ಬರು ಮಕ್ಕಳಿದ್ದಾರೆ. ಆಮೇಲೆ ನಮ್ಮ ಇಬ್ಬರು ಮಕ್ಕಳು ಆದ್ಮೇಲೆ, my lords, after that he
ವಯಸ್ಸು
married.
ಎಷ್ಟು ಅವ್ರು? ಅವ್ರ ವಯಸ್ಸು ಎಷ್ಟು?
They are majors, my lords.
ಏನ್ ಮಾಡ್ತಾರೆ?
My lords, one of them is an advocate. He became an advocate because of this litigation only.
ಈ ಕೇಸ್ನಿಂದ ಅಡ್ವೊಕೇಟ್ ಆಗಿ
ನೋಡಿ advocate ಆಗ್ಬಿಟ್ಟಾವ. Another lady, my lords, she is just married and residing in her husband's place.
ನಿಮ್ಗೆ ಏನಿದೆ ಬೇರೆ?
ಅಲ್ಲ, ನಾವು ಕೇಳ್ತಾ ಇರೋದು ಆರ್ತಿ ಬಿಲ್ಡಿಂಗ್ ಅಂತ ಹೇಳಿ ಒಂದು 8 ಗುಂಟೆ ಜಾಗ ಇದೆ ಸ್ವಾಮಿ ಧಾರವಾಡದಲ್ಲಿ.
8 ಗುಂಟೆ ಜಾಗ ಇದೆ.
8 ಗುಂಟೆ ಜಾಗ ಇದೆ. There is a building also. In the first floor, I am residing. I am still in possession of the property. Admittedly, there is an interim order operating in RSA. ಆ ಬಿಲ್ಡಿಂಗ್ ನಲ್ಲಿ ಸ್ವಲ್ಪ ನಮ್ಗೊಂದು ಹಾಫ್ ಶೇರ್ ಕೊಡಕ್ ಕೊಟ್ರೆ ನಾವು ವಿಲ್.
ಎಷ್ಟು ದೊಡ್ಡದಿದೆ ಬಿಲ್ಡಿಂಗ್?
8 ಗುಂಟೆ ಬಿಲ್ಡಿಂಗ್, 8 ಗುಂಟೆ ಜಾಗ ಇದೆ. ಅದರಲ್ಲಿ 2 guntas, my lords, I think it's building of 3 floors.
4 guntas are recalled, my lords. Already it is disposed of.
ಯಾರಿಂದ? ಅವ್ರೇನ್ರ ಮಾಡಿದ್ರ, ನೀವು ಡಿಸ್ಪೋಸ್ ಆಫ್ ಮಾಡಿದ್ರ?
ಇವರೇ ಡಿಸ್ಪೋಸ್ ಮಾಡಿ.
Respondent number 2.
ಹಂಗಾಗಿ ಸೆಂಟೆನ್ಸ್ ಅನ್ನ ಆಲ್ರೆಡಿ ಇಟ್ ಈಸ್ ಡಿಸ್ಪೋಸ್ಡ್ ಆಫ್ ಅಂತ ಹೇಳ್ಬಾರ್ದು. ವಿ ಹ್ಯಾವ್ ಡಿಸ್ಪೋಸ್ಡ್ ಆಫ್ ಅಂತ ಹೇಳ್ಬೇಕು. ಏನಾರ ಕಾಂಪ್ರಮೈಸ್ ಮಾಡ್ಕೊತಿರೋ ನಾವೇ ಆರ್ಡರ್ ಮಾಡ್ಬೇಕು.
In the mediation center, my lords, they offered 15 lakhs. Then, my lords, my client says that, my lords, now the property is worth 4 to 5 crores. He himself was ready to pay 1.5 crores to them if they are ready to give up that building. Offer, counter offer ಕೊಟ್ಟಿದ್ವಿ. He said 15 lakhs, I said 1.5 crores, I will pay him. Let him give that
The
building.
duty of the husband is to maintain the wife, not to make wife a millionaire.
No, not like that. What has transpired in mediation center.
ಇಲ್ಲಾದಲ್ಲಿ ಏನಿದೆ ಅಲ್ವಾ? ಅದು ಲಾದಲ್ಲಿ ಏನಿದೆ ಒಂದು. ಸೆಕೆಂಡ್ಲಿ, ಯು ಹ್ಯಾವ್ ಆಲ್ರೆಡಿ ಗ್ರೋನ್ ಅಪ್ ಚಿಲ್ಡ್ರನ್, ಅದು ಇದೆ. ಹಂಗಾಗಿ ಒಂದು ರೀಸನೇಬಲ್ ನಿಮ್ಗೆ ಹೇಳೋದಿದ್ರೆ ಮತ್ತೆ ಬೇರೆ ಪ್ರಾಬ್ಲಮ್ ಆಗ್ತದೆ. ನಮ್ಮಿಂದ ಒಂದು ಆರ್ಡರ್ ಮಾಡಿಸ್ಕೊಳ್ಳೋ ಬದ್ಲಿ ಯು ಶುಡ್ ಸ್ಟ್ಯಾಂಡ್ ಟಾಲ್. He has begotten 2 children. Now she is in the evening of life and he has closed his eyes once for all. So instead of ನಾವೊಂದು ಎಂಥದೋ ಒಂದು ಆರ್ಡರ್ ಮಾಡಿ ಅದ್ರ ಮೇಲೆ ನೀವು ಮತ್ತೊಂದು 20 ವರ್ಷ ಸೈಟ್, ಅದು ಅರ್ಥ ಉಪಯೋಗ ಇಲ್ಲ.
3 cases can be.
ಒಂದು ರೀಸನೇಬಲ್ ಆಫರ್ ಅನ್ನ ತಗೊಂಡು ಬನ್ನಿ. ಇಲ್ಲಿ ಹೋಗಿ ಸಿಟ್ ಅಂಡರ್ ದಿ ಶಾಡೋ ಆಫ್ ಸಮ್ ಟ್ರೀ, ಗುಡ್ ಟ್ರೀ, ಅಲ್ಲಿ ಕುತ್ಕೊಂಡು ಈಗ ಮಧ್ಯಾಹ್ನ ಕರಿತೀವಿ ನಾವು, ಇಲ್ಲ ಮುಗಿಸ್ಕೊಂಡ್ಬಿಡ್ಬೇಕು. ಇಲ್ಲಪ್ಪ ಅಂದ್ರೆ ಎರಡೂ ಸೈಡ್ ಆರ್ಡರ್ ಮಾಡಂಗಿದೆ ಇದು ಈ ಕೇಸ್. ಅಲ್ಟಿಮೇಟ್ಲಿ ಇದರಲ್ಲೂ ಒಂದು 10 ಪಾಯಿಂಟ್ ಇದೆ, ಅದರಲ್ಲೂ ಒಂದು 10 ಪಾಯಿಂಟ್ ಇದೆ. ಯಾವ ಪಾಯಿಂಟ್ಸ್ ನಮ್ಮನ್ನು ಹೆಚ್ಚು ಇಂಪ್ರೆಸ್ ಮಾಡ್ತದೆ ನಿಮ್ಗೆ ಹೇಳಕ್ಕಾಗಲ್ಲ ಅಲ್ವಾ? ಕುತ್ಕೊಂಡು ಮುಗಿಸಿ. ಎಷ್ಟು ವರ್ಷ? ಶಿ ಇಸ್ ಆಲ್ರೆಡಿ 60 and the patriarch has already closed his eyes ಅಲ್ವಾ? ಮುಗಿಸ್ಕೊಂಡು ಕುತ್ಕೊಳ್ರಿ. With your experience, come out, or you tell one writing ನಾಗ ಏನಾರ ಕೊಡಂಗಿದ್ರೆ ಕೊಡಿ. Suggest it.
I will consult my.
I request on 17th, my lords, it could be taken up.
ಮತ್ತೆ ಮುಂದೆ ಹೋಗೋದು.
ಅಲ್ಲ, 17th
61 ವರ್ಷ ಆಗ್ತದೆ ಅವರಿಗೆ. ಇದೇ ನಮ್ನಿ ಹೊಟ್ಟು ಕೇಸ್ ಎಲ್ಲ. ಅವತ್ತಿಬ್ಬರನ್ನು ಕರ್ಕೊಂಡ್ ಬರ್ತೀರಾ?
I will keep the parties present.
Call on 17th at the request of both the sides. who have agreed to keep their clients present before the court to work out some amicable settlement.
Grateful.
Okay.
Next matter, notice on IA as well as on main.
There is a delay of 1.
Notice on IA as well as on. Two appeals, notice on IA 2 of 23 as well as on main. It's a corporation appeal.
Yes, my lord.
Execution is filed. Execution is filed.
Yes, my lord.
Huh?
I'm sorry.
Execution hakidara?
No, my lord.
Illa.
No.
Notice ಆಗಿ ಬರಲ್ಲ ಅಥವಾ ಸ್ಟೇ ಬೇಕು ಇವಾಗಲೇ?
No.
ಇಲ್ಲೇ ಇದೆಲ್ಲ.
Stay may be given and notice may be given.
Amount deposit ಹಾಗಿದೆ.
ಎಂಟೈರ್ ಮಾಡಬೇಕಾಗಲ್ಲ.
Yes, ma'am.
ಇಲ್ಲೇ ಕೊಡಿ. And notice on IA 1 of 24 as well as on May, 2 of 23 as well as on May. Meanwhile, there shall be interim order of stay of the impugned judgment and award of the tribunal subject to appellant depositing entire compensation amount along with accrued interest before the tribunal within a period of 8 weeks. The tribunal is directed to reinvest the said amount of the initial period of 1 year. Call 40 is here.
Yes.
It is made clear that if the amount is not deposited, interim order granted to this can dissolve as a bond without further orders of the court.
New act.
ನೀವು ಯಾಕೆ ಹೋಯ್ತಲ್ಲ ಮತ್ತೆ ಅವತ್ತು ವಜಾ ಬರುತ್ತೆ ನೋಡೋಣ ಬರ್ಲಿ ಏನಾಗುತ್ತೆ ನೋಡೋಣ
ಕ್ಲಿಯರ್ ಮಾಡೇವಿ.
ಯಾವತ್ತು
ರಿಸರ್ವ್ ಮಾಡೇವಿ. ಅದನ್ನ ಯಾರು ರೆಸ್ಪಾಂಡೆಂಟ್ ಯಾರ್ಯಾರು?
Respondent millards, one is government,
to notice on IA
1, 2 are government millards, 3 to 6 are private party.
ಜೊತೆ ಮಾಡಿ ಮಾಡಿ learned AG is requested to accept notice for
ROCP.
SCTP.
ಪ್ರೈವೇಟ್ ಪಾರ್ಟೀಸ್ ಇದ್ದಾರಾ? ಪ್ರೈವೇಟ್ ಪಾರ್ಟೀಸ್.
Private party 3 to 6 millards.
Notice on to the respond number so and so on IA 1 of 23 as well as on May list along with other reserve ಆಗಿದೆ.
ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟರ್
List along with so and so third reserve.
ಕಾಶಿ.
List along with
Is the award matters, milord, we filed appeals against it maybe.
15.
15. Appeal is filed, milord. Similar matters where this is also with respect to.
list along with WA award. And this number is.
May be permitted to file objection to IA number 5, Lordship.
No, this is the last hearing, my lord. My lord has directed to my brother to give the visitation rights in writing. So today morning I served the copy of the objection statement to the application for the interim custody. And I am going through suddenly the proposal which have been given seems to be unreasonable. At least because very purpose of which seeking interim custody of child is that the bond between the child and the father should not be destroyed or destructed. But in fact, in the last occasion when he visited the residence, my lord, he don't want to put everything verbal in the open court. He made notes of what has been transpired on the last occasion. What happened, he has visited the child.
Clients ಹೇಳಿದ್ದಾರೆ.
Because child is in the custody of the.
ಚಾಕ್ಲೇಟ್ ತೊಗೊಂಡೇನು? ಚಾಕ್ಲೇಟ್ ಬ್ಯಾಗ್ನಾಗ ಇದೆ ನೋಡಿ. ಸ್ವೀಟ್ಸ್ ಅದೊಂದು ಲಾಂಗ್ ಇದು ಒಂದು ಚಿಕ್ಕದು ಇದೆ ಪ್ಯಾಕೆಟ್ ಇದೆ ಚಾಕ್ಲೇಟ್.
May I request my lord to have some word with the child and the parents in the chamber so that.
Chamber. 115 ಬರ್ತೀರಾ?
ಬರ್ತೀವಿ madam.
Please. 110 ಬನ್ನಿ.
1 o'clock ಬನ್ನಿ. Just 1 o'clock.
1 o'clock, no issue, my lord.
Please.
Along with check.
Please.
ಬಹಳ ಓಪನ್ ಮೈಂಡ್ ನಿಂದ ಬರಬೇಕು. ಒಂದ್ ಪುಟ್ ನಮ್ ಕೋರ್ಟ್ ಸುತ್ತಲೂ ಒಂದ್ ಪುಟ್ ಇದು ಪುಣ್ಯ ಭೂಮಿ ಇದು. ಒಂದ್ ರೌಂಡ್ ವಾಕಿಂಗ್ ಹೋಗಕ್ ಹೇಳಿ ಇಬ್ರಿಗೂ. ವಾಕ್ ಮಾಡ್ಕೊಂಡು ಶಾಂತವಾಗಿ ಬರ್ಬೇಕು ಮಗನ್ ಜೊತೆ. ಮಗನ್ ಕೈ ಹಿಡ್ಕೊಂಡು ಇಬ್ರು ಒಂದೊಂದ್ ಕೈ ಹಿಡ್ಕೊಂಡು ಹೋಗ್ಬನ್ನಿ. Then you come to the chamber. We'll see that. Eh? Okay.
ಅವ್ರ ಜೊತೆ ಕರ್ಕೊಂಡು ಹೋದ್ರೆ ಒಂದು ರೌಂಡ್ ಹಾಕಿ ಬಂದು
The DGO, my lord, at the relevant of time, is working in the, my lord, case worker in the deputy commissioner office. My lord, the allegation against him, my lord, the one complainant challenged the, my lord, sale deed.
Vasanti Amarnalli, after 6 months not maintainable.
That is, what is the difference, my lord? The tribunal has considered this case as a grievance.
Complaint
Yet,
ಅಂತ ತಗೋಬೇಕಿತ್ತು.
this is not a grievance, it's an allegation.
Allegation ಆಗ್ತದ.
Allegation ಆಗುತ್ತೆ. When they made a
Is defined. Complaint is
complaint,
also.
the grievance is
Two
entirely
different
different.
actions.
If it is not a grievance, then 6 months. For
Not
the,
for,
no, not. At least notice, my lord.
He comes with lot of preparation. ಚೆನ್ನಾಗಿ ಮಾಡ್ತಾನ ಅವ. ಗಿರೀಶ.
Accepting the cost of production of so and so, dismissed for the time being.
Please, I appear for the bill.
Ha.
Lord, the state has challenged the order passed by the tribunal, wherein on the basis of the criminal acquittal case, my lord, the KT has allowed the application taking.
PV ರುದ್ರಪ್ಪ ಆಗ್ತದೆ ಅದು.
ಅಲ್ಲ, ಅದು ಹತ್ತೋದಿಲ್ಲ ಅಂತ. ಯಾಕಂದ್ರೆ my lord, as per the evidence, charges have been proved before the disciplinary authority. But the acquittal was prior to the charges which have been proved. That was in the year 2012, my lord, the session court has acquittal on the basis that the prosecution failed to establish their.
Come to finding Bari.
My lord, the reasoning assigned by the special court in see at page 115.
Acquittal ನಲ್ಲಿ ಮಾಡುವಾಗ ಏನಂತ ಹೇಳಿದ್ರು ಕೋರ್ಟ್ನವರು?
Acquittal, may I take ಅದಕ್ಕೆ page 115.
115.
Yes, my lord. In the middle of that page, internal page number 37, my lord.
Hence the evidence.
Yes, my lord. Further, the investigation officer has not investigated the matter fairly, and evidence on record discloses that after getting touched the amount from the accused, his hand was washed or taken. The prosecution is also not able to play the material place on evidence that is the so and so. The evidence of witness is inconsistent and contrary in this regard. Apart from that, though the accused has no financial powers regarding STMC accounts, he has right to monitor the work, and there is no evidence to show that the STMC authorities and complaint have maintained the accounts pertaining to the installments released to the additional. The accused cannot be held to sit blindly when low quality of construction was going on and the account and being maintained being a responsible of it. Hence, the evidence on record clearly established that the prosecution has failed to bring home the guilt of the accused beyond reasonable doubt. Further, the citations relied so and so. On this basis, my lord, the sessions court has acquitted. Taking this fact, my lord, the KAT, this is the second round of litigation.
ಅಲ್ಲ ಅಲ್ಲಿ ಮುಂದೆ ನೋಡಿ.
Please.
The present case in hand,
Yes,
in view of absence of proper evidence of demand and acceptance.
Yes.
Demand acceptance ಸ್ವಲ್ಪ ಏನಾರ
Allah, but in the evidence, my lord, during the course of disciplinary incident, he has stated that, and the disciplinary authority has come to the conclusion, shadow witnesses have not supported the case of the prosecution in the disciplinary proceedings.
ಅದನ್ನ ಬಿಟ್ಕೊಂಡ್ರೆ ಬೇರೆ ಫೈಂಡಿಂಗ್ ಏನಿದೆ?
ಬೇರೆ ಫೈಂಡಿಂಗ್ ಏನಿಲ್ಲ.
ಫೈಂಡಿಂಗ್ ಇನ್ ಯುವರ್ ಫೇವರ್, madam?
My lord, senior counsel is appearing provisional.
I'm for the petitioner, respondent number, my lord, serial number, page 340, my lord, of the tribunal's order. Page 340.
Tribunal's order ಬಿಡಿ, that is put in challenge. Now go show PV ರುದ್ರಪ್ಪ attract ಆಗ್ಲಿಕ್ಕೆ 5 parameters ಯಾವ್ದು ಬರ್ತದೆ?
Lord, none of the witnesses have, my lord, supported the case of the prosecution, my lord.
ಅದು ಅಷ್ಟ ಆಗಲ್ಲ.
Yes, my lord, that is what has been categorically stated, and my lord, the documents and material evidences that were relied on in the criminal case, my lord, were also the basis for the findings of the inquiring authority, my lord.
ಅಲ್ಲಿ absence of evidence ಅಂತ ಹೋಲ್ಡ್ ಮಾಡ್ಯಾರ. absence of evidence ಇದ್ರೆ one of the postulates ಆಗಲ್ಲ PV ರುದ್ರಪ್ಪದಲ್ಲಿ.
Lord, here, my lord, even the evidence, my lord, of the witnesses, my lord, has not supported the case of the in the inquiry, my lord. That is the finding, my lord.
Inquiry ಅಲ್ಲಿ ಸಪೋರ್ಟ್ ಮಾಡಿಲ್ವಾ?
ಇಲ್ಲ.
ತೋರಿಸಿ.
The page 342, my lord.
Page 300
242, my lord.
242 ನಾ? ಏನ್ ಕರೆಕ್ಟ್ ಮಾತಾಡೋದಿಲ್ಲ. ಕ್ಲಾರಿಟಿನ ಇರಲ್ಲ ಲ್ಯಾಂಗ್ವೇಜ್ ನಲ್ಲಿ, ಕೊನೆ ಅಕ್ಷರ ನುಂಗಿ ಬಿಡೋದು, ಇದನ್ನ ಮಾಡೋದು. Page number
342, my lord.
The order of the tribunal atu, that is put in challenge.
Yes, my lord.
Independently show us. Where is that
Right.
material to show?
My lord, that is at
Nothing
page.
can be gained from that.
PW1, in the cross examination, my lord.
PW1 is complainant.
Yes, my lord.
At page 300, page 300, cross-examination of the complainant. Cross-examination.
300.
Yes, 300.
Lord, I'm reading at the last line in the cross-examination page, my lord, page 4, my lord, ink page. The DGO and the engineer came and inspected the building. It is not true to say that at the time it was noticed that the construction was substandard. It is also not true to say that on that day we did not give proper account to the DGO. It is not true to say that as the work of the substandard and accounts were not proper, DGO stopped the payment by telephoning the bank manager. It is true to say that DGO has telephoned to the bank manager, MG Bank, and not to make payment to us. After the said stop payment directions by DGO, the building management committee has held a meeting. After said stop payment direction by the DGO, we have not approached DGO with necessary documents. We have also not approached the DDPI in that regard. This shows, my lord, that the intention of PW1 was, my lord, because he has directed to make the stop payment, my lord, he had with an intention, my lord, has proceeded to, my lord, file a complaint. In the school management committee, there was a discussion to give complaint to Lokayukta against the DGO. The first, I wrote the complaint in Lokayukta office. The Lokayukta police corrected the same, and then I prepared and a fair complaint as per Exhibit P1. It is not true to say that on the instructions of police to make out a case against DGO, I wrote the complaint. It is not true to say that on the instructions of police, I wrote last sentence saying that DGO forced to pay 10,000. At about 5:30 p.m. On 25/3/2008, I gave the complaint. I alone went to the Lokayukta office and gave the complaint. It is true to say that SDMC meeting was advised to give complaint, and as per the say of member, I gave the complaint. The said bribe amount of rupees 10,000 produced by me was my personal money. It is not true to say that no witness were summoned by the Lokayukta office, no procedure were held by writing in entrustment measure Exhibit P2 in my presence. It is not true to say that without knowing the content of P2, I signed the same. It was about 6:30 p.m. when the entrustment measure was completed in Lokayukta office. On the same day at about 8:15 or 8:30 p.m., the police took all to Chikkodi. It is true to say that I alone went inside the house of DGO and Shadow Pancha CW2 was outside the house of DGO. Lord, this is what is very relevant, my lord, because in the cross-examination of PW2 at page 259, my lord.
259, huh?
That is in the writ petition, my lord, at page
Criminal court ಮಾಡಿದ್ದು discharge acquittal? Acquittal.
Yes.
Why the tribunal is saying discharge?
Oversight, my lord.
Oh, the quotation from some other judgment.
Yes.
Not this judgment. He refers to that ಇಲ್ಲಿ ಒಂದು page 259. The court has referred to other judgment of this was a case of discharge. Discharge is the ಪ್ರಶ್ನೆ. ಒಂದ್ಸರಿ ಟ್ರಯಲ್ ಸ್ಟಾರ್ಟ್ ಆಯ್ತು ಅಂದ್ರೆ either it has to end in conviction or acquittal.
Yes. Yes. Lord, this is annexure A20, my lord. I'm reading the deposition of
page number ಏನದು?
Lord, A21, my lord. Deposition of PW2 shadow witness, my lord.
Page number 286.
PW1.
Yes, page 292, 821.
ಯಾವುದು?
821, PW
Shantavir Gowda.
292, page
He
number
was
292.
21.
Yes,
Shantavir Gowda, he was a shadow witness, my lord. But cross-examination is 293, my lord, page. In the middle, my lord, when we went to the house of DGO, the main door of the DGO house was closed. CW1 pressed the calling bell for the bell of the house of DGO, and then somebody opened the door. I do not know who opened the door. I was standing at a distance of 15 feet from the main door of the DGO house.
ಫೆನಾಪ್ತಲಿನ್ ಟೆಸ್ಟ್ ಪಿಂಕ್ ಟೆಸ್ಟ್ ಏನಾಯ್ತು?
Blood, actually, the money was kept on the teepie of the house of the respondent, my lord. Blood, the investigation officer directed him to pick up the notes and then hand it over to him. At that stage, my lord, they proceeded to, my lord, conduct the phenolphthalein test, my lord.
Lord, may I
ಪಿಕಪ್ ಮಾಡ್ಕೊಂಡು ಹೇಳಿದ್ಮೇಲ
take it to Lord's
Yes,
page 220, 220. That is the impugned order which was challenged by the respondent before. That is the annexure A17, page 220. Internal page number 4. ಅಲ್ಲಿ ಕ್ಲಾಸ್ ಕಂಡೀಷನ್ PW2 ಶ್ರೀ ಶಾಂತವೀರ್ಯ ಸೋ ಅಂಡ್ ಸೋ ಟ್ರ್ಯಾಪ್ ಪೂರ್ವದಲ್ಲಿ
Blood.
Your suggestion is denied by them. You suggested. ಆ ಟಿಪಾಯಿ ಮೇಲೆ ಹಣ ಇತ್ತು, ಆ ಹಣನ ತಗೊಳಪ್ಪ ನೀನು ಅಂತ ಅನ್ಕೊಂಡು ಹೇಳಿದ್ರಿ, ಅವ ತಗೊಂಡ ಮಾಡಿದಾರ ಅನ್ನೋದು ನಿಮ್ ಸಜೆಷನ್ ಅದು.
Your Lordship may kindly come to the suggestion, the page 26, my lord, the deposition of PW2, my lord, at page 293, my lord.
293.
Yes, my lord, the cross-examination starts on the last page of the cross-examination. Blood.
294.
Yes, my lord. Page number 4, my lord. Lord, after CW1 gave the amount to DGO, both of them went inside the house of DGO, and CW1 was inside the house of DGO at for about 5 to 10 minutes. It is true to say that after CW1 gave signal, myself, CW1 and police staff went inside the house of DGO. It is true at that time the amount was on the teapie on the house of DGO.
It is true to say that said.
Yes, sir.
ಎಂತದ? It is true to say 295.
Yes, sir. 290.
After CW1 gave signal, myself, police staff went inside the house of DGO. It is true at that time the amount was on the teapot in the house of DGO. At that time, 2-3 neighboring house people were present apart from DGO's family members. It is true to say at that time, one person was in the house in DGO. It is true to say that said Professor made Galata saying that DGO had not taken the money and he has not touched the money, and made Galata saying that CW1 has kept the amount. It is true to say that the wife and children also started crying. It said that hence the police took DGO along thus to the IB. It is true to say that said Professor also came to the IB and made Galata. It is true to say that. Ivaru yaru Professor Mutnal yaru avaru?
He was there inside the house, my lord. He was a friend of the respondent. The trap took place in his residence, my lord.
No, ಆ ಅಮೌಂಟ್ ಟಿಪ್ಪೈ ಮೇಲೆ ಇರುವಂತ ಅಮೌಂಟ್ ಅನ್ನ ನೀನು ಹಿಡಿಯಪ್ಪ ಹಿಡ್ಕೋ ಅಂತ ಅನ್ಕೊಂಡು ಹೇಳಿದ್ದೆಲ್ಲಿದೆ? ನಿಮ್ ಸಜೆಷನ್ ಆಯ್ತು. ಎನಿಥಿಂಗ್ ಕ್ಯಾನ್ ಬಿ ಸಜೆಸ್ಟೆಡ್.
My lord, CW1 has kept the amount on the teapie. It is there, my lord. He has not touched the money and made Galata saying that CW1 has kept the money on the teapie.
took amount
Which he told.
from shirt pocket and gave to DCO.
Gave to DCO.
You gave to DCO ಅನ್ಕೊಂಡು ಒಂದಿದೆ, ಟಿಪಾಯಿ ಮೇಲೆ ಇಟ್ಟಿದ್ರು ಅಂತ ಇನ್ನೊಂದು ಕಡೆ ಇದೆ. Then DGO received the amount and went inside and kept on it, DGO himself.
And kept on the teapot.
ಟಿಪಾಯ್ ಅಂತಿದೆ ಅದು. ಇದು ಚೀಫ್ ಇದು.
So if teapot is legal, suggestion. Received item.
Received ಆಗುತ್ತೆ ಇದು.
DGO received the amount. Went inside and kept on.
Correct ಇದೆ ಆರ್ಡರ್, ದಿ ಪನಿಷ್ಮೆಂಟ್ ಆರ್ಡರ್ ಕರೆಕ್ಟ್ ಇದೆ. ಏನ್ ಪನಿಷ್ಮೆಂಟ್?
Compulsory, dismissal from service, dismissal from service.
Dismissal from service.
ಅವಾಗ ಆಪ್ಷನ್ ಇರೋದೇ ಇಲ್ಲ ನಾವು.
ಹೌದು. And he has been now retired from service.
Retired from service. ಎಷ್ಟು ವರ್ಷ ಸರ್ವಿಸ್ ಆಗಿತ್ತು?
As on the date of filing, he was 6/8/2023, he was retired from service.
ಟ್ರೈಬ್ಯುನಲ್ ಫೈಂಡಿಂಗ್ ಹೆಂಗಿದೆ?
My lord, may I take you to lordship at
Mercy.
page 344.
This is with regard to the finding of the trial court, my lord.
It is not due to last 296 money. Last 4 or 5 lines ಓದಿ. It is not true to say that the amount was kept by C.W.1 on the teapoy and police forcibly got that amount removed from DGO and then washed the hands of DGO. They have denied. ನೀವು ಸಜೆಸ್ಟ್ ಮಾಡಿದ್ರೆ ಅದನ್ನ ಡಿನೈ ಮಾಡ್ಯಾರ.
But my lord, it has come on record that the money was kept on the teapot, my lord.
That is the question. ಅದನ್ನ ಹೆಂಗ್ ನಾವು ಡಿಸೈಡ್ ಮಾಡೋದು? ನೀವು ಹಾಗಂತೀರಿ, ಇಲ್ಲ ಅಂತಾರೆ.
Lord, in the trial court, my lord, the trial court has come to conclusion that the money was kept on the teapot, my lord, without the knowledge of the respondent. My lord, that is what the finding of the trial court, my lord.
It is a finding of
344, my lord. 344.
344.
Yes. The reasoning for coming to the conclusion on perusal of the order passed by the sessions court, so and so.
ಆ ಎವಿಡೆನ್ಸ್ ಅಲ್ಲಿ ಇದೆ. ಆಫ್ಟರ್ ಗೆಟ್ಟಿಂಗ್ ಇದು ಹಿಂಗೆ ಹೇಳ್ತಾರಲ್ಲ ಇವರು, ಫೈಂಡಿಂಗ್ ರೆಕಾರ್ಡ್ ಮಾಡ್ಯಾರ ಕ್ರಿಮಿನಲ್ ಕೋರ್ಟ್. ಆಫ್ಟರ್ ಗೆಟ್ಟಿಂಗ್ ಟಚ್ ದ ಅಮೌಂಟ್ ಫ್ರಮ್ ದ ಅಕ್ಯೂಸ್ಡ್ ಬೈ ಹ್ಯಾಂಡ್ ವಾಸ್ ಟೇಕನ್ ಅಂತ. ಅಕ್ಯೂಸ್ಡ್ರಿಗೆ ಮುಟ್ಟಿಸಿ ಆಮೇಲೆ ಇದನ್ನ ಅಮೌಂಟ್ ಅಂತ ತಗೊಂಡಾರೆ ಅಂತ ಒಂದು ಫೈಂಡಿಂಗ್ ಇದೆ.
The finding given by the special court, that is at para 100, page number 100.
ಅವ್ರನ್ನೋದು ಮನೆಯಲ್ಲಿ ಹೋಗಿ ಆ ಟಿಪಾಯಿ ಮೇಲೆ ದುಡ್ಡು ನೀವೇ ಇಟ್ಟಿದ್ರಿ, ಆಮೇಲೆ ಅದನ್ನ ಫೋರ್ಸಿಬಲಿ ಅವನ ಕೈಯಿಂದ ತಗೋ ಅಂತ ಹೇಳಿ ತೋಳ್ಸೊಂಡ್ರಿ. ಹಂಗೆಲ್ಲ ಮಾಡ್ತಾರ ಅವರು. ಅಂತ ಕೇಸಸ್ ಇದೆ, ರಿಪೋರ್ಟೆಡ್ ಕೇಸಸ್ ಇದೆ ಕೆಲವು. ಇವ್ರಂತಲ್ಲ, ಇಟ್ಸ್ ಪಾಸಿಬಲ್ ಅಂತ ಅವ್ನಿಗೆ ಹೆದರಿಸಿ ಮಾಡಿ. ಫ್ಯಾಮಿಲಿ ಮ್ಯಾನ್ ಇರ್ತಾನೆ, ಮಕ್ಳು ಇರ್ತಾರೆ, ಹೆಂಡತಿ ಇರ್ತಾಳೆ.
That can be also. That can be also happen.
ಇದು ಬೇರೆ
page 100 my lord.
100.
ಹೌದು. ಅದಾದ್ಮೇಲೆ next the tribunal has come to the conclusion that page 100 para 23. This is with regarding to the deposition of that place.
ಅಕ್ಯೂಸರ್ ಕೈ ತೊಳೆಯಕ್ಕಿಂತ ಮೊದಲು ಆಲ್ರೆಡಿ ಇದನ್ನ ಮಾಡಿಬಿಟ್ಟಿದ್ರು, ಅಮೌಂಟ್ ಸೀಜ್ ಆಗಿತ್ತು.
That is, but the Sessions Court comes to the conclusion that there is inconsistency and counter statements have been given by the witness. But PW4 has admitted that.
But at page 101, my lord, the finding of the trial court, my lord. There is no cogent evidence as to by which hand the
That is
conviction demand and acceptance evidence, cogent evidence illa. That does not mean there is no evidence at all. Cogent evidence illa anta ondeno ಒಂದು adjective ಉಪಯೋಗಿಸಿದ್ರು ಅವರು.
But my lord, the evidence discloses that the accused was forced to touch the amount found on teapoy. This is the finding, my lord. And then his hands were washed.
ಎಲ್ಲಿ ಓದಿ?
Blood. Page 101, my lord. The evidence discloses that the accused was forced to touch the amount found on teapoy, and then his hands was washed. Hand wash was taken. As such, taking into consideration these admission with the hand wash of the accused turning into pink does not carry much importance.
The accused was forced to touch the amount found on teapoy. ಇದ್ರ ಮೇಲೆ ಅಪೀಲ್ ಏನು ಹಾಕ್ಲಿಲ್ಲ?
Appeal has been filed, my lord.
ಇಲ್ಲಿ ಬನ್ನಿ 101 ಬನ್ನಿ.
Yes, I have gone through.
ನಿಮಗೆ ಎಷ್ಟು ಹೋಗುತ್ತೆ?
But further, my lord, further, may I take it to lordship?
ಅವ್ನು ಮುಟ್ಟಿಸಿ ಡೆಲಿಬರೇಟ್ಲಿ ಅವನನ್ನ ಸಿಗಿಸ್ಬೇಕು ಅನ್ನೋ ರೀತಿ ಕಾಣ್ತದೆ ಕೇಸ್. ಆಮೇಲೆ ಇಲ್ಲಪ್ಪ ಅಂದ್ರೆ ಅಲ್ಲಿ ಹೋದಂತ ಮುದ್ನಾಳ್ ಪ್ರೊಫೆಸರ್ ಮುದ್ನಾಳ್, he would not have made ಗಲಾಟ. ಫ್ರೆಂಡ್ ಹೋಗ್ಬಿಡ್ತಿದ್ದ, ಏನೇನ ಆಗಿದೆಯಪ್ಪ ಇದು ನಮ್ಗೆ ಸರಿಯಾಗಿ ಗೊತ್ತಾಗಲ್ಲ. He was there. His conscience was hurt. ಮತ್ತೆ ಹಿಂಗಿದೆಯಲ್ಲ ಫೈಂಡಿಂಗ್, ಏನ್ ಮಾಡೋದು?
Thereafter, my lord, may I take lordship at page 104.
104.
ಅಲ್ಲಿ PW9 would have been the best witness for clarifying. The lordship's got.
ಅದು
PW9 would have
hence the evidence of PW9.
Yes. ಅಲ್ಲಿ ಮೇಲ್ಗಡೆನೆ
established that he did not even
ಅಲ್ಲಿ ಕನ್ನಡದ ಎಕ್ಸ್ಟ್ರಾಕ್ಟ್ ಮಾಡಿದ್ದಾರೆ.
ನಾವು ಹೋದ ತಕ್ಷಣ ಅಪಾದಿತ ಕೈಗಳನ್ನು ಹಿಡಿದುಕೊಳ್ಳಲಿಲ್ಲ, ಆದರೆ ನಾವು ಸುತ್ತುವರೆದು ನಿಂತುಕೊಂಡೆವು. ಆ ಸಮಯದಲ್ಲಿ ಅಪಾದಿತನ ಯಾವ ಕೈಯಲ್ಲಿ ಹಣ ಇತ್ತು ಎಂದು ಹೇಳಲು ಆಗುವುದಿಲ್ಲ. ಆ ಸಮಯದಲ್ಲಿ ಹಣ ಹೊರತುಪಡಿಸಿ ಅಪಾದಿತ ಕೈಯಲ್ಲಿ ಬೇರೆ ವಸ್ತುಗಳು ಇದ್ದ ಬಗ್ಗೆ ನಾನು ಗಮನಿಸಲಿಲ್ಲ.
This was the evidence given by PW9, my lord. But established that he did not even apply his mind for proper investigation. He was the investigation officer.
ಒಬ್ರು ಒಂದ್ ಕೈಯಿಂದ ಮುಟ್ಟಿರು, ಇನ್ನೊಂದ್ ಕೈಯಿಂದ ಮುಟ್ಟಿರು ಅಂತ ಹಿಂಗೆ
ಅದಕ್ಕೆ for that reason the special court comes to the conclusion there is a contrary and inconsistency in evidence.
ಅಷ್ಟಲ್ಲ, ಬೇರೆ ಕಾಂಟ್ರರಿ ಇದ್ರೆ ನಾವು ಅಷ್ಟೇ ಕೆಡಿಸುತ್ತಿರ್ಲಿಲ್ಲ.
Inconsistent
ಅಮೌಂಟ್ ಅನ್ನು ಅಲ್ಲಿ ಒಯ್ದು ಇಟ್ಟು ಆಮೇಲೆ ಅವನ ಕೈಯಿಂದ ಮುಟ್ಟಿಸಿ ಅದಾದ್ಮೇಲೆ ಕೈ ತೊಳ್ಸಿದ್ ಮತ್ತೆ ಹಂಗೆ ಬರುತ್ತದು. ಎಲ್ಲ ಪೊಲೀಸರು ಅಷ್ಟೆಲ್ಲ ಸೇರ್ಕೊಂಡು ಬಂದ್ರೆ ಅವ ಏನ್ ಮಾಡ್ತಾನೆ ಕಾಮನ್ ಮ್ಯಾನ್? ಅದು ಹಂಗೆಲ್ಲ ಮಾಡಿದ್ ನೋಡಿ ಆ ಪ್ರೊಫೆಸರ್ ವಾಸ್ ಹರ್ಟ್, ಅವ್ರ ಹಿಸ್ ಫ್ರೆಂಡ್ ವಾಸ್ ಹರ್ಟ್. ಅವ್ರು ಈ ಮೇಡ್ ಗಲಾಟ, ಏನ್ ಮಾಡ್ತಾ ಇದ್ದೀರಿ ನೀವು ಅಂತ. ಒಂದು ನಂತರ ಈವನ್ ದ ವಿಡಿಯೋಗ್ರಾಫ್ ಡಿಡ್ ನಾಟ್ ಸಪೋರ್ಟ್ ಕೇಸ್ ಆಫ್ ದಿ ಪ್ರಾಸಿಕ್ಯೂಷನ್. ಏನಿಲ್ಲ, ಏನೋ ಸುಳ್ಳು ಸಿಗಿಸ್ಲಿಕ್ಕೆ ಹಿಂಗ್ ಮಾಡಿರಿ ಅಷ್ಟೇ. ಪ್ಲೀಸ್. The tribunal has structured its judgment on the principles that have been discussed elaborately in PV Rudrappa. A case refer madilla.
That has been,
although the said case has not been referred to, first off. But the cases referred in PV Rudrappa are referred by the tribunal. First off, the criminal court has recorded a specific finding that goes blatantly against case of that went blatantly against the case of prosecution. Full stop. In the parameters fixed by Rudrappa, comma, one can safely say with no risk of contradiction that it is a case of honorable acquittal, comma, notwithstanding such a terminology is not employed by the criminal code which handed acquittal. First, on being asked, comma, we are told at the bar that no appeal is preferred against the acquittal order. First, all aspects having been examined by the tribunal, comma, the impugned order has been made and it does not call for our interference.
Please. Respond number 2 is Lokayakta. Respond number 2, Anil Kale has been.
Anil Kale.
Please.
ಅವ್ರು ಹೇಳಿ ಮಾಡಿದ್ದೇವೆ ನಮಗೊಂದು ಚೇಂಬರ್ ಹಿಯರಿಂಗ್ ಇದೆ ಇವನ್ ಅದರ್ವೈಸ್ ವಿ ಕಾಲ್ ಇಟ್ ಅರ್ಲಿ ಬಿಕಾಸ್ ವಿ ಹ್ಯಾವ್ ಟು ಸೈನ್ ಸೋ ಮೆನಿ ಆರ್ಡರ್ಸ್ ಅದರ್ವೈಸ್ ಎಂಟ್ರಿ ಮಾಡಿ ಹಂಗೆ ಉಳ್ಕೊಂಡ್ಬಿಡ್ತು ಇದೊಂದು 23.25 Yes.
Past over matter. Number 1, Sanjay Katagiri.
Three fractures and 50 days medical 1,83,000. PW3 doctor do not indicate due to fracture of the spinous and vertebral, and on that basis, my lord, he has assessed 38% descent. The tribunal has taken 20% to the whole body, 38% to the whole body itself, as per exhibit P25. But it is just as reasonable it is taken without any basis.
ಆಮೇಲೆ 1/3 ತಗೋಬೇಕು.
ಕಡಿಮೆ ತಗೋಬೇಕಾಗುತ್ತೆ.
ಇದಕ್ಕಿಂತ ಕಡಿಮೆ ತಗೋಬೇಕಾಗ್ತದೆ.
1/3 ತಗೊಂಡು
ನಾರ್ಮಲಿ
ಎಲ್ಲಿದೆ ಎಲ್ಲಿ ವೇರ್ ಇಸ್ ದ ಜಜ್ಮೆಂಟ್?
ಎಷ್ಟು 12
following a tender
E1 to E6 are the fracture. E1 to E6 and fracture of the vertebra C1.
ಆಯ್ತು, ಬಟ್ he is not
Nature of injury is as like around 1,83,000.
PW3 himself has 38% to the whole body.
Yes,
He is not a treated doctor.
Tribunal is considered 20%.
1/3 was not justified. It's not 1/3.
Not is 1/3. It's
More than
1/3.
No, no, 1/3 is not. He has not
50%.
assessed for particular limb. To the whole body was also.
He has taken
To the whole body. So he is not treated.
All right. What is the which limb you have to take? She is a tailor. Which is the functional limb?
He says the spine and everything is there. Can't see properly, can't do the work itself. Vertebra and itself is there, not for tibia, fibula or other injuries. So that is the reason, my lord, we gave a proposal of 2,79,000 Lokadala. On the last more than 4 or 5 Lokadala, they did not turn up.
ಬಹಳ ಜಾಸ್ತಿ ಕೇರ್ ಅವ್ರು ಏನ್ ಮಾಡ್ತಾರೆ ಪಾಪ.
So the disability itself would be more than.
Even then, the income is taken more at that time. It was the income was taken more than 10,000 they have taken. Actually on that period, as per Lokadal chart, it was 8,750.
Chart value 8,000.
It's 750. 8,750 is it?
ಅದು ಹೆಚ್ಚಾಯ್ತಲ್ಲ ಸಂಜಯ್.
10th.
So far as income is concerned, is 2,004. So far disability is concerned, quite on the lower side. Had it given us to the particular parts of limb, may not have been agreed.
That will compensate other side also.
ಎಷ್ಟು ತಗೋಬಹುದು?
Taking the more in the income.
ಜೋಶಿ ಸರ್ ಎಷ್ಟು ತಗೋಬಹುದು? ಇನ್ಕಮ್ ಆಯ್ತು ಇರ್ಲಿ, ಇವಾಗ ತಗೊಂಡಿದಾರಲ್ಲ ಟೇಲರ್ ಚಾರ್ಟ್ ಅಂತ ಹೇಳಕ್ ಆಗ್ಲಿಕ್ಕಿಲ್ಲ. ಬಟ್ ಇದು ಡಿಸಬಿಲಿಟಿ ಇನ್ನು ಎಷ್ಟು ಹೆಚ್ಚು ಮಾಡಬಹುದು ತಾವು ಹೇಳಿ, ಫೇರ್ನೆಸ್ ಇಂದ ಹೇಳಿ ನೋಡೋಣ. ತಗೊಳ್ಳೋಣ ಅದಕ್ಕೆ ತಮ್ಮ
ಈಗ almost he has taken 50%. 38 ಅಂದ್ರೆ 20% ತಗೊಂಡಾರ.
ಎಷ್ಟು ತಗೋಬೇಕು ಹೇಳಿ ಇವಾಗ? ಆಯ್ತು, ಇನ್ನದ್ರ ಬಗ್ಗೆ
It depends upon the limb.
Because even the PW3 and the doctor is not a treated doctor ಅಂತನ observation ಅದ.
ಆಯ್ತು ಸರ್, ಎಷ್ಟು ತಗೋಬಹುದು ಹೇಳಿ?
ಸ್ವಲ್ಪ ಆ ಕಡೆ ನೋಡ್ಕೊತಾನೆ ಹೇಳ್ಬಿಡಿ.
And 25 matters.
25. Yes, very fair. 10,000 ಅದೇನು ಡಿಸ್ಟರ್ಬ್ ಮಾಡಲ್ಲ.
ಅದಿಲ್ಲ.
ಅದೇನಾಗಿದೆ, ನೀವೇನ್ ಚಾಲೆಂಜ್ ಮಾಡಿಲ್ಲ.
25% ಪೇನ್ ಅಂಡ್ ಸಫರಿಂಗ್ ಎಲ್ಲ ಸ್ವಲ್ಪ ಜೋಶಿ ಸರ್ ಒಂದ್ಸತಿ ತಾವು ನೋಡಿರಿ.
Mr. Joshi has to take some pains to see.
I have seen, I have given the actual calculation.
40,000 ಸರ್ ಪೇನ್ ಅಂಡ್ ಸಫರಿಂಗ್ 30 ಇದೆ.
Another
40.
Another 20,000 ಕೊಡ್ರಿ ಸರ್.
ಯಾದಕ್ಕೆ?
Another 20 pain and suffering.
50,000 ಮಾಡ್ತೀನಿ ಟೋಟಲ್.
Medical expenses as it is.
ಇದೆ. ಫುಡ್ ನರಿಶ್ಮೆಂಟ್, ಅಟೆಂಡೆನ್ಸ್ ಚಾರ್ಜಸ್ ಅದೆಲ್ಲ ಕರೆಕ್ಟ್ ಆಗಿದೆ. ಕನ್ವೆನ್ಷನ್ ಚಾರ್ಜಿಂಗ್ ಜಾಸ್ತಿನೇ ಕೊಟ್ಟಿದಾರಲ್ಲ.
ಮೆಡಿಕಲ್, ಫ್ಯೂಚರ್ ಮೆಡಿಕಲ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಫ್ಯೂಚರ್ ಮೆಡಿಕಲ್
ಟೀಚರ್
ಕೊಟ್ಟಿದ್ದಾರೆ.
ಮೆಡಿಕಲ್ ಕೊಟ್ಟಾರೆ.
ಲಾಸ್ ಆಫ್ ಅಮ್ಯುನಿಟೀಸ್
Life-
ಹೆಚ್ಚಾಗತ್ತೆ ಸರ್, ಅದು 40,000 ಮಾಡ್ತೀನಿ ಅಮ್ಯುನಿಟೀಸ್ ಸರ್.
Mas
ಎಸ್ ಎಸ್ ಆಯ್ತು ಡಿಸ್ಪೋಸ್.
16 इसके क्या एक मत ಬರೀ 16 ಹೋಗ್ತಾ ಇದೆ ಇವತ್ತು, ಮುಂದೆ ಹೋಗ್ತಾ ಇಲ್ಲ. ಹಾ ರೈಟ್
An application also pending regarding maintenance which I have filed.
ಕೊಡ್ಬೇಕಲ್ಲ ಅವರು.
ಅದು ಲಾಸ್ಟ್ ಮಂತ್ ಒಂದು, ಈ ಮಂತ್ ಅದು ಕೊಟ್ಟಿಲ್ಲ ಸಾಹೇಬ್.
ಎಲ್ಲಿ ಮಿಸ್ಟರ್ ಕೈಟ್ ಮಾಡಿ
ಪ್ರೀವಿಯಸ್ ಮಂತ್ ಲಾರ್ಡ್ಶಿಪ್ ವಾಸ್ ಪ್ಲೀಸ್ ಟು
ಕೊಡ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ರು.
ಪ್ಲೀಸ್ ಅದು ಐ ಪೆಂಡಿಂಗ್.
ಅಪಲೆಂಟ್ ವಾಸ್ ಹಿಯರ್ ನಾ, he said I am giving ತನ್ಕೊಂಡು ಹೇಳಿದಾರೆ ಅವರು. ಮತ್ತೆ ಅದಕ್ಕೆಲ್ಲ ಆರ್ಡರ್ಸ್ ಎಲ್ಲ ಯಾಕೆ ಬೇಕು? He himself be saying I will pay.
My only request is, since they don't pay maintenance towards the child is concerned, I have requested for enhancement of maintenance from 15 to 25. Lordship, kindly consider the child's maintenance is not paid.
ಚೈಲ್ಡ್ಸ್ ಎಷ್ಟಿದೆ?
A child is going to two.
ಸ್ಕೂಲ್ ಫೀಸ್ ಎಂಟರ್ ಸ್ಕೂಲ್ ಫೀಸ್
ಅದು ಕೊಡಿ.
ಪ್ಲಸ್ ಆ ಮಗುನ
some
ಸಾಕಿ ಸಲಹು ಮಾಡ್ಲಿಕ್ಕೆ
ಸ್ವಲ್ಪ ಏನು
some amount has to be
Yes.
ಕಳಿಂಗ್ ಕೊಟ್ಟವ್ರು ಎಷ್ಟು ಆರ್ಡರ್ ಮಾಡ್ಯಾರ?
15 ಮಗು ಕೊಟ್ಟಿಲ್ಲ ಸಾಹೇಬ್ರೆ.
ಕರೀತೀನಿ ಅಪಲೆಂಟ್ ಕರೀರಿ ಸರ್. ಅಪಲೆಂಟ್ ಸಂಜಯ್
ಮಗುಗೆ ಏನು ಕೊಟ್ಟಿಲ್ಲ ಸರ್.
ಮಗುನ್ ಸಾಕೋದು ಅಂದ್ರೆ ದೊಡ್ಡ ಕೆಲಸ ಅದು.
ತಾಯಿಗೆ ಎಷ್ಟು ಕೊಡ್ತಾ ಇದಾರೆ ಸರ್?
15 ಕೊಟ್ಟಾರೆ ಸರ್.
15,000 ಮಗುಗೆ ಏನ್ ಕೊಡ್ತಾ ಇದ್ದೀರಾ?
20,000 per month, but in last hearing they withdrawn the case in the district.
120.
Anyway, for child you have also affection for the child. ಚೈಲ್ಡ್ ಮಗುನ್ ನೋಡ್ಕೊಳ್ಳಿಕ್ಕೆ ಅದೊಂದು ದೊಡ್ಡ ಕೆಲಸ ಅದು. ನಾವು ನೋಡ್ಕೋತೆ ಕೊಟ್ಬಿಡಿ ಅನ್ನೋದು ಆನ್ಸರ್ ಆಗಲ್ಲ. ತಾಯಿ ಜೊತೆ ಮಗು ಇದ್ದಂಗೆ ಬೇರೆ ಜೊತೆ ಇರಲ್ಲ. ಅವಾಗ ಹಂಗೆ ಯಾವುದೇ ನೀವು ಅಪ್ಪ ಅಮ್ಮ ಇಲೆಕ್ಷನ್ ನಿಂತರು ಅಂದ್ರೆ ಅಮ್ಮಗೆ ಹಾಕೋದು ನಾವು ಓಟನ್ನ. ಬೈ ನೇಚರ್ ಹಂಗಿರ್ತದೆ, ಅಷ್ಟೊಂದು ಅಟ್ಯಾಚ್ ಇರ್ತಾರ ಅವ್ರು. ಹಂಗಾಗಿ ಮಗುಗೂ ಕೊಡಿ. ಅದರಲ್ಲಿ ಅಪಾರ್ಟ್ ಫ್ರಮ್ ದಿ ಸ್ಕೂಲ್ ಫೀಸ್ ಅಂಡ್ ಅದರ್ ಥಿಂಗ್ಸ್, ಪೇ ಸಮ್ ರೀಸನೇಬಲ್ ಅಮೌಂಟ್ ಫಾರ್ ದಿ ಮೇಂಟೆನೆನ್ಸ್ ಆಫ್ ದಿ ಚೈಲ್ಡ್ ಆಲ್ಸೋ. ಕೊಡ್ಬೇಕು. ಸಾಕು, 15,000 ರೂಪಾಯಿ 5,000 ರೂಪಾಯಿ ಮಗು. ಒಂದು 5,000 rupees ಕೊಡಿ. ಏನಿಷ್ಟ ಸ್ಮಾಲ್ ಥಿಂಗ್. ರೈಟ್ ಮಟ್ರೆ, ಈಗ ಲೇಡಿಗೆ 15,000 ರೂಪಾಯಿ ಇದು ಇದೆ ಮೇಂಟೆನೆನ್ಸ್. ಮಗುನು ಸಹಿತ ಅವಳ ಜೊತೆ ಇದೆ. ಮಗುಗೂ ನೋಡ್ಕೊಳ್ಳಿ ಕೊಡ್ಬೇಕಾಗ್ತದೆ ಅಮೌಂಟ್. ಮಗು ನಮಗ್ ಕೊಟ್ಟು ಬಿಡ್ರಿ ಅನ್ನೋದು ಆನ್ಸರ್ ಆಗಲ್ಲ, ಕಮೋಡಿಟಿ ಅಲ್ಲ. ಹಾ, she was earning even now.
Not on.
ಎಲ್ಲಿದೆ ಮಟೀರಿಯಲ್? ಎಲ್ಲಿದೆ ಪ್ರೂಫ್? ಏನಿದೆ? ಅಪ್ಲಿಕೇಶನ್ ಮಾಡಿ ಅಫಿಡವಿಟ್ ಹಾಕ್ಬಿಟ್ರೆ ಹಂಗಾಗಲ್ಲ. ಏನು ತೋರಿಸಿ. ಹಾ,
And thereafter, my lord, application section 3 of the CR has been filed to the trial court. Thereafter, they will do the petition.
It's all right.
This is what happened because
ಫ್ಯಾಮಿಲಿ ಮ್ಯಾಟರ್ ನಲ್ಲಿ the power of the court to treat a family cause is coextensive with the requirement. Whatever order, including arrest, detention, everything. That's how law has been structured now.
Under section 3 of 340 of CRPC, where a similar application has been filed before the trial court seeking materials. In after filing that application by the petitioner hearing, regarding under section 340, they will do the petition.
After filing here?
Yes, ma'am.
Correct.
After filing the application under section 340 of CRPC, the respondent will review the petition.
Where is the material to show? ತೋರಿಸಿ, ಏನ್ ಕೊಟ್ಟಿ ಫೈಲ್ ಇಲ್ಲ ನೋ ಇದೆಯಾ? ಈಗ ನೋಡಿ, ಮಗು ವಿಜಿಟೇಷನ್ ರೈಟ್ಸ್ ಪ್ರಶ್ನೆನೂ ಇದೆ. ಹೌದಾ? ಆಗಾಗ ನಾವಿಬ್ರು ಈಗ ಚೇಂಬರ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಹೋಲ್ಡ್ ಮಾಡಿದ್ವಿ. ಬೋತ್ ಅಪಿಯರ್ ಟು ಬಿ ರೀಸನೇಬಲ್. ಅವ್ರ ಕೇಸ್ನಲ್ಲಿ ಎಂತಾದ್ರೂ ರಿಫ್ಲೆಕ್ಟ್ ಆಗಿ. We spoke to them for a long time, to each of them. They appear to be, there are many gentle elements in their personalities. The cases highlight only the other elements. They also may be there, though not to that extent they are pleaded. Now, let him, for the time being, ಕಾಯಕ್ ಬಿಡಿ ಕೇಳಿ. ಈಗ ಮಗು ಅವ್ರಿಗೇನು ವೆಜಿಟೇಷನ್ ರೈಟ್ಸ್ ಏನ್ ಮಾಡಿದ್ದೇವಲ್ಲ, ಆ ರೈಟ್ಸ್ ಹಂಗೆ ಇರಲಿ. ಇವರು ಮನೆಗೆ ಹೋಗಿ ಮಗುನ ಕರ್ಕೊಂಡು ಹೋಗ್ಲಿ, ಆಯ್ತಾ? ಮನೆಗೆ ಹೋದ್ಮೇಲೆ ಒಳಗೆ ಬನ್ನಿ, ಕುತ್ಕೊಳ್ಳಿ, ಮಾತಾಡಿ. ಇದು ನಮ್ಮ ಕಲ್ಚರ್. ಇದು ಏನ್ ಬೇಡ, ನೀವು ಅದಕ್ಕೆ ನಾ ಏನ್ ಹೇಳಿದೆ, ನೀವು ಅಲ್ಲಿ ಹೋದಾಗ ಹೊರಗಿನಿಂದ ಎಂಟೈರ್ ವಿಡಿಯೋಗ್ರಾಫ್ ಮಾಡಿಬಿಡಿ. ಅವಾಗ ಯಾರು ಹೆಂಗ್ ನಡ್ಕೋತಾರೆ ಅಂತ ಗೊತ್ತಾಗಿ ಹೋಗ್ತದೆ. ಹಾ, ಈಗ ಮಾಡಿ ಇದು ಬಿಡಿ, ಅದು ಈಗ ಮಾಡ್ಕೊಳ್ಳಿ. ಇನ್ಮೇಲೆ ವಿಡಿಯೋಗ್ರಾಫ್ನಲ್ಲಿ ಯಾರು ತಪ್ಪು ನಡ್ಕೋತಾರಲ್ಲ ಅವರಿಗೆ ಈ ನಮ್ದು ನೆಗೆಟಿವ್ ವ್ಯಾಲ್ಯೂಯೇಷನ್ ಆಗ್ತದೆ ಕೇಸ್ನಲ್ಲಿ. ಗೊತ್ತಾಯ್ತಾ? ನೀವು ಅಲ್ಲಿ ಹೋಗ್ರಿ, ಮಗುನ್ ಕರ್ಕೊಂಡು ಹೋಗ್ಬೇಕಾರೆ ಅಲ್ಲಿ ಈಗ ಲೇಡಿ ಇಸ್ ರಿಸೈಡಿಂಗ್ ವಿತ್ ಹರ್ ಪೇರೆಂಟ್ಸ್ ಅಪ್ಸ್ಟೇರ್ಸ್ ನಲ್ಲಿ. Okay, parents are this one. You let your client go there. Okay, take the child, speak to the lady. After all, she is an estranged spouse. Both are estranged spouses, not enemies. Many estrangements happen between lawyers, judges inter se. Estrange, that's how life is. ಅದಕ್ಕೆ ಭಾಳ ತಲೆ ಕೆಡ್ಸೋಬಾರ್ದು. ನೀವು ಹೋಗಿ ಅವ್ರ ಮನೆಗೆ ಹೋಗಿ ಒಂದು 15 ನಿಮಿಷ ಅರ್ಧ ಗಂಟೆ ಕುತ್ಕೊಳ್ಳಿ, ಆಯ್ತಾ? ಕುತ್ಕೊಂಡು ಮಾತಾಡಿ, ಮಗುನ್ ಕರ್ಕೊಂಡು ಹೋಗ್ರಿ, ಮತ್ತೆ ಮಗುನ್ ಕರ್ಕೊಂಡ್ಬಂದು ಬಿಡಿ. ಅವ್ರು ತಪ್ಪು ನಡ್ಕೊಂಡ್ರು ಅಂದ್ರೆ ಇದು ಮಾಡೋ ಅಗತ್ಯ ಬೀಳೋದಿಲ್ಲ. ಬಟ್ ರೆಕಾರ್ಡ್ ಎವ್ರಿಥಿಂಗ್. ಹೌ ವಿಲ್ ನೋ ಶಿ ಡಿಡ್ ನಾಟ್ ಟ್ರೀಟ್ ಅಸ್ ವೆಲ್ ಅಂತ ನೀವು ಹೇಳ್ತೀವಿ. ಐ ವಾಂಟ್ ಹಿಮ್, ಹಿ ಇಸ್ ಮೈ ಹಸ್ಬೆಂಡ್ ಅಂತ ಅವ್ರು ಹೇಳ್ತಾರೆ. ನಾವ್ ಹೆಂಗಪ್ಪ ಡಿಸೈಡ್ ಮಾಡೋದು? Anyway, both are attached to the child. One happy thing is, he also wants the child, she also wants to retain the child. But unfortunately, ಈ ಕಿಂಗ್ ಸೊಲೊಮನ್ ಕತೆ ಗೊತ್ತಿದೆಯಲ್ಲ, ಮಗು ನಂದು ಅವ್ರದ್ದು ಅಂತ ನಡೆಯುವಾಗ ಸೊಲೊಮನ್ ಹೇಳ್ತಾನೆ, ಆಯ್ತು ಮಗುನ 2 ಭಾಗ ಮಾಡಿ, ಒಂದು ಭಾಗ ನೀ ಇಟ್ಕೋ, ಒಂದು ಭಾಗ ನಾ ಇಟ್ಕೋತೀನಿ, ಅವಳು ಇಟ್ಕೊಳ್ಳಿ. ಅವಾಗ ನಿಜವಾದ ತಾಯಿ ಇದ್ದವಳು, ಆ ರೀತಿ ಮಾಡೋದು ಬೇಡ, ಮಗುನ ಅವಳ ಹತ್ತಿ ಬಿಟ್ಬಿಡ್ರಿ ಅಂತ. ಹೌದಾ? ದೇರ್ ಇಸ್ ಸಮ್ ವಿಸ್ಡಮ್ ಇನ್ ದಟ್. ಮಗುನ್ ನೀವು ಬೆಳೆಸ್ಬೇಕು. ಮಗುನ ಸರಿಯಾಗಿ ಬೆಳೆಸ್ಬೇಕು ಅಂದ್ರೆ ತಂದೆ ತಾಯಿ ಇಬ್ರು ಅವ್ರ ಜೊತೆ ಇಂಟರಾಕ್ಟ್ ಮಾಡ್ಬೇಕು. ಅನೇಕ ವಿಷಯಗಳನ್ನ ಮಗು ತಂದೆಯಿಂದ ಡ್ರಾ ಮಾಡ್ತದೆ, ಕೆಲವೊಂದು ತಾಯಿಯಿಂದ ಡ್ರಾ ಮಾಡ್ತದೆ. ಹಂಗೆ ಹೇಳ್ತಾರೆ ಎಲ್ಲ ಚೈಲ್ಡ್ ಸೈಕಿಯಾಟ್ರಿಸ್ಟ್, ಎಸ್ಪೆಷಲಿ ಸೈಕಿಯಾಟ್ರಿಸ್ಟ್ ಲೈಕ್ ಸಿಗ್ಮಂಡ್ ಫ್ರಾಯ್ಡ್, ಸಬೀನಾ ಸ್ಪಿಲ್ರೀನ್, ಕಾರ್ಲ್ ಗಸ್ತವ್ ಯುಂಗ್, ಇವರೆಲ್ಲ ಆ ರೀತಿ ಹೇಳ್ತಾರೆ ಅಂತ ರೈಟಪ್ ಇದಾವ್. ಹಂಗಾಗಿ ಮಗುಗೆ ಅನ್ಯಾಯ ಆಗೋದು ಬೇಡ. ಇಲ್ಲಿ ನಿಮ್ ಲೈಫ್ನಲ್ಲಿ ಆಗಿದ್ದು ಆ ಮಗುವಿನ ಜೀವನದಲ್ಲಿ ಅದು ಮತ್ತೆ ಜೆರಾಕ್ಸ್ ಆಗ್ಬಾರ್ದು ಆ ಎಪಿಸೋಡ್, ಅಲ್ವಾ? ಡು ಯು ಅಗ್ರಿ? ಇದು ನಿಜ ಅನಿಸ್ತದ ಹೇಳೋದು? ಆ ರೀತಿ ಆಗೋದು ಬೇಡ. ಮತ್ತೆ ಇಬ್ರು ಎಜುಕೇಟೆಡ್ ಇದ್ದಾರೆ, ಕಲ್ಚರ್ಡ್ ಇದ್ದಾರೆ. ಏನೋ ಕಾರಣಕ್ಕೆ ಒಂದು ಎಸ್ಟ್ರೇಂಜ್ಮೆಂಟ್ ಆಗ್ತದೆ, ಅದು ಅಷ್ಟು ತಲೆ ಕೆಡ್ಸಬಾರ್ದು. ಕರೆಕ್ಟ್. ನಾ ಅದಕ್ಕೆ ಮಾತಾಡಿದ್ವಿ. ವಿ ಗ್ಯಾದರ್ಡ್ ಗುಡ್ ಇಂಪ್ರೆಷನ್ ಅಬೌಟ್ ಬೋತ್ ಆಫ್ ದೆಮ್. ವಿ ಟಾಕ್ಡ್ ಟು ಚೈಲ್ಡ್ ಆಲ್ಸೋ. ವಿ ಗೇವ್ ಫ್ಯೂ ಚಾಕ್ಲೇಟ್ಸ್. Child happily took that. Is it not? She is nodding now. Therefore, let the interaction begin. We will have some more inputs thereafter. Depending upon that, we can shape our proceedings. You go there. He should be treated with due respect, if not affection. The husband should be treated with due respect, if not love and affection. He should be treated that way. His husband. Nodi, when Rama went to forest, Sita followed his footsteps. Even Lakshmana's wife Urmila said, I also want to come. But Lakshmana did not permit. Therefore, she stayed back. That's how our culture is. How to be good married couple ಅನ್ಕೊಂಡು ಒಂದು ಬುಕ್ ಇದೆ. ಅದ್ರ ಕೆಳಗಡೆ ಬರ್ದಾರೆ, ದಿಸ್ ಬುಕ್ ಈಸ್ ನಾಟ್ ಮೆಂಟ್ ಫಾರ್ ಇಂಡಿಯನ್ಸ್ ಅಂಡ್ ಚೈನೀಸ್ ಅಂತ. ಅವ್ರಿಬ್ಬರಿಗೂ ಅಲ್ಲ, ಇದು ಬೇರೆಯವರಿಗೆ ಅಂತ. ಅಂದ್ರೆ ಬೈ ಕಲ್ಚರ್ ಹಂಗಿದೆ ನಮ್ದು. ಹಾಗಾಗಿ ಇದೊಂದು ಎಕ್ಸ್ಪೆರಿಮೆಂಟ್ ಮಾಡಿ. ಬರೀ ಎಸ್ಟ್ರೇಂಜ್ಮೆಂಟ್ ಹಿಂಗೆ ಇರಲ್ಲ. ಏನೇನೋ ಕಾರಣಕ್ಕೂ ಒಂದ್ಸರಿ ಮನಸ್ಸಿನಲ್ಲಿ ನಮಗೆ ಸಿಟ್ಟು ಬರ್ತದೆ, ಒಂದೊಂದ್ಸರಿ ದ್ವೇಷ ಹುಡ್ತದೆ. ಬಟ್ ಅವೆಲ್ಲ ಕರಗ್ತಾವ್ ಅಲ್ವಾ? ನಾವೇ ಕರಿಗೆ ಹೋಗ್ತೇವಿ ಕಾಲ ಗರ್ಭದಲ್ಲಿ ಒಂದ್ಸಾರಿ. ಅದನ್ನು ಕಣ್ಣು ಮುಂದೆ ಇಟ್ಕೋಬೇಕು. ನಾವೆಲ್ಲರೂ ಕಾಲ ಗರ್ಭದಲ್ಲಿ ಮುಗಿಯುವಂಥವ್ರು. ಅದನ್ನು ಗಣನೆಗೆ ತಗೊಂಡು ಇದೇ ರೀತಿ ಇರಲ್ಲ, ಎಲ್ಲ ಏನೇನೋ ಬದಲಾವಣೆ ಆಗ್ತಿರ್ತದೆ. ಹೌದಾ? ಅದಕ್ಕೆ ಅವರು ಒಪ್ಪಿದ್ದಾರೆ, ಹೋಗ್ಲಿ. ಅಲ್ಲಿ ಬಂದಾಗ ಗೌರವದಿಂದ ನಡ್ಸ್ಕೊಳ್ಬೇಕು. ಆ ಅಶ್ಯೂರೆನ್ಸ್ ಮೇಲೆ ಕಳಿಸ್ತಾ ಇದ್ದೀವಿ. ಯು ವಿಲ್ ಕಮ್ ದೇರ್ ಆಸ್ ಅವರ್ ಅಂಬಾಸಡರ್ ಟು ಯುವರ್ ಹೌಸ್. ಓಕೆ? ಜೊತೆಗೆ ಹೋಗ್ಬೇಕು. ಮತ್ ನಂತರ ಪೇರೆಂಟ್ಸ್ ಮೀಟಿಂಗಿಗೆ ತಿಳಿಸ್ಬೇಕು. ಇಬ್ರು ಒಂದು ಕೈ ಮಗುನ್ ನೀವ್ ಹಿಡ್ಕೋಬೇಕು, ಒಂದ್ ಕೈ ಅವ್ರ ಹಿಡ್ಕೋಬೇಕು, ಜೊತೆಗೆ ಹೋಗ್ಬೇಕು. ಅದು ಇಂಪಾರ್ಟೆಂಟ್ ಇದೆ. ಇಟ್ಸ್ ವೆರಿ ಇಂಪಾರ್ಟೆಂಟ್, ವಿಚ್ ವಿ ಕೆನಾಟ್ ಮೋರ್ ಡೆಲಿಬರೇಟ್ ಬಿಕಾಸ್ ಆಫ್ ದಿ ಫೋರಮ್. ಓಕೆ? ಆ ರೀತಿ ಹೋಗ್ಕೊಂಡು ಬರ್ರಿ. ಹೇಳಿ, ಯಾವತ್ ಬೇಕಾದ್ರೆ ಹಿ ಕ್ಯಾನ್ ಸ್ಪೀಕ್ ಟು ಹರ್ ಅಂಡ್ ಶಿ ಕ್ಯಾನ್ ಸ್ಪೀಕ್ ಟು ಹಿಮ್. ವೈ ಕೋರ್ಟ್ ಈಸ್ ನೆಸರಿ? ಆಲ್ ರೈಟ್. ಯಾವ ಸಂಡೇ ಬೇಕು ಹೇಳಿ. ಮೇಡಮ್, ಆಲ್ಟರ್ನೇಟಿವ್ ಸಂಡೇ ಕಳಿಸಿ. ನಿಮ್ಮ ಮನೆಗೆ ಬರ್ತಾರೆ ಅವರು, ಅವ್ರಿಗೆ ಕೂಡಿಸ್ಕೊಂಡು ಒಂದು ಕಪ್ ಟೀ ಕಾಫಿ ಏನಾದ್ರು ಕೊಟ್ಟು ಗೌರವಯುತವಾಗಿ ಮಗುನ್ ಕಳಿಸಿ. ಯಾವುದು ಇಶ್ಯೂ ಜನರೇಟ್ ಆಗ್ಬಾರ್ದು. ತುಂಬಾ ಜನ ನೋಡ್ತಿರ್ತಾರೆ ನಮ್ನೆಲ್ಲ, ಸ್ವಲ್ಪ ಆ ಕಡೆ ಗಮನ ಇಟ್ಕೋಬೇಕು. ಆಯ್ತಾ? ಕಳಿಸಿ. ಅವ್ರಿಗೆ ಎಷ್ಟೊತ್ತಕ್ಕ ಬೇಕು ಅಂತ ಕೊಟ್ಟು ಕಳಿಸಿ ಮಗುನ್ ಕಳಿಸಿ. ಏನು ಆರ್ಡರ್ ಬೇಡ. ನೋಡ್ಕೊಂಬ, ಇಂಥದ್ರಿಗೆಲ್ಲ ಆರ್ಡರ್ ಮಾಡೋಂಗಿಲ್ಲ. ಅವ್ರು ಇಬ್ರು ಕಲ್ಚರ್ಡ್ ಇದ್ದಾರೆ, ಎಜುಕೇಟೆಡ್ ಇದ್ದಾರೆ, ಇಬ್ರು ಜಗತ್ತನ್ನು ಸಾಕಷ್ಟು ನೋಡಿದ್ದಾರೆ. ಹಂಗಾಗಿ ಏನು ಆರ್ಡರ್ ಬೇಕಿಲ್ಲ. ಇದೆಲ್ಲ ರೆಕಾರ್ಡ್ ಆಗಿರುತ್ತೆ ಇಲ್ಲೆಲ್ಲ ನಮ್ಮಲ್ಲಿ. ನೀವು ಆ ರೀತಿ ನಡ್ಕೋಬೇಕು. ನೆಕ್ಸ್ಟ್ ಡೇಟಿಗೆ ಏನೋ ಒಂದು ವಿಚಾರ ಮಾಡ್ಕೊಂಡು ಏನಾರ ಮಾಡೋಣ ಅಂತ.
So he has to take the child alternative Sunday.
ಅಲ್ಲಿ ಬಂದಾಗ ಆರ್ಡರ್ ಹಿಡ್ಕೊಂಡು ಹೋಗ್ಬೇಡಿ. ಆರ್ಡರ್ ಬೇಕಿಲ್ಲ. ನಿಮ್ ಮಗು ಅದು. ಟು ಸಿ ಸನ್ ಆರ್ ಸನ್, ನೋ ಪರ್ಮಿಷನ್ ಈಸ್ ರಿಕ್ವೈರ್ಡ್. Therefore, go there. Go with affection, with olive branches. ಹೌದು, ನೀವು ಗೌರವಯುತವಾಗಿ ಪ್ರೀತಿಯಿಂದ ಹೋಗಿ ನಿಂತ್ಕೊಳ್ಳಿ. ಯಾವ ರೀತಿ ಕೆಲಸ ಆಗ್ತದೆ ನೋಡಿ. ಪ್ರೀತಿ ಇಲ್ದಾಗ ನಮಗೆಲ್ಲ ಸಮಸ್ಯೆ. ಪ್ರೀತಿ ಇದ್ದು ಬಿಟ್ರು ಸಮಸ್ಯೆನೇ ಬರೋದು.
Last date of order speaks every day he has to visit. ಅದರ ಬದಲಿಗೆ alternative Sunday ಅಂತ ಹೇಳಿ ಆರ್ಡರ್ ಇಲ್ಲ.
ಆರ್ಡರ್ ಇರ್ಲಿ, ಇಬ್ರು ಅವ್ರಿಗೆ ಬಿಡಿ. ಆರ್ಡರ್ ಇಂದ ಹೋಗಲ್ಲ ಲೈಫು.
ಪ್ಲೀಸ್,
ಜೀವನ ಕೋರ್ಟ್ ಆರ್ಡರ್ ನಿಂದ ನಡೆಯಲ್ಲ. ಜೀವನ ನಡೀಲಿಕ್ಕೆ ಬೇಕಾಗುವಂತದ್ದು ಬೇರೆ ತತ್ವಗಳಿದಾವೆ. ಆ ತತ್ವಗಳ ಕಡೆ ಗಮನ ಕೊಡಿ. ನೋಡ್ಕೊಳ್ಳಿ.
ಮೇಂಟೆನೆನ್ಸ್ ಒಂದ್ ಸ್ವಲ್ಪ
ಬಹಳ ಜವಾಬ್ದಾರಿಯಿಂದ ಮಾಡ್ಬೇಕು. ಅದೇನೋ ಮೇಂಟೆನೆನ್ಸ್ ಏನೋ
ಚೈಲ್ಡ್
ಸಂಜಯ್, ಅದು ವಾಟ್ ಎವರ್ ಮೇಂಟೆನೆನ್ಸ್ ಈಸ್ ಟು ಬಿ ಪೇ ದಟ್. ಡ್ಯೂಸ್ ಏನಿದೆ, ಏನ್ ಕೊಡೋದಿದೆ ಕೊಟ್ಟು ಮುಗಿಸ್ರಿ. ಇದೇನು
ಪೆಂಡಿಂಗ್ ಇಲ್ಲ. ಇದು ಒಂದ್ ತಿಂಗಳದ ಪೆಂಡಿಂಗ್ ಇದೆ ಸಾಹೇಬ್ರೆ.
ಬೇಡ, ಈಗ ಬೇಡ, ಇರಿ. Some good development is taking place, please, in the court hall.
Please.
Okay? ಅವರೇ ಹೇಳ್ಯಾರ, ಎಂಟೈರ್ ಪೇಮೆಂಟ್ ಮಾಡ್ತೀನಿ ಅಂತ ನಿಮ್ಗೆ ಹೇಳಿದ್ದಾರೆ. ಅದ್ರ ಬಗ್ಗೆ ಆರ್ಡರ್ ಬೇಕಾಗಲ್ಲ. He himself said and we believe you.
Copy of the receipt will be provided.
ಕೊಡಿ ಪ್ಲೀಸ್. ರಿಸೀಟ್ ಕೊಟ್ಮೇಲೆ ಅವ್ರು ಕೊಡ್ತಾರೆ.
ಪ್ಲೀಸ್
ಕೊಡಿ.
ಕಾಯಕ್ ಮಟ್ರೆ ಕೊಡಿ.
All right. That's what. Let there be happy beginning instead of ending. Yes, let there be happy beginning now. Please. All right. Whenever you want, take the child. Send your child. His father, after all. He's not enemy. Very good. You go to that place and take the child wherever you want. It's your child. And don't forget that court is the true parent of children. Okay? Okay. ಬೇಡ ಈಗ ಬೇಡ. ಇಲ್ಲಿಂದ ಬಿಗಿನ್ ಆಗ್ಲಿ. ಒಂದೇ ಸರಿಗೆ ಅಷ್ಟು ಲಾಂಗ್ ಜಂಪ್ ಎಲ್ಲ ಮಾಡಬಾರ್ದು. ಸ್ವಲ್ಪ ಇರಿ. Let us see how it develops. Okay? All. We have spoken to him. He's a gentleman of first order. She is a gentle lady of first order. Somehow, some small screen is developed in between. Screens come and go. They should come and go. They are smoke screens, not concrete screens. ಏನೋ ಟೈಮ್ ಬರ್ಬೇಕಲ್ಲ ಜೊತೆಗೆ ಇರ್ಲಿಕ್ಕೆ ಅಲ್ವಾ? ರಾಮ ಸೀತಾನೇ ಬೇರೆ ಬೇರೆ ಇದ್ರು ಗೊತ್ತಾ? ಹೌದಾ? ಮೂಲ ರಾಮಾಯಣದಲ್ಲಿ ಇರೋದನ್ನ ಹೇಳ್ತಾ ಇದ್ದೇನೆ ನಾನು. ಹಿಂಗಾಗತ್ತದ, ಅಷ್ಟಲ್ಲೇ ಕಳ್ಸಬಾರ್ದು. ಬಿಡಿ, ಹಿಂದಿಂದ ಎತ್ಬಿಡಿ. ಹೊಸ ಹೆಜ್ಜೆಗಳನ್ನು ಹಾಕ್ತಾ ಇದ್ದೇವೆ. ಬಿಡಿ, ಹಿಂದಿಂದ ಕಾಯಕ್ ಮಟ್ರೆ ಹಿಂದಿನ ತೆಗಿಬೇಡಿ. ಹಿಂದಿನ ಬಿಡಿ. ಗತಶೋಕಂ ನ ಕುರ್ವೀತ ಅಂತ ಹೇಳ್ತಾನೆ ಸುಭಾಷಿತದಲ್ಲಿ. ಹಿಂದಾದಂಥವನು ಬಿಟ್ಟು ಹಾಕಪ್ಪ ನೀನು, ಮತ್ತವನ್ನೆಲ್ಲ ಎತ್ತಬೇಡ ನೀನು ಅಂತ ಹೇಳ್ತಾನೆ ಋಷಿ. ಇರಿ ಈಗ ಸ್ಟಾರ್ಟ್ ಮಾಡಿ, ಏನೋ ಒಳ್ಳೇದಾಗತ್ತೆ, ನಾವು ಹಂಗೆ ಹೇಳಿವಿ ಅಂದ್ರೆ ಒಳ್ಳೇದಾಗ ಕೇಳಿರ್ತೇವಪ್ಪ. ಹಾ ಆಯ್ತು. ಯಾವತ್ತು ಕರ್ಕೊತೀರಿ? ಹಾ 25th ಇಟ್ಕೊಳ್ಳೋಣ. ಅವ್ರಿ ನಿಮ್ಗೆ ಯಾವಾಗ ಬೇಕೋ ಮಗುನ್ ಕರ್ಕೊಂಡು ಹೋಗ್ರಿ, ಕಳಿಸ್ರಿ ಮೇಡಮ್. ಓಕೆ ಆಲ್ ರೈಟ್. ಬಟ್ ಮನೆಗೆ ಹೋಗಿ ಗೌರವಯುತವಾಗಿ ತೊಗೊಂಡು ಆ ರೀತಿ ಎಲ್ಲೋ ಹಂಗೆ ಏನೋ ಕದ್ಕೊಂಡು ಹೋದಂಗೆ ಹೋಗೋದಲ್ಲ. ಯು ಆರ್ ಫಾದರ್, ಯು ಹ್ಯಾವ್ ಎವ್ರಿ ರೈಟ್. ಶಿ ಈಸ್ ಅಂಡರ್ ಎ ಡ್ಯೂಟಿ ಟು ಟ್ರೀಟ್ ಯು ವೆಲ್ ವೆನ್ ಯು ವಿಸಿಟ್ ದಟ್ ಹೌಸ್. ಗೋ ದೇರ್. ಇಫ್ ದೇರ್ ಈಸ್ ಸಮಥಿಂಗ್ ಇನ್ಫಾರ್ಮ್ ಅಸ್. ಆಲ್ ದಿ ಬೆಸ್ಟ್.
25th, I need not keep the child present because.
ಅವ್ರು ಇಬ್ಬರಿಗೂ ಬೇಕಾದ್ರೆ ಕರ್ಕೊಂಡ್ ಬರ್ಲಿ. ಬಟ್ ಚೈಲ್ಡ್ ಮೇ ಕಮ್ ಆನ್ ಇಟ್ಸ್ ಓನ್ ಬಿಕಾಸ್ ಇಟ್ ವಾಂಟ್ಸ್ ಚಾಕ್ಲೇಟ್ಸ್.
Please, ಯಾಕಂದ್ರೆ ಎಕ್ಸಾಮ್ಸ್ ಏನೋ ಇದಾವೆ.
ವೆರಿ ವೆಲ್, ನಾಟ್ ನೋಡ್ತಾರೆ. ಓಕೆ, ಯಾವ ಆರ್ಡರ್ ಬೇಕಿಲ್ಲ ಈ ಹಂತದಲ್ಲಿ. ಪುಟ್ ಎನ್ ಎಕ್ಸ್ಪೆರಿಮೆಂಟ್.
19 GN Nasamnawar.
ಏನ್ ಬ್ರದರ್ ಇದು?
ಲಾಸ್ಟ್ ಟೈಮ್
ಅದು ಆನ್ ಮಾಡ್ಕೊಳ್ಳಿ.
Service benefits, my lord.
Service benefits.
As per the court order, my lord, they have issued DDs, my lord. As per the main prayer, my lord, you have seeking benefits from 2007, my lord. The learned judge granted up to
87 to 2004.
4 ವರೆಗೆ ಕೊಟ್ಟಿದ್ದಾರೆ, my lord. 2007 ವರೆಗೆ we are seeking in WP, my lord. Our lordship may kindly see the prayer of the WP, my lord.
ಎಷ್ಟಾಗ್ತದೆ 87 to 2004 ಅಂದ್ರೆ?
ಅವರೇ ಲೆಕ್ಕ ಮಾಡಿ
ನೀವು ವರ್ಕ್ ಮಾಡಿದ್ದ ಅಷ್ಟೇ.
Up to 2004 they have settled, my lord, as per the letter, as per the order of the honorable court.
2004 ಮೀಟರ್ ಸೆಟಲ್ಮೆಂಟ್ ಮಾಡಿದ್ದಾರೆ, ಮುಂದಿನ ಮಾಡಿಲ್ಲ ಅಂತಾರೆ.
2004 ತನಕ ಕೊಟ್ಟಾರೆ, ಆರ್ಡರ್ ಅಷ್ಟೇ ಇದೆ.
ಇಲ್ಲ, ಆರ್ಡರ್ ಅಷ್ಟೇ ಇದೆ, my lord. We have pressing for the main relief, my lord.
ಏನು
WP relief, kindly see, my lord, page number 40.
2 ಡಿಮ್ಯಾಂಡ್ ಡ್ರಾಫ್ಟ್ಸ್ ಕೊಟ್ಟಾಗಿದೆಯಲ್ಲ?
ಆಗಿದೆ.
1,10,10,999 ಪ್ಲಸ್ 48,000 ಕೊಟ್ಟಿದ್ದಾರೆ. ಮತ್ತೇನು ಉಳಿತಿದ್ರು?
ಅಲ್ಲ, page number 48, my lord. We are seeking relief in before the single judge, my lord. We are seeking to quash the endorsement dated 21/3/2007, my lord, without authority of law, my lord, as per section 30 of the Parishad rules, my lord. Registrar has no power to dismiss from service, my lord.
ಅಲ್ಲಿ ಅಬೆಂಡನ್ಮೆಂಟ್ಸ್ ಆಫ್ ಸರ್ವಿಸ್ ಆಗಿದೆ ಅಂತ ಹೇಳಿದ್ದಾರೆ.
Yes, my lord.
ಕರೆಕ್ಟ್ ಇದೆ.
ಅಲ್ಲ, without giving any opportunity, my lord.
ಏನು ಅಪರ್ಚುನಿಟಿ ಕೊಡಬೇಕು ಅಬೆಂಡನ್ ಆದರು ಹೋದ್ರೆ?
ಅಲ್ಲ,
did you give opportunity to the employer?
Yes,
so I am going back to particular place for a year or 2. Therefore don't wait, make your own arrangement ಅಂತ year opportunity ಕೊಟ್ಟು ಹೋದ್ರೆ?
With permission, my lord, we have.
ಎಲ್ಲಿದೆ ತೋರಿಸಿ.
Firstly, we have applied for 2 years.
Permission. ಅಬೆಂಡನ್ಮೆಂಟ್ ಆದ್ರೂ ಕೊಡಬೇಕು ಅನ್ನೋದು ಬೇರೆ ಆಂಗಲ್ಸ್ ನಲ್ಲಿ. ಕರುಣಾಕರನ್ ವರ್ಸಸ್ ECI ಅಲ್ಲಿ ಡೈರೆಕ್ಟರ್ ECI ನಲ್ಲಿ ಡಿಫರೆಂಟ್ ಕಾಂಟೆಕ್ಸ್ಟ್. ಈ ಕಾಂಟೆಕ್ಸ್ಟ್
page number 78, my lord. Page number 78, my kindly see.
78.
Annexure M, my lords.
ಏನು ಲೆಟರ್ ಇದೆ? She has been granted leave without pay for 6 months.
6 months
from the date you left Dharwad.
Yes.
Thereafter you are required to join your duty, otherwise your services be considered to have been voluntarily abandoned.
Yes.
You went on 13 to 2000. ಯಾವತ್ತು ಹೋಗಿದ್ ನೀವು?
2004, my lord. Meanwhile, my lord, we have request to extend the leave, my lords.
ಅದು ಕೊಟ್ಟಿಲ್ಲ.
Not granted, my lord.
ಮತ್ತೆ ಮುಗಿತು. ನೀವು ಎಕ್ಸ್ಟೆಂಡ್ ಆಗಲಿ ವಾಪಸ್ ಬರ್ಬೇಕು.
ವಾಪಸ್ ಬರ್ಬೇಕು. ಅಲ್ಲ,
ಕೆಲಸ ಬಿಟ್ಟು ಹೋಗ್ಬೇಕು, ಎರಡು ಆಪ್ಷನ್.
ಅಲ್ಲ, we are in Spain along with our husband, my lord. Passport is not there to come to India, my lord.
ಏನು?
We are residing in Spain along with our husband, my lord. Appellant is residing with the.
ನೋಡ್ರಿ, ಯಾವ್ದಾದ್ರು ವೈಫಿಗೆ ಹಸ್ಬೆಂಡ್ ಜೊತೆ ಇರ್ಬೇಕು ಅಂದ್ರೆ ಇರ್ಲಿ. ಅಂದ್ರೆ ಜಾಬ್ ಬೇಕು, ಹಸ್ಬೆಂಡು ಬೇಕು, ಜಾಬ್ ಬೇಕು ಅಂತ ಹೇಳ್ಕೊತ ಕೊಡಕ್ ಬರಲ್ಲ.
With permission, my lord, we have.
How it is possible? It's an organization. How is it possible? ನಾಳೆ ಎಲ್ಲರೂ ಹಂಗೆ ಹೇಳ್ತಾರೆ, ನಾನು ಹೆಂಡತಿ ನೋಡ್ಲಿಕ್ಕೆ ಹೋಗ್ಬೇಕು, ಗಂಡು ನೋಡ್ಲಿಕ್ಕೆ ಹೋಗ್ಬೇಕು ಅಂದ್ರೆ ಆರ್ಗನೈಸೇಷನ್ ನಡೆಯೋದು ಹೆಂಗೆ? ಎಲ್ಲ ಕೆಲಸ ಬಿಟ್ಟು ಹೋಗಿ ಬೇರೆ ಯಾರನ್ನ ಮಾಡಿಸ್ಕೊತಾರ.
81.
ಏನಿಲ್ಲ.
Revert back to Dharwad, join universities immediately.
Extension of leave, again, we are requesting for extension of leave, my lord. That is also not.
Abandoned. That is.
Meanwhile, my lord, we have for option of voluntary retirement. That is also not considered, my lord.
ಎಲ್ಲ ಕರೆಕ್ಟ್ ಅಲ್ಲಿ ನೋಡ್ಕೊಂಡ ಮಾಡ್ಯಾರ. ಈಗ ಅಮೌಂಟ್ ಕೊಟ್ಟಾಯ್ತು, ಆ ಅಮೌಂಟ್ ಇಟ್ಕೊಳ್ಳಿ.
Main prayer, my lord, without authority of law, my lord.
ಯಾವುದು?
ಅದು Enexer movie which is questioned before the single judge, my lord.
ನಿಮ್ಗೆ ಅದು ನೋಟಿಸ್ come to 81, page 81 ಬನ್ನಿ.
Please.
Page 81 Q.
Enexer Q.
ನೋಡಿ ಏನ್ ಹೇಳಿದ್ದಾರೆ. In view of the above circumstance, you should either revert back to Dharwad to join your duties immediately or on or before 31/8/2000, or else it would be presumed that you have abandoned the service with effect from 1/9/2004 ಅಂತ ಹೇಳಿ. ನಿಮ್ಗೆ ಎಟರ್ನಲಿ ಕಾಯ್ಕೋತಿರ್ಲಿಕ್ಕೆ ಆಗ್ತದ? ಆಲ್ ದ ಟೈಮ್ ಟು ಕಮ್ ಕಾಯ್ಕೋತ್ ಕೊಡ್ಬೇಕಾ? ಅಷ್ಟು ಇಂಪಾರ್ಟೆಂಟ್ ಈ ವ್ಯಕ್ತಿಯ ಆರ್ಗನೈಸೇಷನ್ಗೆ? ನಾಟ್ ನೆಸೆಸರಿ. Is repeated in T. 84.
Enexer we, my lord, rules our lordship may kindly see, my lord. As per rule 30, my lord, as per rule 30. Disciplinary action, my lord, page number 102, my lord. 102, my lord.
Rule number 30, the action.
Rule number 30.
Disciplinary actions.
Action, disciplinary action, my lord. The Kulapati or Sama Kulapati in consolence with the Kula Sachiv shall have the power to suspend an employee in case of dismissal of any employee. It shall be done by the Shashi Parishad, but such action can be taken only after giving an opportunity to the person to prove himself not guilty and also subject to the right to appeal to the Shashi Parishad of the Samsthan. Without
ಅದು ಏನಾದ್ರು ಮಿಸ್ಕಂಡಕ್ಟ್ ಆದ್ರೆ ನೀವು ಬಿಟ್ಟು ಅಬೆಂಡನ್ ಮಾಡ್ಕೋತ ಹೋದ್ರೆ ಅದು ಮಿಸ್ಕಂಡಕ್ಟ್ ಆಗ್ತದೆ, ರಿಲಿಂಕ್ವಿಶ್ಮೆಂಟ್ ಆಫ್ ಸರ್ವಿಸ್ ಆಗ್ತದೆ, ಎರಡು ಆಗ್ತದೆ. ಸಪೋಸ್ ಯಾವುದೋ ಮಿಸ್ಕಂಡಕ್ಟ್, ಒಂದು ಮಿಸ್ಬಿಹೇವಿಯರ್ ಇಂಥದ್ದೆಲ್ಲ ಮಾಡಿದಾಗ ಅವಾಗ ಇದು ಅಪ್ಲೈ ಆಗ್ತದೆ. ನೀವು ಅಬೆಂಡನ್ ಮಾಡಿದಾಗ ದಿ ಎಂಪ್ಲಾಯಿ ರಿಲೇಶನ್ಶಿಪ್ ಕ್ಯಾನ್ ಕಮ್ ಟು ಎನ್ ಎಂಡ್. ಹೌ? ಬೈ ಎಫ್ಲೆಕ್ಸ್ ಆಫ್ ಟೈಮ್ ಫಿಕ್ಸ್ಡ್ ಬೈ ದಿ ಕಾಂಟ್ರಾಕ್ಟ್ ಆಫ್ ಸರ್ವಿಸ್, by resignation, by removal, discharge, dismissal, death, and another is abandonment. If you have abandoned service, that also will come to put an end to service relationship. Service law dalli recognize agide abandoning of service.
That is not as per rule 30 anta.
Rule 30 aವಾಗ abandon ಮಾಡಿದ್ರೆ ಆಗಲ್ಲ.
Meanwhile, we are requesting for voluntary retirement, my lord. That is also not considered, my lord. Instead of
this intra-court appeal calls in question a learned single judge's order dated 19/4/2022, whereby the appellant's WP number 67758 of 2010 res having been partly allowed, the following relief has been granted to her. 9/10, paragraphs 9 and 10, page 16. Next part. Kuthwali, please be seated. After service of notice, the respondents are represented by their learned panel counsels. They resist the appeal, making submission in justification of the impugned order and the reasons on which it has been constructed. First, on 29/8/2024, we had made the following order. Next paragraph. In terms of the above order, payment madagidene ಈಗ?
Payment have made.
Payment of rupees 1,10,769 plus 48,000 in all amounting to rupees so and so has been made to the appellant by bank drafts. First, counsel for the appellant acknowledges the payment of said sum in terms of the mandate of the learned single judge while disposing of, given while disposing of the writ petition. Next part. Having heard the learned counsel for the parties and having perused the appeal papers, we decline indulgence in the matter, broadly being in agreement with what the learned single judge has said. First, it is a pure and simple case of abandonment of service, in as much as for long the appellant did not turn back to employment despite two notices dated so and so, respectively at annexes Q and R. Q and T, na? Q and T. Okay, open. First, the reliance of appellant's counsel on Rule 30 of enta rules idu of Dakshina Bharata Hindi Prachara Sabha service rules. So and so, note does not much come to his aid. First, it has been a settled position in service jurisprudence that the contract of service, regardless of attainment of status, comes to an end with the after the efflux of time prescribed, if any, or by resignation, removal, or by abandonment, or by death. First, abandonment of service is recognized by the conventional writers of service law, service law books, as a factor that would put an end to vinculum juris of employment. That has happened in this case. First, such cases do not fit into the contours of Rule 30, which reads as under. Next one. In the above circumstances, this appeal is liable to be and accordingly dismissed. Costs having been made easy. Yes.
20, Ramesh Chigari.
ಅಲ್ಲಿ Q and T na reproduce ಮಾಡಿ particular portion ಅನ್ನು ತೋರಿಸಿ, which read as under last paragraph ಎರಡರದ್ದು.
There is a delay in appeal, my lord. First time.
Delay is there.
134 days delay.
Admission ಬಂದಿದೆ ಏನಿದು? ಏನು ಮೆರಿಟ್ ಮೇಲೆ ಏನಿದು ಮ್ಯಾಟರ್?
My lords, the petitioner father was died during the course of employment, my lords, and his mother was applied for the compassionary gown, my lords, and wherein it was rejected on the ground that he was minor. And after lapse of 7 years, the petitioner has approached before this honorable court only on the ground of delay in laches. The honorable court, the single judge has rejected the petition, my lords.
So, delay of 7 years.
7 years.
What is the period which prescribed? Justice Thakur prescribed that period. What is that period? ಎಲ್ಲಿದ್ದಾರೆ ಯಾರು ಇವರು? ಏನಿದೆ ಕರೆಕ್ಟ್ ಇದೆ ಇದು ಆರ್ಡರ್.
Sir, there is mother.
The unsuccessful writ petitioner in WP number 147465 of 2020, yes, res, he is knocking at the doors of appellate court to void the single judge's order dated 17/6/2021, whereby relief which he had prayed for has not been granted. First, next paragraph. Learned single judge has while denying relief to the appellant, at paragraph 4 of the impugned judgment order has said as under. First stop, other calculate. We are in complete agreement with the reasoning of the learned single judge. Full stop. The object of providing compassionate appointment to a member of family when the breadwinner has withered away in harness is to see that the difficulty arising therefrom is mitigated. First stop. Here is a case where the claim for compassionate appointment is made 7 years after the incident, and the medical grounds that were urged by way of explanation for the delay brooked have not been substantiated by producing the requisite evidentiary material, as has been observed by the learned single judge, rightly. First, the other Supreme Court judgment ಹಾಕ್ಬೇಕು. ನೋಡ್ಕೊಂಡು ಹಾಕಿ in the above circumstance. ಯಾವ್ದದು immediate relief ಕೊಡ್ಲಿಕ್ಕೆ ಮಾಡಿದ್ದದು ಅಂತ ಬಂತಲ್ಲ.
One factual, he mother filed application immediately, but the rejection order was challenged after 7 years.
Filed application immediately.
At the time of
years they went to, rejection was made and challenge was laid after 7 years.
7 years.
And even he was not a major at that time.
He was only 15 years, my lord.
15 years.
That was the rejected.
Application was filed by the mother on behalf of the minor
child,
who was 15-year-old at the time when the death in harness took place. Full stop. The rejection took place on 21/9/2013. 13.
Same was challenged.
First stop. The same was put in challenge in WP
20
in the subject writ petition in 2020. First stop. So it is first stop. The delay brooked is 7 years. First stop. He should have been attained majority. Even otherwise,
within 1 year.
Within 1 year of the death.
Because he was a minor, he could not
Even
be.
the rejection of minor's application was rightly
rejected.
in as much as a person who is not, who was minor at the time the death happened, would have made a claim within 1 year from the date of death.
Also, he would have attained majority.
And, should he have attained majority in that period?
Case he would not have even attained majority.
ಯಾವ್ದಿದೆ ಜಡ್ಜ್ಮೆಂಟ್ ಯಾರು ಒಂದು
Santosh,
I will provide.
This our view gain support from the decision of appeals court in Santosh versus so and so. In those circumstances, the appeal being independent, the divide of minutes is liable to be and accordingly rejected. Next.
My lord, I'm representing Prashant Karddevar, name should be deleted.
Your voice is as weak as your case is. ನಿಮ್ಮ ಹೆಸರು ತೋರ್ಸಕ್ಕ?
I'm representing Prashant Karddevar, my lord. The name should be deleted.
ಅವ್ರ ಹೆಸರು. Okay.
21, Suraj Mudhol.
Yes.
This is not remand order is challenged by the appellant, not HESCOM, Judicial and not appellate authority on the ground that remand order, not simple remand, not the appellate authority has to not decide the matter afresh. But para number 5, my lord, the remand order, not the finding recorded by the learned single judge is that not it comes to conclusion that the petitioner is entitled. Then not appellate authority can't not go not contrary to this the finding, not. And not there is a not may read not para 5, not. In my view, this reasoning should be incorrect.
You only had surrendered. The sister concern had surrendered it.
Not whether it is sister concern or not, it has to be decided by the authority by placing not the reliance. But it is a contention of the petitioner. But our contention is both firms are different name, different.
Is it now? You tell us. Is it a sister concern or not?
Not according to on instruction. Not it is standing in the name of different persons.
That makes no sense. Under company law jurisprudence, there is a specific meaning to the sister concern. ನೀವು ಹಂಗ ಅನ್ಕೊಳಂಗ ಆಗಲ್ಲ ಅದು. It does not fall into some other statute. There is A. Ramaya on company law. discusses this aspect of matter. ಮತ್ತೆ ಅವನ್ನೆಲ್ಲ ರೆಡಿ ಮಾಡ್ಕೊಂಡ್ ಬಂದ್ರೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ಲಿಕ್ಕೆ ಬರ್ತದೆ. ಅದೇ ನೀವೇನು ಹೇಳ್ತೀರಿ ನಾವು ಅದನ್ನ ಒಪ್ಬೇಕಲ್ಲ. ನಮ್ಗೆ ಒಪ್ಪೋದಿದ್ರೆ ನೀವು ಕಾನೂನು ಲ್ಯಾಂಗ್ವೇಜ್ ನಲ್ಲಿ ಬುಕ್ಸ್ ತೊಗೊಂಬಂದು ಜಜ್ಮೆಂಟ್ ಹಿಂಗಿದೆ, ಆಥರ್ಸ್ ಹಿಂಗ್ ಹೇಳ್ತಾರೆ ಅಂತ ಹೇಳಿದ್ರೆ ಏನೋ ಕೊಡ್ತೇವೆ ನಾವು. ಹಾಗೆ ಬಂದೇನೋ 2 ಸೆಂಟೆನ್ಸ್ ಹೇಳಿ ಏನು ಕೊಡೋದೇ ಇಲ್ಲ. ದಟ್ ಈಸ್ ನಾಟ್ ಅಡ್ವೊಕಸಿ ಅಟ್ ಆಲ್. ಇಟ್ ಈಸ್ ಓನ್ಲಿ ದಿ ಸುಭಾಷ್ ರೋಡ್ ಅಡ್ವೊಕಸಿ ಆಗ್ತದೆ. ಅದನ್ನ ಕೋರ್ಟ್ ನಲ್ಲಿ ಇದ್ದಾಗ ಯು ಟೆಲ್ us. Now I am asking you to decide whether a concern is a sister concern of another or not. How to decide? What is the normative basis? Madkemani, please, we'll give time to you.
May I serve writ appeal papers to the advocate writ appeal.
Convince ಮಾಡ್ರೆ ನಾವು ಕೊಡಕ್ ಬರ್ತದೆ.
ಇಲ್ಲ ಅವ್ರಿಗೊಂದು ಕಾಪಿ ಕೊಡ್ಲಾ ಅಂತ.
Call after 2 weeks to enable counsel for the appellant to come with more preparation. Yes. 22. A. Ramaya on company law discusses this. When is adon? ಅದೇ ರೀತಿ ಇಂಡಸ್ಟ್ರಿಯಲ್ ಡಿಸ್ಪ್ಯೂಟ್ ಆಕ್ಟ್ ನಲ್ಲೂ when it is a sister concern, when it is the same concern, ಇದು ಡಿಸೈಡ್ ಆಗಿದೆ. ನೋಡ್ಕೊಂಡ್ ಬರ್ಬೇಕು. ನೆಕ್ಸ್ಟ್ 22. ಹಾ ಏನ್ ಬ್ರದರ್ ಇದು? Yes, brother. ಏನಿದೆ?
My land is not acquired.
ಎಲ್ಲಿ ಪಾಸ್
Not ready. Pass over today difficult.
File my lords contempt also.
Contempt ಹಾಕಿರಾ?
ಹಾಕಿದ್ದೀನಿ. Connected ಇದೆ ಇದಕ್ಕೆ.
ಫೈಲ್ ಮಿಸ್ಪ್ಲೇಸ್ ಆಗಿದೆ. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ತಗೊಂಡು.
Date my lords, any date.
Date ಕೊಡಿ, week 2 weeks ಆದ. Yes. Yes, brother.
53 J. Gachinmat.
ಹಾ.
ರೂಲ್ ಯಾವ್ದು? 214 ಯಾವ್ದು ಉಳಿದಿದಾವ?
214 ಯಾವ್ದಾದ್ರು ಉಳಿದಿದ್ದಾನ?
ಇದರಲ್ಲಿ
214 ಉಳಿದಿದ ಇದ್ರಲ್ಲಿ ಯಾವ್ದಾದ್ರು?
214 ಯಾವ್ದು?
ಯಾವ್ದಿಲ್ಲ?
In my cases for not.
ಅಲ್ಲ ಇವ್ರದೇ ಇಲ್ಲ, ಗಚ್ಚಿನ ಮಟ್ಟ ಅವ್ರದ್ದು ಯಾವ್ದಿದ್ರೆ ಕೇಳು.
ಗುರು ಯಾವ್ದು? ಯಾವ್ದು? ಯಾವ್ದ್ಯಾವ್ದಿದೆ?
ಯಾವ್ದು ರೂಲ್?
214. Last matter, my lords, 10th matter, 102/752 of 2023.
ಎಲ್ಲ 214 ಆಗುತ್ತೆ.
ಇಲ್ಲ.
214 ಅಲ್ಲ.
214. Only one matter, my lords, pertains to 214. Last matter only.
ಫೈಲ್ ಕೊಡು ಗುರು. ನಿಮ್ ಫೈಲ್ ಕೊಡು. ಪ್ಲೀಸ್ ಫೈಲ್. So it will be covered by that judgment again.
Actually,
factual assertion correct ಇದೆಯಾ ಕಾಳೆ?
I6
12/6. Retirement? 15. ಶೋಕಾಸ್ ನೋಟಿಸ್ ಯಾವ ಕೊಟ್ಟ? ಬಿಯಾಂಡ್ ಟೈಮ್ ಆಗ್ತದೆ ಕಾಳೆ.
ಹೌದು. ಇಲ್ಲ ಅದು 4 years
ಇವೆಂಟ್ ಮಾಡಿದ್ದೇವೆ.
ಹೌದು, ಅದು 4 years ಆ ಸೆಕ್ಷನ್ ಕವರ್ಡ್ ಆಗುತ್ತೆ. It has to be counted from the date of event ಆಗುತ್ತೆ.
The challenge
What you challenge?
by Lokayukta is to the order of the state service, state administrative tribunal.
Tribunal order ಆಯ್ತು.
Tribunal order. Correct. ಎಷ್ಟು ಸಮಸ್ಯೆ ಮಾಡ್ತಾರೆ ಅಂದ್ರೆ ಮೊದಲು ಎ ಹಾಕ್ಬೇಕು, ಎ ಹಾಕ್ಸ್ಬೇಕು ಯಾವಾಗೂ, ಯಾಕೆ ಬಿ ಮಾಡ್ತಾರ ಎಂಬರ್ದಪ್ಪ. Challenge in writ jurisdiction by the Lokayukta is to the service tribunal's order dated 25/6/2020 made in ಅಲ್ವಾ ಹೌದ್ರಿ
ಅಲ್ವಾ ಇದು?
ಹೌದು. ಓಕೆ, ಡೇಟ್ ಬೇರೆ ಆಗ್ತದೆ ಅಂತನಾ?
ಇದು ಕರೆಕ್ಟ್ ಇದೆಯಲ್ಲ?
Dated 17/7/2020, whereby the application filed by the private respondent herein, application number 863 of 2018, filed by the private respondent herein, having been favored, the disciplinary proceedings have been quashed on the ground that the same were time barred in terms of rule 214, ಅಲ್ಲ 214, 2 ಏನ 214, 2B2, 2 of 2B subclass 2 of KCSR. First, the subject matter of this petition is substantially similar to the one treated by us in WP number 102649 of 2021 SKAT connected with etc. between the Registrar Karnataka Lokayukta versus Sri LG Sankar and another, decided on 28 August 2024. Full stop. Correct idea? The foundational facts are that the event in question took place in the year 2005, semicolon. The applicant retired on 31/8/2015 and the articles of charges were served on him on 5/6/2017. Full stop. In a similar fact matrix, this court has taken the view as stated above that the Lokayukta, the matter does not call for interference. First, in the above circumstances, writ petition is clarified on the cost. We have not examined the issue, so and so signs 4 and 5. 4 and 5, no? 4 and 5 are next. 5. Okay. Next. Start with another. Otherly next. Yes. Others need not wait. Perhaps this matter will go series ಇದೆ, individually ತಗೋಬೇಕಾಗತ್ತೆ ನಾವು ಹಾಗಾಗಿ. Yes.
Next up. Sir, next up. In terms of the same.
ಇಲ್ಲ 23 ಅನಿಲ್ ಕಡೆ ಅವರು.
In terms of the same.
ಒಂದೇ ಮ್ಯಾಟರ್ 102749.
ಫೈಲ್ ಇಟ್ಕೊಳ್ಳಿ, ಕಳಿಸಿ.
ಹೇಳಿ. No right. Yes, brother. Mike and ಸರಿಯಾಗಿ ಇಟ್ಕೋಬೇಕು. ಕೇಳಬೇಕು ನಿಮ್ಮ ಧ್ವನಿ ಎಲ್ಲ ಎಲ್ಲ.
Please. The applicant, my lords, was working in the, as a food inspector, my lords, in the Department of Food and Civil Supplies. And my lords, there was certain agencies, my lords, which used to supply domestic LPG, my lords, to the commercial firms. And therefore, my lords, the proper regular inspections, my lords, was not undertaken by the food inspector, which resulted, my lords, in the gas agencies, my lords, not following the rules and regulations, and they have illegally supplied the commercial, the LPG, domestic LPG to commercial firms. And therefore, my lords, there is a misconduct, my lords, on the part of the food inspector in not properly conducting the inspections.
ನೋಡ್ ಇನ್ನೊಂದು ದಿವಸ ಹಾಕೊಂಡು ಯಾವ ಚಿಕ್ಕ ಮ್ಯಾಟರ್ಸ್ ಯಾವ ಇದ್ರ ಮುಗಿಸುತ್ತೆ.
Please.
ಮೀಟಿಂಗ್ ಇದೆ ನನಗೆ ಇದನ್ನ ಮಾಡ್ಬೇಕು ಹಾಗೆ.
But in this, my lord, all are made, my lord, in this, my lord, tribunal has, my lord, allowed the application. On the ground, my lord, the misappropriation documents were not produced before the Lokayukta. On that ground, my lord, there is a perverse report. On that finding, it has been, my lord, allowed.
Then locus ಇದೆ ಅಂತ ಆಗ್ತದೆ. Because of our latest judgment. ಅದನ್ನ ವೆಬ್ ಹೋಸ್ಟ್ ಮಾಡಿದಿರ ನಾವು ಮಾಡಿದಿರಾ? ಅದ್ ನೋಡ್ಕೊಳ್ಳಿ ನೋಡ್ಕೊಂಬನ್ನಿ.
ಇನ್ನು ಬರಲಿಲ್ಲ ಅದಕ್ಕೆ.
ಅದೇ ಅದ್ ನೋಡ್ಕೊಂಡು ಆದ್ಮೇಲೆ ಮಾಡಿ ಅದಕ್ಕೆ ಮುಂದೆ ಹಾಕಿದ್ವಿ.
Please.
ಕಾಪಿ ಒಂದು ಮಾಡಿ ಕೊಡಿ ಅವ್ರಿಗೆ.
17 ಮಾಡಿ
ಕೊಟ್ಟಿದ್ದೀರಾ? ಒಂದ್ ಸ್ವಲ್ಪ ನೋಡ್ಕೊಳ್ಳಿ ಇದನ್ನ.
Please,
ಒಂದ್ಸರಿ ನಾವು ಯಾವ ಇಂಟರ್ಪ್ರಿಟೆಡ್ ಆನರಬಲ್ ಜಸ್ಟಿಸ್ ಶರ್ಮಾಸ್ ಜಡ್ಜ್ಮೆಂಟ್ ಆಲ್ಸೋ. ಓಕೆ, ಅದ್ ನೋಡ್ಕೊಂಡು actually in the meanwhile justice Pandit Saab has also written, same day he has written another judgment. ಅದನ್ನೊಂದು ತಗೊಂಡು ನೋಡ್ಕೊಳ್ಳಿ.
ಕಾರ್ಬನ್ ಕಾಪಿ ಮಿಲೋಟ್ ಸಬ್ಜೆಕ್ಟ್
ಜೆರಾಕ್ಸ್ ಮಾಡಿ ಕೊಡಿ.
ಜೆರಾಕ್ಸ್ ಮಾಡಿ ಎಲ್ಲರೂ ಒಂದು ತಗೊಂಡು ನೋಡ್ಕೊಂಡು ನೆಕ್ಸ್ಟ್ ಡೇಟಿಗೆ ಅಲ್ಲಿ ನಾವೇನ್ ಮಾಡಿವಿ, ವೇರ್ 12(3) ರಿಪೋರ್ಟ್ ಇದೆ ಅದನ್ನು ಫಾಲ್ಟರ್ ಮಾಡಿದ್ರೆ ಅಂಡ್ ರಿಲೀಫ್ ಈಸ್ ಗ್ರಾಂಟೆಡ್ ಟು ದ ಎಂಪ್ಲಾಯ್, ದೆನ್ ಲೋಕಾಯುಕ್ತ ವಿಲ್ ಹ್ಯಾವ್ jurisdiction. Okay, this is
today's matter. 23.17 pertains to the same view. There, they find fault with the report. They say there is no authority and not purchase the entrustment order as well as the EOC.
ಅವಾಗ ನಿಮ್ಗೆ ಲೋಕಸ್ ಇದೆ.
Locus.
Ultimately, what should happen is another thing. Locus ಇದೆ. Because of this judgment.
Yes.
ಒಂದ್ಸರಿ ನೋಡ್ಕೊಳ್ಳಿ. ಅದು ನಾವು ಸ್ವಲ್ಪ we took pains in framing that judgment because of ಈ ಕಡೆ judgment. There were rulings on both sides of the spectrum. ಅದು ನೋಡ್ಕೊಂಡು ಹೇಳ್ಬೇಕು.
Please.
ಯಾವತ್ತು ಅದೊಂದು ಸತಿ ನೋಡಿ ಪಂಡಿತ್ ಸಾಹೇಬ್ರದ್ದು ಒಂದು ಜಜ್ಮೆಂಟ್
ಪಂಡಿತ್ ಸಾಹೇಬ್ರದ್ದು ನೋಡ್ಕೊಂಬರ್ರಿ.
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಒಂದು ವಾರ ಬಿಟ್ಟು
14A 14A ದಲ್ಲೂ ನಾವು ಅದನ್ನ ಅಬ್ಸರ್ವ್ ಮಾಡೀವಿ. ಈಗ ಸಪೋಸ್ 14A ಕ್ವಾಶ್ ಆಯ್ತು ಅಂದ್ರೆ ಮ್ಯಾಟರ್ ಗೋಸ್ ಬ್ಯಾಕ್ ಟು 12(3).
ನಾವು ಈ ಜಡ್ಜ್ಮೆಂಟ್ ಚೆನ್ನಾಗಿ ಅಂದ್ರೆ even though if there is no remand, still
it will be a case of remand ಅಂತ ಬರ್ದೇವೆ ನಾವು. ಹೌದು, unless court says that it is not a remand at all. Because 12(3) act upon ಆದ್ಮೇಲೆ 14A ಬರುತ್ತೆ.
14A ಬರುತ್ತೆ.
If 14A is quashed, it goes back to 12(3). Therefore, in so many words, tribunal need not say matter is remanded. They should be treated as remand, number one. But government does not do anything. We have fixed 6 months.
6 months.
If the government does not do anything, Lokayukta will have locus ಅಂತ ಮಾಡಿದ್ರು. Otherwise, ಅವರು ಇವರು ಒಂದಾಗಿ ಮುಗಿಸ್ಬಿಡ್ತಾರೆ. Correct. What my brother says is correct. Because of this order, our order now which you have given to you, it becomes remand, and you need not come to court at all.
Yes.
No. Yes. ಇಲ್ಲ in view of this order, my lord.
ಯಾವಾಗೂ my brother is right. Suppose if they don't do anything after 12(3), they don't do anything. 12(5) ಇದೆ ನಿಮಗೆ. 12(5) ಇದೆ ಅಲ್ಲ. You can go to the you can complain to the governor.
Sir, now in persons of this order, treating it as punishment of 14A interestment on the ground that non-application 12(4), it goes back to 12(3) stage.
But jurisdiction ಇದ್ರಿಲ್ಲ.
Jurisdiction ಅಲ್ಲ, ಅವ್ರಿಗೆ locus standi ಇದೆ. There are number of cases with the same challenging 12(4) without making a wording of remand.
ಅಂತ ಕಳಿಸಬಹುದಲ್ಲ,
ಅವೆಲ್ಲ ಮುಗಿಸ್ಬಿಡ್ಬೋದು. ಅವನ್ನೆಲ್ಲ ಮಾಡಿ ಕೊಡ್ರಿ. ಎಲ್ಲೆಲ್ಲಿ 14A ಕ್ವಾಶ್ ಆಗಿದೆ ಅಂತ ಅನ್ಕೊಡಿ.
In all the matters,
almost all the matters for interestment orders are quashed.
Only two aspects, 14A
articles of charges.
Penalty ಇಲ್ಲ.
Entire list my lords goes.
ರೆಸ್ಪಾನ್ಸಿವ್ ನೋಟಿಸ್ ಆಗ್ಬೇಕಲ್ಲ.
Yes, my lord. In some of the cases, notice has to.
Notice ಆಗಿದ್ದ cases have ಇದಾವೆ ನಾಳೆ ತಗೊಂಬನ್ನಿ.
Yes, my lord. Only my lord, wherever notices have been
Are
served.
there, you separate that.
Yes, my
At
lord.
least show us. So
ಅವಾಗ
we say
ಅದು-
that it is a remand only.
ಅದು ರಿಮೆಂಡ್ ಆದ್ಮೇಲೆ ಅದು ಗೌರ್ಮೆಂಟಿಗೆ ರಿಮೆಂಡ್ ಆಗ್ತದೆ. ಸೊ ಗೌರ್ಮೆಂಟ್ ಹ್ಯಾಸ್ ಟು ಆಕ್ಟ್ ಅಪ್.
ಅದಕ್ಕೆ ಬರೋದು ಸರ್. Now it is a remand and let the
Therefore, government should take the decisions. Very
Three months.
correct. ಅಂತ ಲಿಸ್ಟ್ ಮಾಡ್ಕೊಂಬನ್ನಿ.
Yes, my lord. Okay, ಲೋಕಾಯುಕ್ತ to once again come back.
Most of the cases we disposed of.
ಮುಗಿದ ಹೋಗ್ಬಿಡ್ತದೆ. Correct.
Lordships can say that after the remand, a reasonable time to be given to the government for deciding on that.
6 months ಕೊಟ್ಟಿವಿ.
Yes.
6 months.
Fix ಇಟ್ಟಿವಿ.
6 month time.
6 months ಕೊಟ್ಟಿವಿ. ಅದನ್ನ ಇದ್ರಲ್ಲಿ ಹೆಂಗ್ ಮಾಡ್ಕೊಂಡು ಹಾಕ್ಬಿಟ್ರೆ ಆಯ್ತು.
Actually, 6
So
months
after
is
12-3,
Huh?
after 12-3, my lord.
Huh.
My lord, when 12-3, my lord, if it is rejected in 12-4, then only, my lord, 12-5 will come in.
Otherwise not.
No, my lord.
So 12-4 ಗೆ
In
ಹೋಗ.
all cases, my lord, 12-4 is accepted, my lord.
no, virtually
All
after the
cases,
remand,
wherever.
if they not do it, it is amount to rejecting ಆಗುತ್ತೆ.
Huh?
If after the KT remand, my lord, even though, my lord, it's not specifically worded as a remand, in view of this order, my lord, they have to pass a fresh order. They have to pass order.
ಅಲ್ಲ. Unless 12-4 happens,
Yes, my lord.
we cannot do anything ಅಂದ್ರೆ in that event we have to give locus to him ಅಂತ ಅವ್ರು ಹೇಳೋದು.
Please, locus ಬರ್ತ
ನಲ್ಲಿ ಮಾಡೋದೇ ಇಲ್ಲ.
ಮಾಡ್ಲಿಲ್ಲ ಅಂತಂದ್ರೆ
ಹಾ.
then they'll, my lord, has a locus to challenge, my lord.
ಆ ರೀತಿ ಮಾಡ್ಲಿಕ್ಕೆ ಬರ್ತದೆ. ಹಂಗಾಗಿ ಇಟ್ಟೇವ್ ನಾವು. ಇಲ್ಲಪ್ಪ ಅವ್ರು ಇಬ್ರು ಒಂದಾಗಿ ಒಂದ್ ಚಾಲೆಂಜ್ ಮಾಡ್ದಂಗ್ ಬಿಟ್ಬಿಡ್ತಾರೆ.
Then 12-4 is must, my lord. 12-4, after 12-3, 12-4 has to, my lord.
Has to be.
Yes,
Only otherwise 12-5 ತನಕ ಹೋಗೋದೇ ಇಲ್ಲ ಅದು.
ಹೋಗೋದು. In all cases, my lord, here 12-4, government has accepted our report. Here in all cases, yes, after accepting a report, either it is culminated into, my lord, 14A, after 14A penalty.
Correct.
Only two options, my lord, two matters are here before your lordship.
ಇಲ್ಲ ಅದನ್ನು ಕವರ್ ಮಾಡಿದ್ವಿ.
Yes, my lord.
ಅದು that is also answered.
Yes, my lord.
We took some pains in framing that judgment. ನೋಡ್ಕೊಂಡು ಹೇಳಿ.
Please, my lord.
19.
ಯಾವತ್ತು ಹಾಕೋಗಿ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಹಾಕೋಣ. 19 ಭಾಳ ಇದಾವ ಮತ್ತೆ 19 ಓಕೆ. ಏನದು 42 ಏನದು LAC ಇಂಡಿವಿಜುವಲ್ ಮಾಡಕ್ಕಾಗುತ್ತೆ ಅಂತ ಅವ್ರು ಹೋದ್ರೆ
I just make one mention, matter at serial 28. 28 ಅಲ್ಲಿ.
28.
Short matter. Wherein Lord Registrar has fixed the area of, limited the area of operation of cooperative society, which is against section 98I of the act. Could it be taken tomorrow or day after?
ಇಲ್ಲ ಈ ವಾರ ಆಗಲ್ಲ ಬಹಳ ಮಾಡೋದು ನಾಳೆ ಎರಡೇ ದಿವಸ ವರ್ಕ್ ಮಾಡೋದು.
42
Your Lordship, I appear for the respondent number 3 in this matter at serial number 28. Lordship, services of senior have been engaged. May I request on 19th or 23rd if your Lordship
They
please.
don't have the locus. In fact, no notice was issued in the writ petition. They are formal party. They are formal party.
I am a society operating, Your Lordship. So therefore,
Ritally, no notice was issued to that.
on 19th or 23rd if your Lordships please, Your Lordship.
ಸೆಕೆಂಡ್ ವೀಕ್ ಆಫ್ ಅಕ್ಟೋಬರ್ ಹಾಕಿ.
ಅಲ್ಲ ಅದರಲ್ಲಿ ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಇಲ್ಲ. ಏನಾಗಿದೆ ಅಂತಂದ್ರೆ ನಮ್ಮ ಮೆಂಬರ್ಸ್ ಆರ್ ಅನೇಬಲ್ ಟು ಅವೈಲ್ ದ ಲೋನ್ಸ್. ಈಗ ಬೈ ವರ್ಚ್ ಆಫ್ ದಿಸ್ ಆರ್ಡರ್ ಮೆಂಬರ್ಸ್ ಹಾವ್ ಬಿನ್ ನಾಟ್ ಪುಟ್ ಟು ಡಿಫಿಕಲ್ಟಿ. ಅಟ್ ಲೀಸ್ಟ್ ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಕನ್ಸಿಡರ್ ಮಾಡಿದ್ರೆ ದಟ್ ವುಡ್ ಬಿ ಆಫ್ ಎ ಗ್ರೇಟ್ಫುಲ್. ಅಲ್ಲ ಅದನ್ನ ಕಳಿಸಿದ್ದಾರೆ.
But whether it is amalgamation.
ಇಷ್ಟೊತ್ತಿಗೆ ಅಲ್ಲೇ ಹೋಗ್ಬಿಟ್ರೆ ಆಗಿ ಹೋಗ್ತಿತ್ತು ಅಲ್ಟರ್ನೇಟ್ ರೆಮಿಡಿಗೆ.
ಅಲ್ಲಿ ಮಾಡಲ್ಲ ಬಿಕಾಸ್ ಆಸ್ ವೆಲ್
ಸೊಸೈಟಿ ಕೋಆಪರೇಟಿವ್ ಸೊಸೈಟಿ ಮ್ಯಾಟರ್. ಒಂದು ಯಾವ್ದಾರ ಡೇಟ್ ಕೊಡಿ.
19th or 23rd if your Lordships please.
19th
19th or 23rd.
23rd ಇಟ್ಕೊಡಿ.
Please. Obliged.
Seal number 48.
48.
My land fund is appealing for respondent. We will try for settlement. It may kindly be referred to mediation.
Mediation ಮಾಡ್ಬೋದಾ?
19 lords are fixed up at it. So that
request matter is referred to mediation.
Mediation.
account waiting for the parties submits that they will keep their respective parties present before the learned mediator on 19,
19/9, this month.
9/2020.
Please.
Prepare this order along with necessary paper to learned mediator.
Please,
19.
please. Serial number 38, final hearing matter. He is a retired employee of the municipality, my lord. Some promotion 38. We taken up next week on date, my lord.
Date told.
23. ಬರುತ್ತೆ sir.
38. Government appeal.
ನೋಡ್. ಹಾ, ಸಬ್ರದವ್ರೆ. ಏನು?
My lord, I have prepared a summary of, my lord, the acquisition.
ಎಲ್ಲಿ ನಿಮ್ ಫ್ರೆಂಡ್ ಬೇಕಲ್ಲ?
Each reference has different value.
Yes, my lord, you will also get, my lord, all the details here. One case, my lord, there are 3 types of lands. Agricultural, my lord, converted for residential purposes and, my lord, converted for industrial purposes. And, my lord, the LAO has fixed the uniform, my lord, compensation market value for different classes of lands, but the reference court has not fixed different rates.
Court officer. Last time sheet court. Then court sheet. Open source.
ಎಲ್ಲಿ ನಿಮ್ ಫ್ರೆಂಡ್ಸ್ ಯಾರು ಇಲ್ಲೆಲ್ಲ? ಹಾ, ಏನು ಮಲ್ಲಿಕಾ?
In one of the matters, senior counsel had, he is on his legs in court of 6.
ಯಾವ್ದಾದ್ರು ಒಂದು ಡೇಟ್ ತೊಗೊಳ್ಳಿ.
Each cases ಮಾಡಬೇಕಾಗತ್ತೆ sir.
ಇಂಡಿವಿಜುವಲ್ ಕೇಸ್ನೇ ಮಾಡಕ್ಕೆ.
Or at least you should make a block of this. Last time synopsis ಇದು ಕೂಡ ಇದರಲ್ಲಿ ಮಾರ್ಕ್ ಮಾಡಿದ್ದೆ ನಾನು. ನಮ್ಮ ಫೈಲ್ ಕಳಿಸಿದ್ರಲ್ಲ ಅದು ಕೂಡ ಅದರಲ್ಲಿ at least agriculture land one type of cases.
ಅದನ್ನು ಮಾಡಿದ್ವಿ.
Last time I have given a separate synopsis.
Separate ಮಾಡಿದ್ವಿ ಅದನ್ನು.
The last time you have
On
given.
the consolidated list of, my lord, all cases, first one.
ಇದರಲ್ಲಿ
Next, my lord, number 2 is, my lord, I think page number 4 it could be, 5 it could be. ಅಲ್ಲಿ ಇದರಲ್ಲಿ agriculture land list ಅಂತ ಇದೆ. ಅದಾದ ನಂತರ
even in I take example sir, agriculture land also rates are varying ಅಲ್ಲ.
Yes. ನಾವು ಯೂನಿಫಾರ್ಮ್ ಆಗಿ ಮಾಡಿದೀವಿ, but my lord, the reference court has not fixed.
Even for example, take agriculture land, 260 per square feet ಇದೆ, 8,25,000 also is.
8,25,000 rupees per acre in one case. And
261 rupees ಕೊಟ್ಟಾರೆ.
ಆಮೇಲೆ ಇನ್ನೊಂದು ಕೇಸ್ ನಲ್ಲಿ 11,50,000 per acre ಮಾಡಿದ್ದಾರೆ. ಒಂದರಲ್ಲಿ 500 per square foot ಅಂತ ಮಾಡಿದ್ದಾರೆ, ಇನ್ನೊಂದರಲ್ಲಿ 2 ಲಕ್ಷ ಅಂತ ಮಾಡಿದ್ದಾರೆ.
2 lakh per ಗುಂಟ
per ಗುಂಟ. ಆಮೇಲೆ similarly, my lord, in case of
uniformity, at least for agriculture land uniformity is required.
uniformity ಇಲ್ಲ.
ಅದೆಲ್ಲದನ್ನು ಏಕರ್ನೇ ಕನ್ವರ್ಟ್ ಮಾಡ್ಬಿಟ್ಟು ಗುಂಟ ಅಥವಾ ಏಕರ್ ಕನ್ವರ್ಟ್ ಮಾಡಿದರೆ ನಮ್ಗೆ ಈಜಿ ಆಗ್ತದೆ ಕ್ಯಾಲ್ಕುಲೇಷನ್ ವರ್ಕೌಟ್ ಮಾಡ್ಲಿಕ್ಕೆ.
500 rupees per square foot
per square foot ಅನ್ಬಿಡ್ತಾರೆ. ಅದನ್ನ ಫಸ್ಟ್ ಒಂದು ಯೂನಿಟಿಗೆ ರೆಡ್ಯೂಸ್ ಮಾಡ್ಬೇಕು, ಕನ್ವರ್ಟ್ ಮಾಡ್ಬೇಕು. ಎವ್ರಿಥಿಂಗ್ ಟು ಏಕರ್, ಎವ್ರಿಥಿಂಗ್ ಟು ಗುಂಟ, ಯಾವ್ದಾರ ಒಂದು.
Lord, the position is that, my lord, whenever vast extent of land is acquired, compensation should be fixed on, my lord, per
acre basis.
Acre basis.
Ordinarily on acre basis.
As far as residential is concerned, it is almost 700 is one uniform is there. 700 rupees per square foot. ಒಂದರಲ್ಲಿ 665.
665 on 665 700.
665.
665 700.
Industrial list ದಲ್ಲಿ
451 ರಲ್ಲಿ ಮಾಡಿದ್ದಾರೆ, 700 ಇನ್ನೊಂದರಲ್ಲಿ ಮಾಡಿದ್ದಾರೆ. ಆಮೇಲೆ ಮೇಡಮ್ ನೆಕ್ಸ್ಟ್ ಪೇಜ್ ಯು ಲಾಶಸ್ ಗೆಟ್.
ಅವ್ರಿಗೆ ಶೇರ್ ಮಾಡಿ, ಅವ್ರಿಗೆ ಒಂದು ಕಾಪಿ ಪಾಟೀಲ್ ಕೊಡಿ.
ಅದಕ್ಕೆ ಒಂದೊಂದು ಲಾಶಿಪ್ ಮೇ ಹ್ಯಾವ್ ಟು ನಾಟ್ ಕನ್ಸಿಡರ್
ಈಚ್ ಇಂಡಿವಿಜುವಲಿ ಕನ್ಸಿಡರ್ ಮಾಡಬೇಕಾಗ್ತದೆ. ಇಂಡಿವಿಜುವಲಿ ಮಾಡ್ಬೇಕಾಗ್ತದೆ
ಇಂಡಿವಿಜುವಲಿ ಮಾಡ್ಬೇಕಾಗುತ್ತೆ,
ಅಥವಾ ಬಂಚ್ ಮಾಡ್ಕೊಂಡು ಮಾಡ್ಬೇಕು.
ಬಂಚ್ ಮಾಡ್ಕೊಂಡು ಮಾಡಬೇಕು. ಮೊದಲನೇದು ಇನ್ ಕೇಸ್ ಒಂದೆರಡರಲ್ಲಿ ಸರಿಯಾಗಿ ಎವಿಡೆನ್ಸ್ ಮಾಡಿದ್ದಾರೆ, ಒಂದೆರಡರಲ್ಲಿ ಮಾಡಿಲ್ಲ. ಬಟ್ ಈ ಎವಿಡೆನ್ಸ್ ಮಾಡಿದ ಕೇಸ್ನಲ್ಲಿ ಇಫ್ ವಿ ಸಕ್ಸೀಡ್ ಅಂಡ್ ಶೋ this would be the market value, then being under the same notification,
That becomes
adjacent
the yardstick for
property,
rest of the matters.
that would apply, despite the fact that in some cases the evidence
Deviations
is
are
lacking. Evidence is lacking.
Like principle under 28
Yes, yeah, 28A. Of course, there are several judgments also saying under the same notification, if they are done. ಅಗ್ರಿಕಲ್ಚರ್ ಅಂತ ಹೇಳಿ ಸಪರೇಟ್ ಕ್ಲಾಸಿಫಿಕೇಶನ್ ಮಾಡಿದ್ದು ಈ ಕೇಸುಗಳಲ್ಲಿ ಇಟ್ ಬಿಕಮ್ಸ್ ಅನ್ಜಸ್ಟ್ ಫಾರ್ ದಿ ರೀಸನ್ ದಿಸ್ ಈಸ್ ಇಟ್ ವಾಸ್ ಆಲ್ರೆಡಿ ಅನ್ ಇಂಡಸ್ಟ್ರಿಯಲ್ ಎಸ್ಟೇಟ್ ಗೋಕುಲ್ ಆಸ್ ಸಚ್.
ಇಂಡಸ್ಟ್ರಿಯಲ್ ಎಸ್ಟೇಟ್ ಅಂದ್ರೆ ಸೆಕ್ಷನ್ 1 ರೆಡ್ ವಿತ್ 1 ರೆಡ್ ವಿತ್
ಅಂದ್ರೆ ಅಲ್ಲಿ ಅವರೇ
ADB Act.
there were several industries located.
3-1.
There were several industries located. In fact, running industry, the places of running industry are taken over. For shifting, they have paid compensation. Anta, amidst that, even if there are to be agriculture land, they cannot say that conversion and development is of such a this thing, because general development, in evidence it has come. By the time they issued the notification, bus stand, that Gokul Road up to airport had already developed new bus stand, and several other this thing had already reached up to that. This is a case of development having reached up to that.
2007.
House 2007.
ಅವಾಗ ಡೆವಲಪ್ಮೆಂಟ್ ಆಗಿತ್ತು.
ಹೊಸ ಬಸ್ ಸ್ಟ್ಯಾಂಡ್ ಗೋಕುಲ್ ರೋಡ್ ಡೆವಲಪ್ ಆಗಿತ್ತು. ಗೋಕುಲ್ ರೋಡ್ ಅಂದ್ರೆ ವಿಚ್ ಕನೆಕ್ಟ್ಸ್ ಟು ದಿ ಏರ್ಪೋರ್ಟ್. ಆಮೇಲೆ ಡಬಲ್ ರೋಡ್ ಆಯ್ತು. ಡಬಲ್ ರೋಡ್ ಆಗೋದಕ್ಕಿಂತ ಮೊದಲೇನೆ ಆ ಏರಿಯಾ ಇದಾಗಿತ್ತು. ದಿಸ್ ವಾಸ್ ಪಾರ್ಟ್ಲಿ ಆಲ್ಮೋಸ್ಟ್ ಮೇನ್ ರೋಡಿಗೆ ಸಂಬಂಧಪಟ್ಟವು ಅವೆಲ್ಲವೂ ಇಂಡಸ್ಟ್ರಿ. There are at least 3 or 4 cases now before the court which existing industries are taken over. Adralage, one of our contention is, though it's a 3 acre or 4 acre land, it is used as single unit industry. Therefore, saying for development there would be expenses, some of this is to be 33% is to be deleted for development, etc., would not fit into this particular case, would be one of the
contentions in such matters.
How?
Almost 570 acres is the agricultural area out of 765.
No, after you issue notification, agricultural land continues to be agricultural land only.
It continues to be agricultural land only, but it is declared as an.
Your operation will be confined to that. If you want to acquire land, you have to acquire in that only.
Yes.
Except
First,
that no other change.
Yes, first we have to, my lord, declare that area as industrial area under 3-1, and, my lord, then issue one more notification under 1-3, making applicable, my lord, the provisions of chapter 7 to the area which is declared as industrial area.
ಅದು ಮತ್ತೊಂದು
1-3.
331.
3-1 is declaration of industrial area. 1-3 application of chapter 7.
Then
preliminary notification.
ಅದಾದ್ಮೇಲೆ 28.
28-1.
Scheme ಹೇಗಿದೆ ಅದು?
And in fact, my lord, for agriculture lands, sorry.
Already it was developed as industrial area. ಅಲ್ಲಿ ನೀವು ಇಂಡಸ್ಟ್ರಿಯಲ್ ಏರಿಯಾ ಅಂತ ನೀವು ಡೆವಲಪ್ ಮಾಡುವಾಗಲೇ ನೀವು ಎನ್ಎ ಏನಾರ ಮಾಡ್ಕೊಂಡಿದ್ರಾ? ಇಲ್ಲ.
ಹೌದು, ಎನ್ಎ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ. ಇಂಡಸ್ಟ್ರಿ ಲೊಕೇಟೆಡ್ ರನ್ನಿಂಗ್ ಇಂಡಸ್ಟ್ರಿ ದಟ್ ಏರಿಯಾ.
Some of the cases, but some of the cases, first case agriculture land.
ಹೌದು, ಅಗ್ರಿಕಲ್ಚರ್ ಲ್ಯಾಂಡು ಇದಾವೆ. In one of the matter where I am appearing, it's an agricultural land directly facing the Gokul Road. My next property itself is industrial property, converted industry.
ಒಂದು ಯಾವ್ದಾರ ಒಂದು ಡೇಟ್ ಹಾಕೊಳ್ರಿ. ನೋಡ್ಕೊಂಡು ಮಾಡೋಣ, ಟೈಮ್ ಆಯ್ತು ನಮಗೆಲ್ಲ ಮೀಟಿಂಗ್ಸ್ ಎಲ್ಲ ನಾವು ಇದ್ಬಿಡ್ತಾವ ಈಗ.
ನಾವು 17ಕ್ಕೆ ಇನ್ನೊಂದು ಬ್ಯಾಚ್ ಪೋಸ್ಟ್ ಆಗಿದೆ ಕೊಪ್ಪಳದ್ದು.
ನಮ್ಮ ಮುಂದೆ
ಹೌದು,
ಹಾಗಾದ್ರೆ ಅವತ್ತಾಗಲ್ಲ ಇದು.
ಅವತ್ತು ತೊಂದರೆ ಆಗ್ಬೋದು. ಯಾವ್ದಾದ್ರು ಒಂದು ಮಾತ್ರ ನಡೆಯೋದಕ್ಕೆ ಸಾಧ್ಯ, ಎರಡು ನಡೆಯಕ್ ಆಗೋದಿಲ್ಲ.
ಇದೊಂದು ಬೇರೆ ಡೇಟ್ ಹಾಕ್ಬಿಡ್ರಿ,
ಬೇರೆ ಡೇಟ್ ಹಾಕಿ.
ಬೇರೆ ಡೇಟ್ ಹಾಕಿ. 23rd ಯಾವ್ದು ಇಲ್ವಾ ನೋಡಿ ಇನ್ನೊಂದ್ಸರಿ. ಇವೆಲ್ಲ ಟೈಮ್ ಹಿಡಿತಾವ, ಇಂಡಿವಿಜುವಲಿ ನೋಡ್ಬೇಕಾಗ್ತದೆ ಎಲ್ಲ, ಹೋಲ್ಸೇಲ್ ಮಾಡ್ಲಿಕ್ಕೆ ಆಗಲ್ಲ.
ಅಲ್ಲ ಹಾಗಾಗೋದಿಲ್ಲ, ಅನ್ಲೆಸ್
ಅಟ್ಲೀಸ್ಟ್ ಬಂಚರ ಮಾಡಕ.
ಹೌದು, ಅಲ್ಲಲ್ಲ ಈಚ್ ಕೇಸಿಗೆ ಇನ್ ವ್ಯೂ ಆಫ್ ದಿಸ್ ರೀಸನ್ ಇಟ್ ಕ್ಯಾನ್ ಬಿ ಆಡೆಡ್ ಇನ್ ದಿ ಪಂಚ್ ಅಂತೇಳಿ ಹೇಳ್ಬೇಕಾಗುತ್ತೆ.
ಅಗ್ರಿಕಲ್ಚರಲ್ ಪ್ರಾಪರ್ಟೀಸ್ ಪ್ಯೂರ್ ಅಂಡ್ ಸಿಂಪಲ್, ನಾನ್ ಅಗ್ರಿಕಲ್ಚರಲ್ ಪ್ರಾಪರ್ಟೀಸ್, ಇಂಡಸ್ಟ್ರಿಯಲ್ ಪ್ರಾಪರ್ಟೀಸ್, ಆ ರೀತಿ ಮಾಡ್ಬೇಕಾಗ್ತದೆ.
Even before your lordship, my lord, industrial lands are only, my lord, 21 acres. Out of 55 acres, 21 acres is, my lord, industrial. 7 acres is, my lord, agriculture. I mean, residential. And residential. 35 acres is, my lord, agricultural. Majority of the cases relate to, my lord, agriculture.
ಆಮೇಲೆ 2003 ಮಾಸ್ಟರ್ ಪ್ಲಾನ್. ಸೊ ಅದಕ್ಕಿಂತ 5 ವರ್ಷ ಮೊದಲಿನಿಂದ ಈ ಏರಿಯಾನ ಇವರು ಅಲ್ಲ, ಈ ಏರಿಯಾನ ಕಮರ್ಷಿಯಲ್ ಏರ್ಪೋರ್ಟ್ ಅಂತ ತೋರಿಸ್ಬಿಟ್ಟು, ಹಾಗಾಗಿ ಟೋಟಲಿ ಟ್ರಾನ್ಸಾಕ್ಷನ್ ಬಂದ್. ನೈದರ್ ಡೆವಲಪ್ಮೆಂಟ್ ನಾರ್ ಟ್ರಾನ್ಸಾಕ್ಷನ್ಸ್.
Sir, 26th.
The other date here.
So sales statistics method is not available. Because of that, sales statistics method is not.
Method apply ಆಗೋದಿಲ್ಲ.
ಹಾಗಾಗಿ ಇದಿಲ್ಲ. ಈಗ ನಾವೊಂದು ಅಲ್ಲಿಂದ ಒಂದು ಅಂದ್ರೆ ಕ್ರೌ ಫ್ಲೈಯಿಂಗ್ ಡಿಸ್ಟೆನ್ಸ್ ನಲ್ಲಿ ಅಕಾರ್ಡಿಂಗ್ ಟು ಅಸ್ ಅಬೌಟ್ 200 meters ಅಂತ, ಅದರ್ವೈಸ್ 1 kilometer ಅಂತ, ಅದು ಒಂದು ಸೇಲ್ ಟ್ರಾನ್ಸಾಕ್ಷನ್ ಇದೆ.
ಅಲ್ಲ, ಸೇಲ್ಸ್ ಟ್ರಾನ್ಸಾಕ್ಷನ್ಸ್ ಆರ್ ಅವೈಲೇಬಲ್
for HDFC sold property. Public auction ದಲ್ಲಿ HDFC ಏನ್ ಸೇಲ್ ಮಾಡಿದೆ ಅಲ್ವಾ?
ಅಲ್ಲ, ಅದು ಬಿಟ್ಕೊಂಡು ಒಂದು ಪ್ರೈವೇಟ್ ಸೇಲ್,
ಒಂದು ಪ್ರೈವೇಟ್ ಸೇಲ್ ಇದೆ.
ಕಿರ್ಲೋಸ್ಕರ್.
ಕಿರ್ಲೋಸ್ಕರದ್ದು ನಾವು ಒಬ್ರು ತಗೊಂಡು ಅವ್ರ ಕೈಯಲ್ಲಿ ಡೆವಲಪ್ ಮಾಡೋದಕ್ಕಾಗದೆ ಮಾರಿ
HDFC auction sale ನಲ್ಲಿ.
ಅದು ಒಂದು HDFC auction.
When, my lord, better evidence is available, my lord, for the surrounding lands, why one should actually look to, my lord,
because of this master plan sale did
rejection ಆಗಿಲ್ಲ.
My lord, there is no evidence has come to that effect, my lord. They have now, my lord, produced some CDP plans. It is only land user. Land user is prescribed, my lord.
ಹೌದು, ರೆಫರೆನ್ಸ್ ಕೋರ್ಟ್ ನಲ್ಲಿ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ರು.
ಅಲ್ಲ, ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ರಿ, ಬಟ್ ಏನಂದ್ರೆ, my lord, no finding is recorded, or, my lord, no evidence is adduced to the effect that there was no development on account of CDP. There is no such thing. And even otherwise, the lands they are claiming are in road portion in the CDP.
No, ಒಂದು ಯಾವ್ದಾದ್ರು ಒಂದು ಡೇಟ್ ಹಾಕೊಳ್ರಿ. ಫಸ್ಟ್ ವೀಕ್, ಸೆಕೆಂಡ್ ವೀಕ್, ಅಕ್ಟೋಬರ್ನಾಗ ಹಾಕೊಳ್ರಿ. ಅಕ್ಟೋಬರ್, ನವೆಂಬರ್ನಾಗ ಹೋಗಿ ಹಾಕೊಳ್ರಿ. ಅಕ್ಟೋಬರ್ನಾಗ ಹಾಕಿ ನಾವಿದ್ರೆ ನಡೆಸ್ತೀವಿ, ಇಲ್ಲ ನೆಕ್ಸ್ಟ್ ನಡೆಸ್ತೀವಿ ಅಷ್ಟೇ.
Number 26, sir. Small issues, my lord, regarding the.
ನೋಡೋಣ, ಎಲ್ಲ ಸ್ಮಾಲ ಇರ್ತವೆ ಈಗೆಲ್ಲ, ಬೇರೆ ಬೇರೆ ಮೀಟಿಂಗ್ಸ್ ಅದು ಇದೆಲ್ಲ.
Up to tomorrow, my lord. 17B of the Accord Salary and Condition Act. One day. Is completed 80 years or complete not it? That is one week of.
Serial number 47, my lord. Kindly make a Friday. Please, my 47. Please.
It has come very handy. Vijay Kumar.
26. Day up to tomorrow.
Sir.
Till Friday. Tomorrow. Next week ಹಾಕಿರ್ತೀನಿ. ನಡೆದು 41.
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಹಾಕಿರ್ತೀನಿ ಸರ್. ನಾಳೆ
ಮಂಗಳವಾರ.
ನೆಕ್ಸ್ಟ್ ಮಂಡೇ.
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಂತ ಹಾಕಿರ್ತೀನಿ.
ಡೇಟ್ ಅನ್ನು ಕೊಟ್ಟಿಲ್ಲಲ್ಲ?
ಅದೇ ಅಷ್ಟೇ.
ಅಕ್ಟೋಬರ್ ಸೆಕೆಂಡ್ ವೀಕ್ ಅಂತ ಹೇಳಿದ್ರು ಅಷ್ಟೇ. ಸೆಕೆಂಡ್ ವೀಕ್ ಡೇಟ್ ಹಾಕ್ಬಿಡಿ ಸರ್.